Welcome to Looking at Legal Stuff. Today we have 14 hearings in a case with a high conflict couple who've been working on their divorce for 2 years now. It's not going well. Mom, who's pro se for the first half of the divorce, has been trying to do anything she can to be able to stay in the marital home, and she makes grand claims of being able to buy out Dad's equity, but all the while she drags her feet and gets confused about what the court orders mean. Mom also lost primary custody and was ordered to have supervised visitation with the children after it came to light that Mom's dangerous felon boyfriend, whom Mom was court ordered to keep away from the children, was actually spending a lot of time with them. Mom tries to submit telephone records to show she's no longer in touch with him, but Attorney Baldwin subpoenas the official phone records, and they appear to show that she was lying about the amount of contact she had, and that she falsified the records she submitted to the court. What does the judge think of this mess? Let's find out.
We have show cause contempt, motion to compel,
and motion for relief.
and a motion for relief.
Very good. And so again, for the record, I represent Cameron Gibson, who's the petitioner in this matter. I'll address the compel first. It's most straightforward. Discovery in this matter has been pending since 2021. We are now in 2023. The responses that were received quite a long time ago were will supplement. They were never supplemented. We went through the rigmarole of doing ACR 26I. Timeline was chosen not by me for responses, but by opposing counsel. We received just a handful of documents from the many that needed to be actually provided. And we provided a list, a detailed list and letter. Again, we're in a position where really nothing more has been provided since that initial sort of couple of documents that were provided after the 26I. We've made efforts. We're just not getting anywhere. We filed a motion to compel. We are asking for the court to order her to provide the materials as indicated in the letter that's attached to the motion. I'm asking for fees of $1,125. And I'm asking that the court set it out 2 to 3 weeks. I guess I've inclined towards 3 weeks. We can do a presentation at that time, and then we can also address compliance. We are rolling towards a trial. We do need to have these documents provided so we can appropriately do that. Does the court want me to just go through each of the motions, or do you want to roll on them one at a time?
Hold on. So and I just want to make sure that I'm following along. So if you have Odyssey up, index 160 is, and then that attachment A is the list that's still outstanding. Is that correct?
So we don't have index numbers on our side of Odyssey.
Sorry.
Unless I pull up each document.
It's titled motion to compel, and it's a 6-page. So and it's the exhibit A, and it looks like it's a letter to Rory Flay on February 7th, and then posts CR 26I, and then the list of a page and a half of. So that's what we're still missing.
That's correct.
Okay.
Other than we did get a few items but those were identified in the motion specifically on what we received. That was like the 2021 tax return, and I think her wage stubs.
Okay. All right. So I think will be easier to just deal with these one at a time. So Ms. Gibson, any response to the motion to compel?
Yes, Your Honor. Thank you. So that first discovery request was done in October of 2021. I did have counsel at the time who did fill that out, obviously with some of my stuff. I didn't understand, or I guess I wasn't aware that I needed to freely supplement that information from Ms. Baldwin. And I didn't find out about any of it until I briefly had counsel this last month in February. Per my conversation with my counsel, I supplied the wage stubs and the tax return information because that is what he relayed to me was due at the time to Ms. Baldwin. It wasn't until afterward that after he withdrew on February 14th or February 15th, I believe, that I received that document that listed those 26 or 27 outstanding supplementations. So I have been working to compile those and get those for Ms. Baldwin, having 26 or 27 different things to look through and gather, and having to re-reference the first discovery response to know what exactly I need to include and update is very time consuming. And I haven't not complied. I've been trying. the apparent deadline for when she had contact with counsel came and passed. And after that February date, after that week due date passed, I didn't receive any word from Ms. Baldwin relating to not having submitted what apparently was agreed by my counsel that I was going to submit. The only notification that I received about this was the motion that was filed 2 weeks later. Had she reached out and had I known that that was what she needed, I would have worked with her to get what was requested of me. And I've been working to supply all of it and get it all put together for her. As I said, there are over 26 different supplementations to get through. And so I would ask the court to have additional time to complete the request and work with Ms. Baldwin to get that over to her. As I said, the only, I guess, contact that I received from her after this conversation that she had with my counsel was the filing of this motion. Had she reached out to me prior to that, but after my attorney's withdrawal, I would have been more than happy to work with her to try and get it resolved, but I didn't receive anything as such. I didn't realize that all of those things were outstanding and needed to be given to her. And so I'm asking the court to allow me additional time to compile everything so I can be compliant with her request. I'm also asking that they not award any attorney fees or expenses at this time. As I said, my attorney withdrew on February 15th, and this was filed, I believe, the 26th or 27th after that. So there were 2 weeks that at any time Ms. Baldwin could have reached out to me to let me know that I hadn't given that information to her. And instead I received this motion.
Very briefly. Go ahead.
I'm just going to ask one question here. So, Ms. Gibson, how long do you think it would take you to complete the requests for these supplements?
I mean, I'm going through them as each one, so I haven't looked at the list in its entirety to see what all is needed. I've been going through each one and getting everything. So I would ask if I could have, an additional 6 to 8 weeks just to make sure I get absolutely everything to Ms. Baldwin. That way we don't have to come back in front of Your Honor if I get something to her in haste and unintentionally forget something that was requested. I don't want to come back in front of you for that reason. So I would ask for that time to be able to get everything to her in its entirety.
Okay, Ms. Baldwin.
Thank you. She's provided a letter. She kind of keeps repeating saying, like, I didn't know. A, she had counsel. B, from the get-go, she put will supplement, which is a statement that you will do something, and she has not done it. C, she's not done anything since getting the motion. Her entire statement is, I want to continue to delay, and I'm going to go through the list one at a time and not look at the whole. Ms. Gibson is not uneducated, not incapable. This is a delay and a stall. And so these have been outstanding for a long time. She doesn't need 8 weeks. The court should set a reasonable amount of time, but they're supposed to be answered in 30 days. There's not even statements that she's ordered things and they're on their way. It's just, again, a delay. So the court should order materials to be provided. I'm suggesting 3 weeks. That's very reasonable. Fees are appropriate. We've made efforts to try to get these materials, and she's just not responding.
Your Honor, if I may.
Briefly.
Okay. I spent the majority of 2022 without counsel. If Ms. Baldwin really wanted these documents, as she's now stating that she does, she could have requested them from me. Again, when I had counsel, when I filled these out, I was told that it's standard when you don't have the documents to say that you'll supplement them, and then opposing counsel will ask for those documents at a later date. So it's not that I've been sitting on it since December of 2021, not doing it. It was relayed to me that counsel would ask for it at a certain point. And I was without counsel for the majority of last year. Ms. Baldwin could have reached out to me at any time requesting that documentation so I could continue to work on it. And she, for whatever reason, decided not to, chose not to. I don't want to speak for her, but
have you reached out to her at all? Have you reached out to her at all?
Regarding
the case? Regarding
this specific documentation?
No, the case.
Yes, I've reached out to her. I'm sorry?
I said, okay.
Yes, I've reached out to her. Oh, okay.
No, you can keep going. That was just my response was okay.
Oh, okay. Yeah. So that, I mean, that's all I'm going to say on that is it's not me intentionally since December 2021 not supplying things to her. She could have just as easily reached out to me requesting that documentation. If she had chosen to earlier, I would have done and gotten it to her sooner. I just found out about this when she filed this motion. So I just ask for more time and to not award fees and expenses at this point, because I feel like this could have been resolved outside of having to appear in front of your honor.
So I'm gonna grant the motion to compel. I'm gonna reserve on fees to the review date, which I'm gonna set. So assuming everything gets completed by then, that will determine whether I impose fees. How about, does April 18th or April 25th?
Either date should work for me.
All right, April 18th. So that's another 4 weeks to get that supplemental information in.
Well, can we have her provide it by the 11th? And then that way I can compile it and then submit something that says, this is what we have and this is what we don't have.
Sure, let's do this then. Let's have everything due by the 18th of April. And we'll review it on the 25th of April.
Okay, very good.
And I'll reserve fees until that date. And reconsider at that point in time.
Okay.
All right, then let's move on to the next.
So the contempt is pretty straightforward. We can handle that one next.
Okay.
So in this case, the contempt is somewhat side by side with the withholding of information. 2021 court order, parties to file their 2021 taxes, and that the refund was supposed to be placed in an attorney's trust account. My client, they're supposed to do, clicked the 2 buttons, DocuSign, tax return gets filed. All of a sudden, he doesn't have it. Wife gets the money, and he doesn't know where it is. He never even knows sort of that this happened until we received the 1 or 2 documents from opposing counsel earlier this year. At that point, we realized that a refund had been issued. My client says, hey, where's the refund? And that's essentially the contempt, is that refund was supposed to be placed into a trust account. It never was. My client didn't agree to splitting it. And even if Ms. Gibson sort of said that's her, she says, well, we agreed to split it. Like, well, if that was true, why didn't she disclose that she received it, how much she received, and give my client his half? So her statement said, well, I believe we had an agreement, really clearly falls flat, because if she did, then she didn't follow the own agreement that she says existed. Again, we still don't even know where those funds were kept. After this motion was filed for contempt, she says, well, what if I pay you, your half? We say, great, like, let's just resolve, how much you owe. But that doesn't resolve the contempt. And that, again, we don't know where she held it. She had the access to those funds for an extended period of time. She doesn't provide any documentation in her response to the contempt on where the money was kept, what happened to it, if she just spent it. And these are different funds that she's now using to pay him back. So again, pretty straightforward. And we're just simply, at this point, my client has received his half of the tax return. So we're just asking for fees and costs. Those are appropriately, I put $1,585 and a sanction, just $100 sanction. The fees include ex parte fee and service fee. And so that would be our request. Again, just really straightforward. And you see my emails of trying to obtain compliance prior, sort of really no response to those. So straightforward, we're asking for contempt. She knew where the money was supposed to go and just kept it herself.
Right, Ms. Gibson.
Thank you, Your Honor. I don't believe that I am in contempt regarding the 2021 tax return. There's been no willful violation or bad faith on my part. I've been trying to get petitioner his half of the tax return since it was received. Back when the court ordered that we needed to file it jointly, we filed it with the same accounting firm that has filed our tax return for the entirety of our relationship, which is local here in Cowlitz County. We DocuSigned that document each individually. when you DocuSign a document, after it's completed by all parties, you automatically receive an electronic copy of what you signed. So for petitioner to say that he never got a copy of it and he didn't know how much the return was or where it went, it was in that document that he received. I called the accounting firm and got the DocuSign log showing when you open, who opens it, who does what, which I attached as Exhibit A in my responsive declaration, that shows that he reviewed and received it on or around August 1st. DocuSigning a tax return is not just you log in with your email and you're given access. You have to provide your social security number. You have to provide address information. It prompts you and asks you questions about previous places you've lived, previous relatives, things like that to confirm your identity so you can sign it. So for him to say that he didn't know what happened to it or where it went, just it isn't true. He received it from the log. He had equal access to this document that I did. I don't understand why it's solely my responsibility to have access and get his counsel a document that he had access to. I even gave an example in my responsive declaration. He could have simply called the firm. He could have called the accounting firm to get a copy of the return, and I'm sure they would have gladly given it to him since his name is on it. I don't understand why it's my responsibility to do something when he could have simply made a phone call to obtain the information. Which the couple of times that I had counsel, I did address it with them. And I explained that and they said, well, he'll get it to his attorney. And I said, okay, so that's why I didn't do anything with it. Petitioner and I did agree in a series of texts when we had to file this that we were just going to split the return. I attached one as Exhibit B, stating that, you know, he agreed that we would split it 50-50, get everything done. And that was on June 23rd of 22. I even attempted to get petitioner to give his accounting information to the accounting firm so that he could just directly get his half of the tax return. Exhibit C shows I even went so far as to screenshot the contact information for the person who supplied our tax return, had her name, had her phone number, has her email, has the address of the location, for him to give his routing and accounting information so he could directly receive his half of the return. He chose not to provide any of that information, so they went off of all the information that they had, which is that the return ended up in my bank account as it had for every single year that we filed our taxes together prior to this divorce. He then sent me a text on June 28th of 2022 where he indicated again that we would split it 50-50 and that his attorney, Ms. Baldwin, would be sending an agreement for me to sign relating to the half of the return. I sent a response email to her on June 30th because she wanted to see the text. I provided that texting information to her and said, you know, hey, I'll sign the agreement, or if he wants to provide his half, he can get the return. I received no response on that email. So I felt like I couldn't move forward without speaking to his attorney since he had counsel or continues to have counsel. I felt that I couldn't move forward without any recognition or response from her for fear of getting in trouble with the court. And so I didn't hear anything regarding the tax return until this year in January, when I briefly renewed counsel. He stated that I needed to provide the tax return information through the discovery request, which I did. I didn't hide any financial evidence. The document, as I've stated, was available to both of us. He could have easily called and obtained a copy. He was given an electronic copy of the document once everyone signed it, which states the amount of the return and the account and routing information where the return was placed. And it wasn't until I was able to speak with Ms. Baldwin on March 6th of this year that I was able to get an indication from her that if I got him his half of the tax return, we would be done. I've been trying to do this since June, and I either would get response from petitioner that yes, we would do it, and then nothing, or yes, we would do it. My attorney's going to draft something. I reach out to her and then I don't get any response about it.
Okay, hold on one second.
Oh,
hold on
go
one
ahead.
second.
Yes, ma'am.
Ms. Baldwin, was there some kind of temporary order or anything that indicated this is what the parties are to do with 2021 taxes?
Yes, that's what the contempt is based on. So
Okay.
they were required to file it as a joint filing and place it and place the proceeds in an attorney's trust account, essentially unless they had a signed agreement otherwise.
And do we know when that order was entered?
Yes, November 16th, 2021.
All right, so I guess I'm going to get to down to the brass tacks here. So it sounds as though there may have been a text agreement between the parties, but there wasn't a written agreement per court order. Is that kind of fair to say?
My client would disagree. He said we went back and forth, and he ended on like, hey, we don't have an agreement, and he attached that text to the reply saying like, no, it's not agreed. Put it in the trust account. And so for him, that's where he left it. So they negotiated, but never resolved it.
But the only bank account that was provided to the financial or the financial folks that prepared the tax return was the Miss Gibson's routing number.
Correct. And then we still don't have, I believe, those banking records, and that's part of the compel. So we really don't know where it went, other than no other opposing counsels indicated that they have.
Okay. Ms. Gibson, if you want to reply to anything that I just asked about, please do so.
Yes, Your Honor. As I said previously, petitioner and I did agree via text. Any conversation that we had after that, they were mostly verbal. He kept asking me where his half of the refund was. And my responses to him were always, I need to hear from your attorney to know that I can give it to you. My fear was that I would give the return directly to him or through his counsel, and that I would get in trouble with the court later for getting him his half and create an issue down the road. I made multiple attempts to resolve it and didn't get any clear indication from counsel other than that text from petitioner that he was aware that his attorney was going to draft an agreement of some kind. I sent those responses to her, and then I never received it. As I said, and then counsel and I spoke on March 6th of this year. She said to get her a half. I went and I dropped it off the next day at her office. I've been trying to resolve this. So I would just ask the court to not find me in contempt or order any judgment or fees related to it, because I've been trying to get it resolved. And I even gave petitioner in the text that I included, I believe it was Exhibit B, or I'm sorry, Exhibit C, the contact information for our tax preparer so that he could submit his information. And he never provided it to me. He never, to my knowledge, provided it to the tax accounting firm. So they just submitted the return and put it where it had gone the other 8 or 9 years that we filed our taxes together. I didn't know his routing information. Otherwise, I would have provided that to them so he could directly get his half. I don't know what else I'm supposed to do other than I diligently tried to get it over to Ms. Baldwin. And until I got confirmation from her on March 6th that I could do so, felt that I couldn't, as I didn't have representation and I didn't want to get in trouble with the courts.
Does the court want any rebuttal or no?
Well, I guess, and please correct me if I'm wrong, but it appears as though both parties had access and had to sign off on the tax documents as they were filed. Is that correct?
So DocuSign doesn't automatically send you an email with a copy. It has you verify who you are, but it's not automatically providing you a copy. So my client essentially click, and all of a sudden it's done and it's closed. And so for him, he believed he had done what he was supposed to do in signing the taxes provided for him. The issue here is not the tax return. The issue here is that they did not have an agreement to split it from the initial filing. That the court order, it's in the order of child support, specifically says that it's supposed to be held in a trust, an attorney's trust account pending further court action or written agreement of the parties. So we don't have either of those. And so the issue is where Ms. Gibson kept the money from essentially July, August until my client received half as a way of, I would argue, compromising to resolve at least that piece of it. So the issue is that she withheld it, kept it secreted. We didn't even know how much it was. And again, we had asked for the tax return and discovery. So these are the issues on the contempt. So again, we've addressed how much, but if she believes it was agreed, then there's no reason for her to have withheld it for the entire time. My office has always been in the same place. She could have provided a check at any time.
Your Honor, if I may respond.
No, I'm okay now. Thank you.
Okay.
All right, let's hear the last issue. So the motion for relief.
So motion for relief, several different issues. So the first is child support overpayment. Children were placed with my client back in November. There's a lag between that placement and entry of the order of child support. Division of Child Support continues doing their thing with the last order on file, meaning they continue to garnish my client. Ms. Gibson, knowing the children had been moved to my client, continued to receive those funds and kept them. There was a overpayment of over $1,000. At this point, we were able to confirm that she's paid back $500. That leaves a balance of $538.72. She doesn't dispute that. That should accrue interest at 12% because essentially they are funds that she knew she was not supposed to be receiving, and she received them and kept them. She could have just turned them right around to my client and didn't. Money going out of the children's household. We're asking that be paid back at $200 per month until paid. Pretty straightforward. The next issue is my client lives up in the Seattle metro area. He's asking to be able to sell his gas guzzling truck so he can buy something rational and affordable. He's asking essentially if he gets an offer for $12,000 or more that he be allowed to sell it. We're asking the court to set the floor, not the ceiling here. That really, I think Ms. Gibson in this sense just doesn't understand what we're doing. She doesn't seem to disagree about the sale. She just wants it to be sold for more. My client wants it to be sold for more too. But if he can sell it for $12,000, he should, because there's a lot of transportation of these children up and down the I-5 corridor. It's very expensive driving a huge truck. He does sometimes use his parents' vehicle. His goal is to get a vehicle so that he doesn't have to use his parents' vehicle or his vehicle, neither of which are fuel efficient. So pretty straightforward on that issue. Whatever he sells it for, that's what he's going to be awarded to him as the line item in the balance sheet, along with the debt associated. The next issue is these parties have a real property home. We're asking that the house be placed on the market for the summer selling season, and that be placed on the market essentially as of mid to late May. The home has a value of approximately $300,000 to $400,000, depending on how you value it. There's over $100,000 of equity in the home. In this case, Mrs. cannot afford to live there. It's just not financially possible. When you look at her income and her obligations, even if you just look at some of her obligations, she just cannot make that mortgage payment in any rational fashion. She presents no evidence that she can refinance the home into her name. And again, she's not refinancing the current debt. She has to refinance to pay my client his half of the equity. She just can't do it. She's had at this point essentially 2 years to be able to show that she could refinance the home. She's not showing that. She's not showing it here. She's not even attempting to do it here. I would certainly object to any kind of settlement negotiations. Those certainly are not appropriate to be considered. Those are her offers, not ours. So again, we shouldn't address those or consider those at all. We did the math for you not once, but twice. There just is no way around. She cannot afford this home. It's not possible. Just simply looking at child support obligations and child care obligations as her percentage share, she just doesn't have enough to live and make that mortgage payment. This is one of the major assets of the home. We want to maximize that asset for both parties, and we want to minimize risk. We do have risk here. Mrs. is paying late. She doesn't deny that. She says, well, I'm not having to pay a late fee, but you see her starting to pay later and later, approaching that late fee. Again, these are indications that she cannot pay. This is rational and reasonable to place the home on the market. We can have an agreed realtor. If we can't, we can each present 3 and the court can pick a realtor. That's fine. But again, appropriate, it's reasonable. Kids aren't living there. This is not their home. Kids live with my client up in the Seattle metro area. We need to move on. And again, minimize the risk and maximize the asset to both. Proceeds would be placed in an interest-bearing account or an attorney trust account. Either is just fine. Next issue is 2022 taxes. I believe we're agreed that the parties should file these separate. They separated in 2021. There's no reason why they shouldn't file married filing separate for 2022. We're asking that my client be able to claim the family home. He did pay spousal maintenance for 2021 and 2022. He continues to pay maintenance, and that Mrs. has a credit off of her child support payments. She's receiving a credit that is essentially, instead of just trading money around, she's getting a credit off of that and spousal support. So it's appropriate that he be able to claim a significant portion of that. Mrs. sort of presents, I would argue, a red herring issue of, hey, he should have been paying these taxes all along. A, she only raises this now, and B, when you look at the underlying temporary order, it says Mrs. is responsible to pay the mortgage, which includes the taxes and insurance. It's a single payment. They aren't differentiated, and we're asking the court for that clarification too. And again, one more reason to sell the home. As far as primary care providers, I'm hoping that we have an agreement and that Mrs. agrees to the language there. Children, again, were moved up to the Seattle metro area. We want to have providers where they are. The respondent wants to maintain their local providers. Fine, they can do so. My client's not being unreasonable there. Just their appointments get set up in the Seattle metro area for all sort of standard appointments. So my client isn't then spending $100 in gas to drive them to a dental cleaning and losing a day of work to do that. We are asking finally that all communication be via our family wizard. There's a lot of sort of he said, she said in some of these communications. And my client says, I just want to communicate via our family wizard so mom can't kind of pull this, well, I didn't remember that, or I didn't hear that, or you didn't say that. He's like, I provided her with all the notice in the world. Let's do everything for through our family wizard so that way no one can make those statements in the future. Finally, we are asking for fees. A number of these issues are pretty straightforward. We're just in a position where Ms. Gibson wants to maintain a home that there's just no way she can afford. And so similarly, should have had to bring the primary care provider issue for the court, but that's where we are. Some amount of fees is reasonable because we're having to come to court to address these issues where I think reasonable parties would have come to an agreement.
What did you indicate that he's paying that he should be able to claim the home on the taxes?
Spousal support. So the court ordered spousal support that I would argue was really to prop up the house. And so he's been paying that from 2021. And now it's really worked into the order of child support. So I think she receives a $250 credit or about that off of child support. And you can see, if you were to look at that, or you can see it like written in. And I had the court do that just so that he's paying her and she's paying him back kind of a thing. Just do it all at once so there's one transfer and not two.
Okay, thank you.
So in regard to the overpayment for support, I was unaware that there was any delay when the court entered and there was any delay in overpayment. I did that $500 payment. I was under the impression that took care of an overpayment. I was never told that anything in addition was due up until this motion was filed. So if the court finds that something is still outstanding, to be repaid at an amount of $100 a month instead of $200. In regards to the vehicle sale, I'm aware that petitioner has wanted to sell his truck. Previously, when I had counsel last month, Mr. Flay indicated to me that Ms. Baldwin had created a proposition for him to value the truck at $15,000.
These are all settlement negotiations. They're not properly before the court.
So that's correct. So, I guess, what is your opinion based on any conversations that you had with your attorney about the sale of the truck?
Okay. My conversation with the attorney was that the $15,000 proposed offer was a good value for the truck. And he did indicate to me that Ms. Baldwin had said that language would be drafted that if the vehicle sells for more, that it would be valued at the higher rate, but that the $15,000 was a good offer and that we should accept that. And I told him that if that's what he believes, then that's what I'll go with. And that I would receive a document to sign that we agreed to that. And then I never received anything. I didn't have counsel. And then Ms. Baldwin reached out to me and said that now it's being offered at 12. I understand that petitioner drives the vehicle to and from work. He's never driven the children down here in this truck. The children's car seats just simply don't fit. So he's been using his parents' vehicle. So to try and relate any of the wear and tear to driving between the two homes, I don't believe is accurate. So I feel like we should agree to that proposed $15,000 value or higher, whichever is greater. But I will defer to the court in that matter on whatever the court feels is best. In regards to the home, I've never paid the mortgage late. I've never indicated to Ms. Baldwin that it's been paid late. It's never accrued any late fees. I attached as Exhibit F my mortgage statements and bank records to show that it's been continually paid on time. And that petitioner claimed it's negatively impacting his credit, though he provides no proof of that. On the contrary, I provided proof that the credit monitoring app that I use show no payments have been made. And so it's not been negatively impacting my credit. In addition to that, to ensure that I don't fall behind on it, I've been paying petitioners obligation to the homeowner's insurance and property taxes that's wrapped in as our escrow part of our mortgage payment. The temporary order entered into the court on November 16th of 2021 states that the parties shall split 50-50 all other bills of the community, including but not limited to the HELOC, which is our second mortgage, property taxes, and homeowners insurance. I've made all of those payments to ensure that the house is paid on time. In addition to that, so that was signed, as I said, signed and entered, I believe, November 16th of 2021. And then additionally, this was brought back before the court in a hearing on March 29th of 2022, and amongst a number of things. So it should be, I believe, reflected in the court minutes that the court ruled they wouldn't make any changes regarding to the expense of the family home, which meant the property taxes and the homeowner's insurance that should be split 50-50. I've been paying 100% of those payments to ensure that the home is paid timely, to ensure that I don't fall behind on any of my bills. So as such, he's continued to not pay that obligation for the past 16 months. So I believe that he owes me for that bill $2,692. I have suggested to Ms. Baldwin that we use that as an offset for current childcare costs. I don't know if that's something that the court can order, but I believe it could be easily resolved outside of the hearing. But I just want to point that out, that I've gone so far as to pay his court-ordered obligation in order to maintain this home. And so I ask that the court not order the sale of the home at this time. I feel like petitioner is trying to create a problem that hasn't yet existed. It's never been late. All bills are paid on time. I have unofficially spoken to our mortgage broker who believes I would qualify for a refinance.
It's not in the court record. It's not even in her declaration as hearsay.
Yeah, I don't, we can move on from that, Ms. Gibson.
Okay. So I would just ask that the court give me 6 months to attempt a refinance so that I can see where my options are. I believe I can afford the home. Yes, petitioner does have the children, but that is temporary per the most recent court orders from November. It was indicated that it was a temporary change. And I understand that that's not before the court right now, but it's not permanent. So I don't want to lose the home that my children have grown up in and known all of their life. If the court does order that the home be sold, I ask that the proceeds be split 50-50 and not placed in a trust account. I would need access to those proceeds in order to make other living arrangements. The 2022 taxes, I do agree that we should be allowed to file them separately, and that I be allowed to claim one of the children on the taxes, because that is I believe is what's fair for each of us to claim one child. If we alternate children, I'll leave that up to the court. The petitioner didn't make a single contributing payment towards the house in 2022. So that not the property taxes, that taxes on those payments, I don't believe petitioner should be allowed to claim on his 2022 tax return because he didn't make those payments. I made the entirety of all those payments, Your Honor. So I don't believe it's reasonable that he be allowed to claim them. As regarding the medical providers, I do believe Ms. Baldwin and I have come to a tentative agreement that the children, will be seen by the provider that's in the area where the residing parent is. So I don't have any issue with that. I just ask that the court not award fees in this matter. A lot of these concerns could have been resolved outside of a court hearing. I attempted to try and resolve a number of them with little to no response from counsel. And as it's been indicated in the responsive declarations, we've come to an agreement on the providers since that motion was filed. That was something easy that could have been taken care of.
Child support's very clear. She doesn't deny. I'd ask the court to adopt my figure. $200 a month is reasonable and it should accrue interest. This sort of, I didn't know. You received money in your bank account. You saw it come in. You did know. You chose to keep it instead of giving it back to the primary parent. The vehicle sale, again,
sorry to interrupt, but double check. That is what she already paid $500 to your office for.
yes, and
So
there's
there's about how much left? $600 or $700 left.
yeah, 560 something. It's in the motion. Hold on, I can tell you exactly.
Sorry, I threw you off there.
That's okay. $538.72.
Thank you.
So that's what's owing. You should accrue interest since December at 12%, because that's the child support percentage. And again, we're asking for $200 a month because she kept it when she knew she shouldn't have. She's asking for $100 a month, whatever. I'll trust your honor's discretion. The vehicle sale, she essentially wants to trap him in a vehicle that she admits doesn't fit the kids. That's ridiculous. Unless he sells it for the highest possible blue book value. That's not appropriate. Whatever he sells the vehicle for is going to be what they get for it. The children should be able to ride in a safe vehicle. You should have the ability to have a fuel efficient vehicle. We're asking that if it sells for $12K, that's what it is. If it sells for $15, that's what it is. So she's not getting shorted even $1. It's just whatever it sells for, we're setting the floor, not the ceiling. As far as the home, we do see that she's paying late. Mortgage based on her own documents is due on the 1st. We have her paying on the 6th and then the 13th. We see it progressing later and later, especially in 2023. So what we don't want to get into is where we're getting really, really late and really delayed and having significant impacts. Again, this will give me 6 months, but that completely eliminates the primary selling season for homes. We want to put the home on the market when it maximizes the price for both parties. We can come back once it sells and address what to do with the proceeds at that time. I'm not really hung up on that issue. My client just wants to maximize how much both parties receive from the sale of that home. There's just no way she can afford it with her income. It's not possible. And once you're in a position where it's not possible, it's inevitable, we should be maximizing the value for both parties. As far as the 2022 taxes seem to be agreed that those should be filed separately. Again, my client paid substantial maintenance in 2022, initially $1,700 a month, then it was reduced to $1,000 a month. Then there were further reductions later in 2022. So again, we have really substantial payments that have been made from my client, and really those were to prop up the mortgage. And so that's why it's appropriate. If the court wants, you can sort of split this and say father's going to claim both children and mother claims the home. That might be a way of sort of equalizing those tax benefits between the two parties. I do think these are appropriate, sort of holding my client in a vehicle that he really can't transport the children in doesn't make a whole lot of sense. So things like that are reasons why we're here. So we're asking for an award of attorney fees and relief.
As for the overpayment of child support, the balance is $538.72. I will order that the 12% interest take place, and I'm going to order a minimum payment, $125 a month until that's paid off. The vehicle sale, I think I understand the blue book value. I don't know. Frankly, there wasn't a lot of discussion about the condition of the vehicle. I think it's appropriate given what looks like a 2013 Toyota Tacoma. Access cab makes me think jump seats in the back. So that's why so I think a private party sale, yes, the blue book says the $15,000 to $18,000 range. I think I would imagine that Mr. Gibson wants as much money out of it as possible as well. I think if he can sell it for anything above $12,000, that'll be authorized by the court. And then obviously that'll be reserved for division. The home. So I did review the mortgage payments. So there was a kind of a summary on I guess, Exhibit F. And then I reviewed some of the statements that were also included in Exhibit F. I really see September 16th is the late one for 2022. All other payments were made within, well, I guess February 13th, 2023 was a little late. And then March 7th, 2023, but there's 3 that are arguably, and I don't know what the grace period is on the home. I'm not going to order the home be sold at this point in time, but I would, but I'm going to put a kind of a deadline for Miss Gibson. I'd like to review this in 2 months. So instead of 6 months, I'm going to give you 2 months to look at what you can do for refinancing, and if you can come up with a plan here. But I'm not going to order that at this point in time. Ms. Baldwin must have read my mind. I wrote 2022 file separately. Dad gets the kids, mom gets the home. And then we'll reserve for 2023. And then request for attorney's fees of $1,500. I think Ms. Gibson doesn't know this. Ms. Baldwin knows this. As do most of the attorneys here. I'm usually very reticent to order attorney's fees in cases just across the board. I reserved on the motion to compel any fees. And at this point, I'm gonna reserve on this pending our review in May. I'm gonna return to the contempt, and this is a difficult one for me. I think clearly Mr. sees it as relatively black and white. Mrs. doesn't. There appeared to be an agreement according to Mrs. There didn't according to Mr. There was some access by Mr. to that tax return. Arguably, he could have made the change on the tax return to include his attorney's trust account. So it went where it needed to go. I don't really have the information provided by Ms. Gibson. It obviously was an attempt to be thorough and provide as much information as possible, and I appreciate that. But the tracking of the DocuSign information doesn't really give me a lot of insight as to who looked at it last, what was seen when it was accessed. You know, I guess the opposing argument could be Mr. probably shouldn't have signed off on it until he reviewed it all. So based on kind of just the muddiness surrounding that, there's a lot of muddiness surrounding that, but the language in the prior order is relatively clear. And Ms. Gibson seems like a very intelligent individual. She was very effective in her responses and filing those responses. But she sort of just sat on this money. And I understand she was concerned about, getting in trouble with the court. I think probably what she did was the worst option for that. But I understand the confusion. I'm going to make a finding of contempt in this case, and I'm going to order the $100 sanctions. I'm not going to impose any attorney's fees on that. The attorney's fees for the motion to compel and motion for relief will be reserved for our next review hearing. All right, we'll set presentation for April 11th. If that's agreed upon before then, we can strike that portion from that date, but we'll set presentation at this point. Thank you for that. Then we have the FELON matter and the Gibson matter. So I will.
I'm happy to take the Gibson matter.
All right.
All right. We do have Ms. Gibson with us. For the record, I'm Chelsea Baldwin. I represent petitioner Cameron Gibson. We're on for presentation. First and foremost, I've received no objections to that proposed order. Proposed order was filed on March 24th.
Hold on, let me look because I have. I have a few different orders that I was presented with. I have an, so if you'll bear with me on this one, I have an order compelling answers that was, it looks like was already heard and dated by you February 27th.
Yes.
And that was, so I reviewed all this, and I always think I make great notes, and then, but it appears to me that this was already ruled on, the $1,125 in a prior hearing on.
Yes,
So that's just on for presentation, correct?
correct.
And then I have an order. This one appears to look the same. And it's that same $1,125, the same order, except for it has an April 3rd date. So I don't know if it was just maybe you did a secondary one. Okay, I'll sign the newer one. And then I have a third one, which is really the second one, and it's with the blank judgment that I think is for today's hearing.
Okay.
And then an order for relief as well as a contempt order. So is that
Correct.
okay? All right. I
Yes.
just want to make sure. As to the order compelling answers with the $1,125, I reviewed that, and that was based on a prior hearing and a prior order. So I'm going to sign up on that. And I did not see any response to that or objections. So, excuse me.
Your Honor, if I may,
Sure.
I'm confused. I thought we were here on the motion to compel for the second discovery request. And then the proposed orders from our hearing that we had a few weeks ago are the documents that I received.
That is correct. So the proposed order from the last hearing is what I just signed.
Okay. And that was the
$1,125 judgment on the first motion to compel.
okay, I did not receive that. The only ones I received were the contempt hearing for the $100 and the other one regarding the child support overpayment. So I guess I'm confused and don't understand.
All right. So there was, excuse me. I am going back through my notes here. Looks like on was it March 21st or was it before that? That there was a judgment entered based on the initial motion to compel that wasn't complied with. And so the order that I just signed basically reflected that judgment that was ordered based on that first motion to compel. It does appear to me that I do have an affidavit of mailing that Ms. Romaine filed on behalf of Baldwin Legal Services, indicating that on the 15th of March, it was emailed to you as a proposed order, it appears.
And I thought that during that hearing, Your Honor, you had allowed me time to compile those responses to Ms. Baldwin. My understanding was that I had until the 18th to provide those responses to her, and that based off of that, that there would potentially be something filed in regards to attorney fees.
Hold on, let me go back to my notes here. So it looks like and I Miss Baldwin, my assumption is this is a combination of things. So there was a judgment for overpayment of child support. There was a reward of an attorney's fees. And
Yeah, we did I think three separate hearings on that day. We did the relief, we did the contempt, and we did the compel. And those were all on March 21st, looks like. And then the court set today for presentation.
and I reserved on attorney fees
Until review.
until review, which we're at today. So, and then there was a contempt sanction and award. So,
And I don't recall if today was the day for review for this or just presentation, a review of the compel. And it doesn't reflect in the notes, in the minutes, either way. So I'll leave it at your honor's discretion. If you want to set the review for the compel further out, we can set that and address that with the presentation from the second compel and address both of those at the same time.
okay. Miss Gibson, I'll set that aside for now, that order that I just entered, just so we're all on the same page. So I'm just gonna white out my name here real quick.
But I would
Thank you,
ask that you
Your
go
Honor.
ahead and enter the contempt and the order.
Oops. And I do, of course, just ran out of whiteout. I believe in my review of the case, there was a review set to 425 on the order to compel. So I don't know if we want to set and 425, we can't do 425 because that's judicial conference week. So that was one of the things that I noted we needed to address here, because we had, and I think that they kicked it to maybe May 16th, because that's the next available date.
All right, that's on for reviewing the guardian ad litem report on the 16th anyway. So we're already here on that matter. So that's logical.
I apologize. What was that date again?
May 16th.
Okay.
Yes.
Well, I can't find any more whiteout, so I'll take care of that afterwards here. So I do have, so the order was, Miss Gibson, just so we're all on the same page, that you were to provide responses based on the order to compel to Miss Baldwin's office by close of business April 18th, 2023. So you are correct. We're not at that date yet. So, and I did set this initially for review on the 25th. The clerk smartly did not do that since we're not having a docket that day. We are set for, it looks like, May 16th. So we'll set May 16th not only as a GAL review, but a review for the motion to compel and contempt. The contempt order, so Miss Gibson, you did receive a copy of that, is that correct?
The one for the $100.
Yes.
Yes, ma'am. And I submitted payment to Ms. Baldwin's office on the 30th.
Okay.
Perfect. I would just ask that she sign that. I can't verify that at the moment. If she did, and it appropriately clears the bank, then we'll do a satisfaction.
Okay.
Thank you.
All right, so I've signed that, so that part is taken over. Then I have, and I'm gonna, Miss Baldwin, I guess, just very briefly, do you want me to route these, the orders on the order compelling back to you, or do you want me to
Just
recycle?
recycle, please, and I'll make
Okay.
sure that clean copies. That way, I think that will cause less confusion.
Perfect. Okay. So then, Ms. Gibson, I'm looking at the order for relief. And this
Yes,
was
ma'am.
the attorney's fees being reserved, which I ordered, and then the child support being paid back, in the 538.72 at 125 per month minimum. So I'm
Yes,
gonna
ma'am.
sign that order as well. Okay.
May I
So,
ask, I apologize. May I ask one clarifying thing regarding that document?
sure.
Okay. So I was provided with the order for relief. On the second page, it has the court orders. Number 3, which was the sale of real property, you're reserving on, in that hearing, you reserved on the issue of selling the home, and we're going to review it at the May 16th hearing date. It says that I need to establish that I can refinance the home. I just want to clarify with the court that that's not me having gone through with a refinance. That's just providing proof that I qualify to refinance the home.
That is my understanding and what I was ordering. Yes. So
Okay.
I'm not expecting you to have a refinance done by then, but proof that if we were to take over that home, that you would be able to do that.
Okay. Thank you, ma'am.
Okay. So then I do believe I saw some filings or correspondence regarding some of the additional requests for discovery and the compel order. Is any of that need to be addressed today, or are we gonna? Okay.
So,
All right. So Ms. Baldwin, go ahead.
thank you. Everything we've talked about was regarding the first discovery request and the first motion to compel. Now we're talking about an entirely different discovery request and a motion to compel regarding that request. If you look in Odyssey, because the request is not overly long, we actually just filed a copy of the entire thing so you can review it. That was attached to the reply. So in this case, regarding the second discovery request was largely focused around obtaining communications between Ms. Gibson and her boyfriend. As well as her family who provide supervision or who have provided supervision for her during this case. Unfortunately, the response back was incomplete. It was misleading, and other things were objected to improperly. Sort of a common refrain from the respondent, will supplement, but she never does. The court will recall from the first request, she wrote will supplement in 2021 and then never did. Her responses here are the same, will supplement, I'll look into it, but there's never any action steps. I've ordered it, I'm printing it, I'm getting it. It's just a delay and a stall. Again, the communications are important that we receive those. This is the boyfriend who lived with her and that she hid from over a year from the court and the guardian ad litem. The boyfriend was court ordered to not have any contact with the children of this case because of the level of danger that he represented. He wasn't allowed contact with his own children. He had significant felony history. And so we're seeking the communications between the two of them, as well as, again, how much her family and friends participated in sort of this ruse to both the court and the guardian ad litem as well, because there'll be arguments at trial about whether or not they can safely provide supervision for her. The requests that we have made are largely sort of point and click type of requests that she can fulfill very, very easily. We've given instructions on, click here in Facebook, go there, click this, and you can download a file that has all that information. So this is not difficult information to obtain and procure. Unfortunately, not only has she not done that, she's also provided what I would argue is falsified information. We attached the sort of phone log minutes that she provided saying that she has satisfied that request. Again, you see that minutes is misspelled. that indicates to me that that's not likely an original document. This is something that she's doctored and provided. So again, she's doing that to mislead the court, but also to mislead the guardian ad litem. She's providing the same information to the guardian ad litem saying, gee, I really haven't had communications with this fellow. Look at my phone records, when again, it doesn't look like these are genuine. So again, in this case, it's very important that we receive the actual documents. When you look at the objections that she has made, the objections that she's made are improper. They're clearly objections for a personal injury case. She's essentially taken something from her office. She happens to work in a legal office, cut and pasted that into her responses, and that is providing them. She says, this X or Y isn't time limited. Most of these are time limited, or if they're not time limited, they are point and click type items, items that it's just, it isn't burdensome. Unlike so many other things, some things really aren't burdensome. For text messaging, she says, oh, gee, I can't provide it. In our response, we provide there's 10 plus places that can provide this information, again, through sort of a point and click type of process to make it very easy. So her arguments really fall flat. We're asking that she be required to provide the information. It really is critical information to the case and ultimately to the safety of the underlying children. Finally, we're asking for fees for being here. I'm asking for 3 hours of my time. That would be $1,425. The objections are meritless. We've gone round and round with her. I've done CR26Is, tried to give her opportunities, and she provided falsified information. I think that warrants fees and potentially a sanction.
All right, thank you. Ms. Gibson.
Thank you, Your Honor. So I received these from Ms. Baldwin's office. As she stated, some of these requests don't have limitations on them. Specifically, that very first request for production wants a complete archive of my Facebook account, of an Instagram account. The Facebook account, as I put in my responsive declaration, I've had for about 20 years. I don't believe it's reasonable for Ms. Baldwin to need 20 years worth of information. During our CR26I that we had regarding these things, I asked her, I stated to her, I don't believe this is reasonable. I asked that you reduce it down to something that's more reasonable and more manageable in relation to this dissolution. And I didn't get any response. That it was just, it is what it is. You point and click and get me the information. I'm happy to provide her with that information. I just ask that the court limit the length of the information that I give her. Again, I don't think specifically for the Facebook account, 20 years worth of information is relevant to these proceedings. And again, with regard to the text messages, I didn't know of a way to get her as the request states, to get a electronic native copy of information other than taking a bunch of screenshots. When I asked Ms. Baldwin during the CR26I, she said, oh, there's lots of ways you can get that information. I asked for an example of one because I didn't know of any, and she didn't provide a response. However, in petitioner's responsive declaration, he lists a handful of different programs to be able to obtain that information. Had Ms. Baldwin's office provided me with that information before this, I could have potentially fulfilled that request. Also, that wants it doesn't narrow, I apologize, it doesn't narrow who she wants communications from. As I put in my response, I communicate with my phone, with my family, with friends, with my coworkers, and with my employers. This request for production does not, the only thing it excludes is attorney-client privileged communication. I don't believe that communication with my coworkers or communication with my employers, communications with my friends outside of the friend who is the one of my supervised visitors, I don't believe that information is relevant. Again, I asked Ms. Baldwin during the CR26I if she would limit that information, and I didn't get a response. So I held to the objection. Regarding, the objections, I'm doing the best that I can with that representation. And I felt like the things that I objected to me made sense. There was, I feel, a lot of invasion of the privacy of the people that I communicate with. Had there been a request stating the individuals that she wanted information from, I could have, thought about and made an assessment based off of that. But this doesn't state that. It states that I can only exclude attorney-client privileged communications. So I just ask that if Your Honor is going to order that I produce some of these things, that there are limitations on the people who she wants information from. A lot of my friends I don't communicate with regarding this. If she wants things from my sister and, as I said, my best friend who are currently supervised visitors, I will happily provide that information. That was not indicated to me in the CR 26I. That's not indicated anywhere in either the motion or the response motion. And so I just need some more clarification on what to provide. The other thing that I would like to address is the production of what she calls these doctored cell phone logs from AT&T. I cannot be responsible for how AT&T imports their information. As soon as I received the responsive declaration from Mr. Gibson regarding this, I immediately went onto my AT&T account and pulled up my most accurate phone log to see what indeed was going on. I downloaded it as I am able to based on my AT&T account information. And that is how the log pulls the word minutes in. It's very incorrect. I noticed it the first time that I, provided the logs to the GAL. I didn't change the word minutes because I didn't want Ms. Baldwin to, or anyone really, to misconstrue thinking that I, messed with the logs. So that's an error on AT&T's part. I don't know if it's a coding error. I don't know what the issue is, but that's how the logs gave themselves to me when I went to download them. So the fact that there's an allegation that I doctored these logs without any proof, just stating that I've doctored them or made them up, created them, I feel is really baseless, and just trying to throw something out there to try to mislead the court, stating that I'm misrepresenting what's going on. When the court ordered the switching of custody and the girls went to petitioner back in November, you can see it on the phone logs. Like, there's no more communication. There were a couple of phone calls after that hearing date in November, and that's it. Because I'm following what the courts asked me to do, and I provided those phone logs. So for petitioner to state that I falsified them without, or just doctored them completely without any proof, is baseless, and I don't believe should be considered by the court. I ask that the court not award attorney's fees in this matter today or reserve on them. Again, I asked Ms. Baldwin for better clarification. I asked her for specific communications that she wanted from the people in my life to get these requests to her, and I didn't get any conclusive responses. So I held to what I had provided to her office.
Okay.
So
I'm going to cut you off 1 second, Ms. Gibson.
That's
I need to step away for 1 second. So I'm just going to turn myself off, and then I'll give you a chance to finish, Ms. Gibson, if you have more, and then I'll hear from Ms. Baldwin. I will be right back. All right. Sorry about that. I appreciate your patience. Are we still on the record, Ms. Wade?
Yes, we are.
Okay. Thank you. All right. Ms. Gibson, I'm sorry if I cut you off in the middle. Do you have any additional comments?
I did have just a couple, Your Honor.
Sure.
Just in responding to the reply declaration that petitioner submitted, interrogatory number 4 that was requested from Ms. Baldwin's office wanted me to state the social media sites I used within the last 5 years. I stated at the end of that objection what sites I used. So petitioners claiming that I objected and that I didn't apply and I didn't identify appropriate platforms makes no sense because it's right there that I put at the end of my response to that answer. Interrogatory number 5 wanted text messages, which again, I provided to the GAL per the GAL's request of what she needed per that court order in November of 2022 for her to look into any, quote, continued relationship with Mr. Rosales. I provided the phone logs that she had requested, petitioners claiming that I've doctored them and that I created the document simply because the word minutes is misspelled, but there's no supporting documentation to prove that, stating that I'm falsifying evidence, which they provide no proof to the contrary. And the only other thing is, there's only one response to these interrogatories and these requests that I stated I would supplement. And that one was the request to have all communications from my attorneys with the GAL. And I had to state that I would supplement that response because I didn't know what or if my attorneys had any communications with the GAL. I couldn't provide a time frame on which to produce those documents because I didn't know when those attorneys would have an opportunity to get back with me. And in my responsive declaration, I attached the emails that I got from both of those attorneys regarding that request. So the claim that I'm purposefully trying to keep people in the dark, or that I'm just trying to make things delay and last longer, just simply isn't true. That's the only response. The will supplement response was the only one. And that was simply because I didn't know the time frame in which my former attorneys would be able to get back to me to supplement that information to Ms. Baldwin's office. So again, I asked the court if they are going to order that I'm required to provide that information to Ms. Baldwin's office, that it be limited as I've stated in my responsive declaration, and not to enter attorney's fees at this time. Thank you.
All right, thank you, Ms. Gibson. Ms. Baldwin?
So the request was made back in early February. We don't even see her attempting for the first time to obtain the information sought until March 30th. So basically, I'm not going to do anything. I'll wait until the motion to compel, and then I'll start filing. I'll start a request at that point. So again, I'm going to sit on my hands. I'm going to delay. When you look at the requests, all but essentially 2 of them are time limited and fairly time limited. Year and a half since 2021, since 2020. They're looking really at the last primary 3 years. The only ones that are not are really the Facebook Meta group, because it's the easiest to, frankly, obtain the full record. A little harder to parse it out, frankly. Again, this is a total of just 5 substantive interrogatories and 5 requests for production. On several of these, she admits, well, I'll provide this, but she hasn't. So she admits there are things that are appropriate and that she should have provided. And not only has she not provided them initially, she doesn't provide them after the 26I, and she hasn't provided them still. So again, even though I admit I should provide it, I'm just going to continue to withhold that information. Relevance is not the standard for discovery. That's the trial standard. The discovery standard is much, much more broad. And again, it's appropriate, it's she doesn't even claim that she would be embarrassed by these communications. It's just, I don't want to. And that's not an appropriate objection. She doesn't deny that her legal objections are meritless. So again, in this case, even though she admits that there are many things she should have provided here, she has not done so. She continues to withhold them. and improperly so. We have a guardian ad litem review coming up next month. And again, the concern here is that a big question is how long was she hiding from the guardian ad litem this relationship, and what did this relationship look like, and what role did her friends and family take in hiding that during the time when he was barred from having contact with the children. So this is relevant information, even though that is not the standard. So again, because we're here, this is the second time we're having to be here on a compel, I am asking for some substantial attorney fees. And in order to compel, we can review on that same date as we previously set forth.
So I think Ms. Baldwin did make a very good comment here that the relevant standard does not apply to discovery. I would clearly make rulings on whether some of these, a Facebook message from 20 years ago is relevant. Arguably, I mean, we may all be able to agree that that probably isn't, but you don't know. And generally, the court doesn't get real involved in the specific requests of one attorney on behalf of their party to another party. Starting to go down that road and deciding what's appropriate, what's not appropriate, parsing out some requests or limiting certain requests or making rulings on certain requests is kind of, frankly, I see it a little bit as a slippery slope because I guess I wouldn't want to set any kind of precedent that, just go to the court and the court will limit what you have to turn over in discovery as part of a dissolution. So I'm a little cautious to do that. I have reviewed the attached, I think it was Exhibit A as attached to the reply declaration that is the very specific, here's what we're asking for. And I read through each request. Obviously, apart from the Brian Rosales portion of that, the court feels that none of these are trick questions, or I think how overbroad they are isn't relevant at this point in time. And so I'm gonna grant the motion to compel. I'm not going to limit anything that's in there. I understand Ms. Gibson is wanting some parameters or clarification. I would hope that Ms. Baldwin's office would work with her on any of those clarifications. But I'm gonna set a limit on this. I know we have one deadline coming up next week for the first set of discovery. If we have our next review on the 16th of May, I could either set the 28th or the 5th for those to be provided. I just want to make sure that all parties have sufficient time to get that done and to review what they receive.
I've asked for that to be April, was it 28th that you're proposing?
Yeah, and I don't know why I'm picking Fridays. I guess it doesn't have to be a Friday, but
yeah, April 28th is fine because again, a lot of the information goes into what the GAL would have received. And so that's why I'd like it to be the earlier date, because then if we need to push out the GAL's review, then we can address that. There's time to essentially then address that.
All right, so I'll set the 28th of April. So that's 2.5 weeks from now. Close of business. All that needs to be given to or responded to with information, the supplemental information. I'm not going to make any kind of finding that the phone records are falsified at this point. Ms. Gibson, if you have, I'm not expecting you to, take extra steps to prove that, it is what it says it is. But obviously, if there's another way to show that information, you may want to do that. But I'm not making a finding that they're, falsified. I understand the concern. It does look a little different than a lot of the phone logs that we do get. But So everything by the close of business on the 28th, and your half days on Friday, is that correct? Did you tell me that last time?
I am not half days on Fridays. We're
Okay,
open to
so close of business on Friday, the 28th. We'll review everything on the 16th. As to attorney's fees, I understand the request. I also understand Ms. Gibson's likely frustrations of having to navigate this on her own. I think we have some I'm going to reserve to the 16th. So Ms. Gibson, if you do everything that you need to do and we get everything completed, I'm going to take that into consideration with regards to any imposition of fees in this case. So those will be reserved, and I'll hold the request for that 1425 over to the 16th of May at 1 p.m.
I think I sent an order. Does Your Honor, would you prefer I just prepare a new order?
Let me double check to see what I have. I think it was the blank order. Was it the blank order?
Probably.
Yeah, let's start with a new one then, because.
Very good.
All right, good luck. We'll see you on May 16th.
All right, very good. Thank you.
Thank you, Your Honor.
A, I think it'd be hard for Your Honor to deal with it without Odyssey. We do have Ms. Gibson present. B, I'm going to ask that we set this matter over to the 30th. So discovery is a big issue in this case. We actually just this morning received documents we had subpoenaed from AT&T and are now being able to go through those and compare those to what we received from Ms. Gibson. And that, I think, will illuminate a lot of the questions. But that'll take us a little bit of time. So I'm asking to set to the 30th. That gives us time to review that and then provide sort of a summary and some of those documents to Your Honor.
Right, and Ms. Gibson, any questions or concerns about that?
Is that just in regards to the discovery, not in terms of the GAL report, or is this for both items?
So we're actually on for review for a number of things, but again, because if you don't have access to Odyssey, I think that's very challenging to be able to suss that out. So we're on regarding reviewing the home, the guardian ad litem report, and discovery issues. So there's a number of sort of pending items. I would just ask we move those all to the 30th.
So that is correct. I'm seeing, Ms. Gibson, that it's review of GAL, review of attorney's fees, motion to compel, and order to compel. So there's several different things that we were going to touch on today. And any concerns with that?
No, if Your Honor needs access to Odyssey in order for us to accurately and effectively be able to do those things, then it doesn't really seem like we have an option but to set it over.
And again, my apologies for that. So we just got an email that the fiber optic cable that was cut has refractured.
Oh.
So they're not even giving an estimate on when that matter will be resolved at this point. So let's set it to the 30th. I appreciate your patience with us, Ms. Gibson, and thank you, Ms. Baldwin.
First is guardian ad litem review. Just to talk about where we are in that process, the reviewing the motion to compel, and then there was two orders from a motion or two pieces of a motion for relief that the court had set over to address essentially today. We do have the guardian ad litem present, as well as the opposing party are present today. And for the record, I'm Chelsea Baldwin. I'd like to address the guardian ad litem review first. So where we were originally was sort of at the end of 2022, there was a custody change to my client due to violations of the court's order preventing the respondent's boyfriend from having contact with the children. From there, the court sort of, because that was not very expected, the court granted the guardian ad litem extra time to suss out how long that contact had been happening. And that's where we have sort of that motion to compel issue regarding the phone records. And so that's, we've been a little bit in a holding pattern waiting for those phone records. We did finally get those in about a week to 2 weeks ago, which as the court now knows, revealed a substantial amount of continuing and ongoing contact that was directly contrary to what the respondent claimed was going on, and directly contrary to the documents she produced. For the purposes of the guardian ad litem, unfortunately, within the last week, one of the children made a disclosure that has resulted in a criminal investigation and a planned CJAC interview. And that's regarding, again, contact between the child and the boyfriend. So at this point, I think the guardian ad litem, because that's newly emerging, I think the guardian ad litem should have a little bit of additional time. I understand criminal investigations can go on for a while. I would suggest 30 to 45 additional days, let the CJAC interview play out so that can be included. And so I was thinking sort of mid-July for the guardian ad litem to be able to issue a report, not only on the phone records issue, but at this point, all safety issues and any appropriate issue, the guardian ad litem should just be free, hands untied to address those to the court. I will reassure the court that the child's needs are being met. Specialized counseling is being, we're obtaining referrals, CPS referrals, and all the appropriate care that the child will need to address the situation. And we do have the guardian ad litem present.
That's Miss Gravina, correct?
Yes.
Okay, thank you.
This is Tanea Gravina, the guardian ad litem.
Good afternoon.
And yes, this previous weekend, Your Honor, father disclosed to me that the child is making disclosures and there has been involvement with law enforcement, CPS, and father is awaiting a scheduled CJAC interview for the child and a referral from the pediatrician for a pediatric sexual assault therapist. And I simply only have that extent of information to give the court at this time. I have reviewed the phone records as well as the documents mother provided. And as far as that piece of it, have a firmer understanding, but with new safety issues, I do have concerns, Your Honor.
Does the time frame suggested by Miss, excuse me, by Miss Baldwin, well, knowing that we don't have any control over the if and when any criminal charges may arise from this or how that is even handled, is a mid-July date reasonable?
I would anticipate potentially receiving the results of a CJAC interview by then, but I am doubtful of receiving any CPS or criminal information by then, Your Honor. So if the court would be okay with me presenting the phone record information and the CJAC information only at that time as an update, that would be appropriate, Your Honor.
And I don't have any issue with pushing out further into August to give more time, sort of whatever the guardian ad litem thinks she needs.
Your Honor, if I may.
Sure.
Okay. So we are here today to review the GAL report. This was originally set back in the beginning of February, Your Honor. During that hearing, Ms. Baldwin had indicated that she had information, including a potential video, which was the whole basis for her extension request for the GAL to finish this report. My last understanding from when I spoke to the GAL a few weeks ago regarding this is she just now received the phone records from Ms. Baldwin's office. And to my knowledge, she's never received any potential video alleged evidence, which is the whole reason why the hearing got pushed out in the first place. So I do agree that the GAL should do an updated report. But I believe that, or I'm asking that the court allow her to do a full updated report, not just on my end. The girls have been living with their dad for the past 6 months. So it's been a big change for everybody. And so I think that anything that either side wants to bring up, if we need to pay additional fees for the guardian ad litem, I understand and am, prepared to pay my half of that. But it's been a good amount of time since the children have been in petitioner's care. So I believe a whole updated report would be needed. Up until my understanding last week, Ms. Baldwin didn't provide anything to the GAL for the last 3 months. I got what was needed to the GAL when she requested it for me back in February. And I've done what was asked of me. You can see in the GAL's report that back in November, the girls went to go live with petitioner and that the court had me do a class. I immediately went and took the class. I did 2 other classes on top of that. The GAL also requested that I do therapy, which I was already in therapy just in relation to this whole process. And that all of this was just a temporary relocation for the kids' safety. We come to the hearing in February and, it needs to get pushed out because there's all of this new evidence, which Ms. Gravina can touch on this if she's received it or not. But the whole basis was because of this alleged video, which to my knowledge, the GAL hasn't seen it. I have not seen it. I couldn't make a motion pending that allegation because the court granted more investigation time. I was prepared at that time in February, if the court accepted the GAL's report, to do that so I could get some residential time back with my kids. I'm not objecting that she needs to do an investigation, but that she should get to do one on both parties, not just myself, because the girls have been living there, like I said, for quite some time. I've sat patiently. I've done what was requested of me. I've done what the courts have asked me to do. And now all of a sudden on Friday, I find out Friday afternoon before this hearing, again, this huge allegation of
something going on, which I agree that it needs to be investigated, but it just feels like a pattern that this happened in February, it's happening again now, and everything is just getting pushed and pushed and pushed. So Ms. Baldwin, as I said, indicated that there was some video evidence, I believe was the wording that she used, that I'm not sure any party has seen. And now there's this very serious allegation that's going on, which the first I've heard about it was Friday afternoon. And again, I understand that there's a procedure for that and that some things need to happen. And I wanted to get to the bottom of that also. But everything keeps getting pushed. I don't know if I'm allowed to still have my supervised visits with my children. I haven't seen or talked to them since last week. So I don't know what we're doing, but I've done everything that the court has asked me to do and then some. And every time it feels like I get close to the finish line, something else comes up that's brand new information that pushes everything out and keeps me from spending time with my children.
Well, I understand your frustration, and I I would be dishonest to you if I sat here and said that it isn't frustrating to the court as well. But the GALs are appointed in these cases. They get information from 20 different angles. Some of that stuff takes a really significant amount of time to get back with different, ROIs and different requests. So I understand your frustration. I get frustrated as well when we set a final GAL report date and then there more time's needed. That being said, I also understand the GAL's point of view when more information trickles in, sometimes more serious information, and some information isn't received. So, or maybe received in a timely manner. But it sounds to me like everybody wants the GAL to do finish the report, look into all these issues. And I will say, Ms. Gibson, the GAL is looking at what's in the best interest of the children. They're not investigating one parent. They are looking at the entire situation and for any safety issues and concerns that they may have as an outsider looking in for the children in the case. So it wouldn't be just a witch hunt for you or a witch hunt for Mr. Gibson. It's basically looking at everything that is provided to them and giving a summary to the court. So everybody, it sounds like, wants the GAL to get that completed report and have as much information in it as possible. So Ms. Gravina, what if we were to do a report? How about July 25th?
Your Honor, if I may, I am hesitant to include any interviews with the children prior to CJAC interviewing the children. I would not feel like that was within my scope or expertise. If there were any disclosures or any other statements made by the child, and don't want the court to be misled thinking that I could wrap something up sooner than that. If I am having to plan a trip up to, I believe, Spanaway and do so after CJAC and still be able to provide information to the court that soon.
All right. Well, when do you think, can you give me a date then?
I could meet with the children probably shortly thereafter. I'm assuming mid-July. So maybe beginning of August, if the court would like updated information about Father's Home and the children's adjustment to that, as well as the additional information that's already requested by the court.
I propose August 8th. I have an appointment on the 1st that might make me unavailable at the 1 o'clock docket. So I would propose August 8th then. If there's major issues that happen before, then we could always note it back on and address those with the court.
Yeah, I would prefer a realistic date. And even if that's a little further out than having a shorter review and then only to not have any resolution at that time. So does August 8th work for everyone?
Yes, Your Honor.
Ms. Gibson?
Yes, Your Honor.
Okay.
Yes. May I ask one clarifying question?
Sure.
Okay. During this time, am I still able to have contact with my children? When I was able to briefly speak with Ms. Gravina about all of this that just happened on Friday, she had indicated that might not be a possibility. It's not like I don't have unsupervised time with my children. I'm currently set for supervised visits at both locations and do video chats that either Mr. Gibson or his mother are essentially present for when I do video chats with the children. Am I restricted in any way from spending time with my children because it's not unsupervised time?
So this isn't properly before the court. There's a lot of things happening at the same time. There may be safety plans in place from CPS, from law enforcement, due to very specifically the statements that have been made under oath to the court about no contact with the children's alleged perpetrator. And then the massive body of evidence of contact between the respondent and that person. That's a substantial concern. So I'm just asking the court not address it today. It's not before the court. If we need to bring it back before the court, we will.
So, and I appreciate that, Ms. Baldwin. What I'm going to tell you, Ms. Gibson, is I'm not doing anything today in this action that is changing the situation. However, because there's other things going on, other things could be implemented that are outside of my control and my knowledge. So I would encourage you to continue to try to do what you've been doing and until you hear otherwise. But otherwise, I can't really go beyond that to address that concern.
Okay. So we're still operating under the current temporary parenting plan. Is that what I'm understanding?
At this point, yes. I'm not changing anything as far as that goes today. The other part of what we were doing today is reviewing the discovery and the order to compel and any attorney's fees associated with that. So let's discuss that part.
And we're also here to discuss the sale of the family home that the court had reserved on the prior order, as well as there's sort of some taxes and insurance information. So I'll just sort of argue those all now together. So on the motion to compel, the court will recall originally the respondent sort of put down will supplement, left that, didn't supplement. I believe in this case it was for more than a year. It was an extended period of time where she just made no efforts. Substantial efforts were made towards gaining compliance. Finally come back before the court, sort of feet to the fire. Court says, okay, we have an April hearing. Court gives her an additional 3 weeks, gives her a deadline. She's still late, still provides the documents late on May 1st. I'll note she didn't print them. She delivered them essentially as individual screenshots on a stick drive. The cost to print those alone was $474. And my staff had to spend hours doing it because it was like essentially spool a single document, print it, spool a single page and print it. It took hours. I'm concerned that the method used to do this was intentional. Ms. Gibson is a legal assistant. She knows sort of standard formatting and not standard formatting. Could have been Dropboxed, could have been PDF'd. Instead, we did it in like essentially the most cumbersome way possible, which is a concern. Specifically, though, the court should, when it's thinking about sanctions, turn its eye also to the AT&T records. The court will recall the phone records were a major piece of contention. Ms. Gibson said, oh, I've provided them. These were specifically the records between her and her boyfriend, the boyfriend who is now the alleged perpetrator of the child. This was a substantial concern on what their communication was, because she had said, no, I've broken it off. The children have no contact. And she provided the court recall copies of her records. Now, those records contained the phone calls with the boyfriend, but also a smattering of lots of other calls, but they looked very slight. And we even noted for the court there was misspellings that would indicated really red flags on whether or not they were authentic. At the same time, and as a result of that, we subpoenaed the records from AT&T. The records that we subpoenaed were only the communications between her and boyfriend. So the communications that you now have, or the record that you have included in your court file is only there. So the stack, the page after page after page is only the communications between the two of them. It is not her whole phone record, just their communications. There are thousands of communications, thousands that are far exceed what she provided to the court previously, what she said was the totality of the record. And the difference between the two is so extreme that there's no way she did not know. This was an intentional effort to pull the wool over the court's eyes and everyone's eyes and say, this is the totality of the conversations. But we know even up through 2023, the communications were continuing long, a year after, long after she said that these had long since tailed off. So again, when you're looking at, and we provided the totality of what we got from AT&T, it is a brick. It's probably 50 pages. And we received that in, it was printed by AT&T in the last week of April, April 28th. We got it sometime shortly thereafter, at the beginning of June. So when we're looking at this and the delays and the costs, simply even to print out her own materials, the court's award here has to be substantial. It has to be substantial, not as to just fees and costs, but also as to sanctions. Sanctions are appropriate when a party under penalty of perjury comes before the court and says, this is the totality of the record. And under subpoena, we find something extremely different. So in this case, I'm asking for an attorney fee award and costs rolled together of $5,000. At this point, we've had several hearings. I've issued her letters. That would be at least $3,500. Again, just printing the materials alone was just short of $500. My staff time to just print out the materials exceeded $1,000. I think $5,000 is a reasonable total judgment and sanction for the behavior here. As far as the next issue is regarding the sale of the home, again, these parties, one of their major assets is a single family residence. The court sort of gave the respondent time to prove she could refinance the home. She has not done so. What she has provided for you is essentially a mortgage calculator that you could go on to Bank of America and print out today. It is not a letter from a bank saying we will do this refinance for this person who has this income. She provides none of that. It is just, here's what the current rates say I would pay. And the current rates, and I'll note my client produces emails to the contrary from the bank that they currently bank at that says, no, that those numbers don't add up. We wouldn't be able to refinance somebody with that level of a debt to income ratio. She provides that the lowest possible payment is almost $1,900, which would be about 63% of her income going to that sole thing. And with that, she then would not be able to also pay child support and childcare costs. So just those two costs alone would exceed really her monthly income. There's no ability for her to refinance this home. The only answer is to sell it, and waiting to sell it is prejudicial to my client. This is a major community asset. It is a time-sensitive asset in the fact that the summer is when houses are most expensive and sell for the most money. And waiting until the dead of winter actually reduces each party's value in the home, and that goes to my client and her. I'll note that my client indicates in his declaration, Ms. Gibson's behind on child support and thousands behind on daycare costs. So this is not a situation where she's currently sort of even floating as it is, and that's with a lower mortgage cost than she would have if she refinanced. What I ask the court to do is to order that the home be placed on the market, that it be placed on the market within the next 2 weeks. We're asking that it be, the parties use Kristen Sheetley. She's well-known, experienced. She's one of 2 real estate agents I commonly use, so this is not somebody's cherry-picked friend. If there's another suggestion, Sherry Ebold is one commonly used by many other offices as well. Either of those would be fine, in my opinion. That takes us to taxes and insurance. There's a claim by Ms. Gibson that sort of, hey, he's not paying the taxes and insurance on the home. That's not appropriate. If you look back at the old temporary order, Ms. Gibson's ordered to pay the home mortgage. The home mortgage includes taxes and insurance on the home. There's then this weird sort of spurious second line items in the order saying my client's supposed to pay the taxes and insurance as well, but that doesn't make sense when she's ordered to pay the mortgage. This was the temporary order was drafted by Ms. Gibson's prior attorney. Ambiguities go against the drafter, and in this case, the claim that my client should be paying those taxes and insurance that is rolled into the mortgage she's ordered to pay didn't happen until my client asked for payment on daycare costs. And it was only then that we received this, oh, you owe me for daycare costs. So now I'm going to claim that you should be paying the taxes on the home that I'm living in. That doesn't make a lot of sense. So we would like the court's affirmative order if possible on that as well. So given this, we're asking the court for a substantial judgment on the order to compel and order the home to be sold, order that the taxes and insurance were part of the mortgage.
Thank you, Your Honor. So first, regarding the discovery, all discovery that I've provided to Ms. Baldwin's office to date has been electronic. There's never been an objection. She's never called and said, hey, this is going to cost me X amount of dollars to print this. Each time I submitted discovery to her, I indicated in an email if there were issues opening documents or if she didn't think that I submitted everything to please contact me so we can work it out. And I received no indications from her whatsoever that anything was received. In regards to the motion to compel regarding the first discovery, that first discovery was done a long time ago. I, for the better part of 2022, spent the time without counsel. Had Ms. Baldwin wanted that discovery from me, she could have contacted me. I had no idea that that was something that I needed to regularly update for her. I will also just point out that I've not received any updated discovery from her client. I understand that's not before the court today, but so for her to say that I intentionally waited over a year to supply any sort of updated response for her, I believe is inaccurate. I'm not an attorney. All she had to do was reach out to me and say, hey, this discovery says it's ongoing. We haven't received anything from you. And I would have worked to get it to her. Instead, she just waited, filed a motion to compel, and then I had to provide all the documentation to the court, which I did. Ms. Baldwin also said that I provided all of the documentation to her late on May 1st. That is untrue. My second date to provide things was, sorry, I'm pulling up my calendar for you so I can be accurate, was April 28th. I did provide the vast majority of that second discovery to her. In my response, the thing that was outstanding was getting all of the copies of my text messages. And I had indicated in my response that I'd used multiple programs. My computer crashed. I was doing everything that I could to get it done. And I promptly got all of that response to her Monday, May 1st at 8:30 a.m. So I understand that that piece of it was not timely, but that was the only piece that wasn't timely. And I even indicated in my response to her that that was the only thing outstanding, and I was actively working to try to correct it. And I didn't hear anything from her office. Again, I've provided everything digitally and electronically from her. And this is the first time that something is being brought up about my owing fees for things. There was no CR26I conference regarding any of this. There was no phone call. There was no email saying, hey, this is thousands of pages long. You need to print this. Also, additionally, CR34, which is about producing documents for discovery, does not specifically state that they need to be produced by copies, but allows for a variety of production, including just allowing the documents available for inspection. I went a step above that and actually provided them to Ms. Baldwin, provided them in a format that was convenient for everyone using it electronically. And I do work in a law office. We send discovery documentation all the time to opposing counsels on USB drives. Yes, sometimes we send things through Dropbox, but normally our files are so large that we send them on USBs. It's not uncommon. The fact that it took her office that long to print all of that is out of my control. But again, I don't believe I should be responsible for those fees because CR34 doesn't state that I need to specifically provide printed copies of documents. I simply have to make them available for her to inspect. And I went a step above what the requirement was by actually providing the documentation to her. Had she wanted them in paper copies and saw that there was going to be an extensive cost to that, she could have reached out to me, and she chose not to. She chose to print it. There's also no declaration of fees from her office to support any of those costs, to support the page count, to support the time that it apparently took her staff to print all of that. In regard to, I believe the next thing she discussed was about the home, the family home. Excuse me. Back during the hearing in April, you had indicated to me that I needed to show that I could qualify for a refinance, not that I actually had to follow through with the refinance, which I clarified with you at a later hearing. The documentation that I provided isn't stuff that I looked up from the internet. You can see that there are emails from mortgage lenders showing what I would qualify for. The price of the home isn't set, the amount of what the home is worth, any of that stuff, that's all related to finalizing all the property assets, which is not before the court today. What the court asked me to do was to show that I could refinance for the home, and based on two different mortgage companies with two different lenders speaking to them with my estimates, that's what they said I would qualify for a refinance, and that's what I updated. So Ms. Baldwin's indication that I just pulled those off the internet is inaccurate because they're attached to emails from mortgage lenders, from mortgage companies. The home is still being paid on time. It is not being paid late. Everything is being paid. So at this time, I request that the court not order the home to be sold. This is my children's primary home. I believe another indication of trying to keep the children from having more residential time with me is to make it more of a financial obstacle for me. And I did what the court had instructed me to do and what I clarified with the court for me to do. And that's really all I can say about that. In regard to the property taxes and the homeowner's insurance, Judge Scudder, I believe it was, signed that temporary order back in November 2021. It states in paragraph form as well as in a chart who pays what obligation. It is said that I pay the first mortgage, but the property taxes and the homeowner's insurance are split equally between both parties. Yes, it is lumped into the mortgage payment, but on every mortgage statement, which the petitioner has provided some, it shows the escrow account that money goes into and what that charge is. I've had to cover that this entire time because he's chosen not to pay it. This was already argued in front of Judge Scudder back in, it was March in 2022, I believe, shortly after Ms. Baldwin became petitioner's counsel. This was already litigated in front of Judge Scudder, and he orally ruled that he was not going to change any of the the household expenses. He was not changing any of that at this time. So now Ms. Baldwin wants to come in and try and change something that was already litigated and already ruled on by Judge Scudder. So at that point, petitioner knew and his counsel knew that he needed to pay those halves of those expenses, and he still chose not to. My attorney at the time indicated to me and advised me that I should just pay that cost if I can, and that it would be settled out during settlement. The only reason I bring it up now is I have all of these additional obligations, and petitioner's not following through on his obligation that was initially set over a year and a half ago. So that's really the only reason why I brought it up is his declaration said that I was behind on a whole bunch of things, and I'd been working from the very beginning when when childcare expenses had gotten laid out. I had tried multiple times to work with petitioner, to work with his counsel, to get those things used as an offset, and the only response was, that's not what the court order says. That's not what the court order says. It very clearly indicates in two separate ways that that is how it is. It's never been changed, and that ruling, I believe, because it's never been altered in any subsequent order, is still valid. And then there was the issue about child support I pay that through the state. I was not aware that there was any outstanding balance. So I can call that division, I forget what their proper name is at the moment, so I apologize, to see what is going on with that. But that's continually paid. It's continually coming out of my paycheck. And the only thing that I ask in terms of that, in terms of any sort of outstanding things, is that we're able to use the outstanding homeowners taxes and property taxes, homeowners insurance and property taxes, offset the current childcare costs. I shouldn't have to bear the brunt of all of these financial obligations when for over 2 years, petitioner has blatantly not paid a court ordered expense. And then it was already litigated in front of Judge Scudder. He decided he was not going to change anything at the time, and it's continued to not be paid. So I've had to suck it up and pay it so that the house stays current, so the house stays in good standing, which I've done. So just in conclusion, I've complied with all of the discovery requests as well as I could. I sent emails to follow up with things were missing or things couldn't be opened. I got no response. I've tried to just comply the best that I can. And I don't believe fees are warranted in this case, because I, again, provided everything that was requested of me. My AT&T records, I pulled those directly off of my AT&T account. That was the only way that I was told by the local AT&T store here in town, as well as the customer service, that I could get them outside of going to the corporate headquarters, which is located in Texas. Looking through all of those documents, I'm having a hard time reading it and understanding it. But what I provided to the court was accurate from my AT&T account. I don't know how those differ from the business accounts that AT&T produce. But everything that the court ordered, or that the court had indicated for the GAL to review, was everything from November 2022 to current. There's just a handful of stuff there. Everything else prior, the court knew that there was contact. The only restriction on the contact was for him not to be around the children. Having phone calls doesn't indicate that anyone was around my children. We're not together. I haven't spoken to him. I can't even respond to the declaration that petitioner's mother filed for today. I believe that that's all hearsay, indicating a conversation that she overheard between two parties. Petitioner didn't even put it in his declaration. The only person who would be able to accurately respond to that would be Mr. Rosales, and I don't have contact with him because the court has said that I can't. So I feel like it's almost a trap sort of set up in order for me to get any sort of response. I can't even really respond to anything that's said in there. That's the first that I've heard that there was an alleged conversation. I feel like if there was a conversation like that, it would have been brought up before the end of May. I don't know when that alleged conversation occurred, but the only person who could potentially affirm or contradict that is Mr. Rosales, and I can't contact him because of current court standings. So I believe all of that is hearsay at this point, because there's no evidence to support that a conversation even happened. So I apologize, I was a little bit winded, Your Honor. But I don't believe fees are appropriate in this matter. I did everything that I could to comply. As I'm not an attorney, I did the best that I could. Ms. Baldwin could have very easily indicated to me via phone or via email if anything was missing or if I needed to print anything out, and I had zero contact with her. So I think any awarding of fees at this point is not reasonable.
The court goes back and looks at the correspondence attached to the February 22nd, 2023, and to the statements in the March 21, 2023, both motions to compel. One has a laundry list letter attached that I sent to Ms. Gibson, details the efforts to get her to comply. Same with the March motion to comply or motion to compel. So again, we've made significant efforts. There's a big difference between, hey, they didn't ask me to supplement and or asked me to update versus I said I'd supplement and I just never did. I just ignored the fact that I said I would give this to you later and then just decided not to. It's very challenging when someone says, I still am not having contact with him, and the text messages. So the phone logs show text messages and phone calls. And at some point, AT&T had to cut it off, but we show text messages between the two of them all the way through March 28th of 2023. And again, AT&T has to cut it off somewhere. So to continue sort of this facade at this point is just futile. I don't understand it. But regardless, it costs to subpoena things. And the only way we would have obtained these records is by subpoena because Ms. Gibson hid them. And there's no other explanation, especially when we have misspellings in the materials that she gave us that were supposedly native records. The fees that we've asked for are reasonable. As far as child support, again, the claims that I didn't know that I owe daycare costs, just ridiculous. There's no other word for that. She's very aware that she owes daycare costs. It's in black and white in these orders. The home sale, a home should be sold. What she provides literally says loan program scenarios. There's nothing saying that she would qualify as an actual refi. This is a mortgage lender just running through general scenarios of cost. If you're refinancing X dollar, this is what your rate will be, but not in any way that she would qualify to refinance. It is prejudicial to my client to not sell the property. The children don't live there. It is not their primary residence. Their primary residence is with their father, who lives up in Spanaway. We're asking the court at this point to order the home sold, order fees, and give the relief requested.
Right. Thank you. So I do have a little bit of a concern with the communication between, I'm going to start with the house, the communication between Ms. Gibson and Mr. Betneski from Guild Mortgage. And I understand Ms. Gibson's position that, this is what he's saying. But clearly it was don't run the credit. He didn't even confirm, he just ran numbers in a scenario that was requested to me. And I made note of this when I received the declaration affidavit that this doesn't satisfy the court that there would be a ability of the respondent to refinance. When we don't have the credit run, we don't have anything saying that she 100% qualifies and could do this, just the scenario, and here's the numbers. So that's concerning. I did set a deadline for that for the 16th, I believe, of May. The declaration was filed on the 12th. But when I reviewed that, and I sit here today still not thinking that's unfortunately sufficient. As for, I'm going to kind of jump around here a little bit, and I apologize for that. I understand the taxes, insurance. I understand that and I believe Ms. Gibson cut and paste part of the original order in her responsive declaration that basically outlines this is separated out. That's, to be frank, kind of strange. I've not seen an order that does that way. Almost every order has the property taxes and homeowners insurance as part of the mortgage and not separated out. That being said, you'd read the order as it sits, and it does indicate that the party shall place or split 50-50 all other community bills, excluding credit card debt, including but not limited to the HELOC, property taxes, and homeowners insurance. So I understand Ms. Gibson's frustration with that. And I do see it would be about $168 per person every month. And she totals that up to $3,028.50 in arrears for those two things. I don't know that she's officially filed something asking for that relief. So correct me if I'm wrong. She may have.
I have not, Your Honor.
Okay.
I didn't understand what to do.
So at this point, here's what I'm going to do. Ms. Baldwin, you're not are you available on the 20th? The 20th is closed. Did we close the 20th, Ms. Wade, or did we close the 13th?
The 13th.
We closed the 13th, but you're not here the 20th, Ms. Baldwin?
That's correct. I could be available the 13th or the 27th.
Okay. In regards to the discovery and the request for attorney's fees and costs, I'm going to grant some attorney's fees and costs. We had a motion to compel. I basically stayed the request for attorney's fees to see if we could get the discovery completed. I do have some concerns that, and I did a cursory review of the kind of comparing the phone records, and there are some pretty distinct differences in those phone records. So that is concerning to the court because it does appear as though, I mean, there's differences that are concerning. So I'm going to, as far as any attorney's fees and costs associated with discovery, I'm going to impose $2,500 in fees. And then as far as the house goes, I understand it sounds like Ms. Gibson is very much wanting to keep that house and believes that she can. So we're going to set a review and then presentation for June 27th at 1:00 p.m. If I have, Ms. Gibson, from you, something that says that I can refinance, the credit check has been done, and I can have the refinance done by X date and pay off the numbers that are appropriately needed to pay off Mr. Gibson, then I will consider allowing the refinance. If we don't have that information on the 27th of June, then I'm going to grant the request for the sale of the home. So it's really pretty much cut and dry. That there's
Okay.
no, and I just ask that you get that information to the court and the parties, because I understand some of that can take some time, maybe by sorry, I'm looking at the wrong month here, no later than the 23rd, just so we have an opportunity to review that and counsel can make any phone calls or inquiries as needed before the 27th.
I want to
Okay.
clarify, the home should be set at, for this purpose, and not any other purpose. The home should be set at a value of $400,000. So it's not that what I don't want her to do is go get essentially a payoff refinance. The CMA says essentially $400,000. That's what we should set it at. And that's what she should have to refinance at that value.
I would agree.
I don't understand. Can someone please clarify? I'm just trying to get my numbers correct.
Okay, well, you can't just say, well, I owe this much and I need to pay him X much, so I'm only refinancing the payoff amount plus the amount. You need to be able to refinance the entirety of the home to take that on. I understand that, and it may not work out to be that ultimately, depending on how everything works out, but you need to be able to take on the refinance of the entire home under your name. So that means credit will likely need to be run. We need confirmation that, yes, we can do this. It's just a matter of signing the paperwork. So that's what the court's looking for.
Okay.
If you run into any issues with that, Ms. Baldwin's office is available and is happy to have a discussion with you. We're not going to discuss it further here. So at this point, what's before me, GAL, we already set a date for Ms. Gravina to come back, and that's August 8th at 1 p.m. We're setting a review and presentation for June 27th at 1 p.m. for the orders on fees that were imposed, and to review whether Ms. Gibson is able to refinance the home with the ability to make a payoff that is necessary to the petition. So we'll see you all back in about a month on the 27th at 1 p.m. Gibson and Gibson, 2130038308.
That matter's ready. Although, so in this matter, for the record, I'm Chelsea Baldwin. I represent the petitioner Cameron Gibson. There's a couple different things on. The two main things are to review the sale of the family home, and the second is regarding the restraining order. The responses to both weren't filed until, or received at least at my office, until Friday at 4 via email. That means we've had no time to respond to them, which is not appropriate. So the opposing party is no stranger to the law. She works in the legal office. She's fully aware. And regarding the home sale, the court ordered that she was supposed to have responded timely. The court had set that matter over for a month. So here's what I'm asking that we do. I'm asking the court address the home sale. That's been pending since I believe March. So that should be addressed today. As far as the restraining order and the child issue, my client does need to respond to that. And I think that that's appropriate that my client have the ability to respond. I'm asking that we set that over to the 11th where, shoot, the court's not here on the 11th. We are already set on the 11th for a contempt. The court could set your preference to the 11th or the 18th. I don't have a super strong preference. So that's my request, is we deal with the home sale issue today. We set over the child issues to another date so that my client can file a response.
All right, nice. I would assume Miss Gibson will want to, well, I know that there was a supplemental report filed by the GAL requesting change in supervision, or excuse me, visitation. Is that something you want to pass as well? Or do you want to deal with that today, Ms. Baldwin?
I think that's really part and parcel with the child's issues. So, so I would sort of package all the issues associated with the child together.
So Miss Gibson, my Odyssey is not working very well. This is the first opening it today. Yesterday when I looked, none of your information was in. I looked at it yesterday at 2:36 p.m. and there was nothing in Odyssey. So between yesterday at 2:36 and today at 2:33, I didn't look again. I've been in court. So I haven't had an opportunity to review any of the responses, and it looks as though there were some declarations from other individuals that were filed as well.
Yes, Your Honor, if I may.
Sure.
Okay. At our last hearing, you indicated to me that any responsive documents that I had for today's hearing needed to be submitted to Ms. Baldwin's office by Friday. I submitted those to her office on Friday. I actually showed up earlier Friday afternoon to deliver documents to her office, and the office door was locked. So there was probably like a 20-minute delay between when I tried to physically drop off documents to her office and when I was actually able to get them to her office. Because the door was locked. So the indication that I didn't file timely, I filed it by your deadline that you gave me. Also, I understand if you haven't had an opportunity to review the police report that I filed under seal relating to all of this. Had Ms. Baldwin and her and her client, excuse me, if they had wanted to file any sort of response to the report, they could have freely obtained the report. That's the only reason that I even knew anything was going on. I've not had any contact with the GAL. I've sent her a handful of emails trying to inquire status and find out information from her. I didn't believe that I would get anything from Ms. Baldwin's office. But petitioner was told about the interview. It was conducted now 3 weeks ago. And if you would like to look in the report that I filed, I believe it's page 6 of that report. The officer indicated to Mr. Gibson the findings or non-findings rather of the CJAC interview. So
I guess my concern here is I don't want to get into the meat of the argument unless we're going to argue.
Okay.
No,
So-
I understand. I
Well,
guess
Ms. Gibson, let me talk for a second here. In reviewing the minutes, what you were to file by Friday was the refinancing of the home, not 7 other declarations that have to do with different things. So I just reviewed the minutes from the clerk,
Mhm.
and you had
Okay.
until Friday hold on, let me get back to it. So clearly there's a lot of other stuff that you filed that deals with a lot of other things. We were on today initially for a review of the ability to refinance. So when we were in court last, and I
Mhm.
said you could file things late or get things late to Miss Baldwin, it was for that specific reason, not for all the other reasons that have cropped up in the meantime. So with me not having reviewed them, I don't know how much time Miss Baldwin's had to review them. Some of those issues we will not get into today. That's just the way it is. We can get into the refinancing, and if you did file something specifically in regard to that, I can look for that and try to review it. I
I
don't know.
did, Your Honor. I
Okay,
apologize.
was it under seal, or was it just like under a financial record, or was it just?
I addressed it in my declaration that I filed. I also, oh no, I believe it's just in the declaration. I filed it on Friday. I also addressed a bench copy to Your Honor when I filed everything on Friday. So I apologize if that didn't make it to you.
It's it's page 3 of her declaration is where the home refinance information is. And then exhibit B that is attached to the same declaration.
All right. So Miss Baldwin, since you've clearly had an opportunity to review this, thank you, Miss Gibson. Since you've had an opportunity to review this, what is the position of Mr. Gibson on the refinance? And I'll listen to you and kind of look at what I have here.
Very good. So the easiest thing to do is honestly to just look at the exhibit B that she provided. So the court was very clear in its order. The court said you have to refinance at $400,000, which is the value of the home. And that you had to refinance sufficiently to withdraw half the equity. So you have to refinance essentially the existing debt. Half of the equity in this home is over $200,000. They only owe $180,000. It's a $400,000 home. That means each party's equity, their 50% share would be $110,000. And again, at that $400,000 total value of the home. When you look at the exhibit B that she provides, it fails on every level. So the first is that it is not a loan approval or an offer or an acceptance letter. It's none of those. It's once again just a person in office at a bank office clicking through, okay, 30% at this rate, at these dollars. So it fails there. This is not showing she can actually refinance the home and that any bank has accepted her as far as being able to get a home loan. Second, she set the home value at $350,000, directly contrary to your order. The $400,000 is even in the clerk's minutes. So she's not even trying to get the numbers correct. So fails there. And second, the offer or the materials that she provided shows a cash out of essentially $9,000. That is miles away from the $110,000 she would need to cash my client out for his half of the equity. Again, in this case, the court was very clear on what she had to do by today. She's unable to maintain the home post-divorce. She cannot cash out sufficient equity of the home that would be necessary. The court already ordered on May 30th that if she couldn't provide these parameters, the home will be sold. So the court's already ordered, hey, if you can't provide that you can refinance with these parameters, we're selling the home. That's the end of the story. So in this case, we're there. I also want to remind the court that this has been pending since March. So this is not a new issue. She's had an exceptionally long period of time to try to get this done, and she can't because it's not possible. She does not have the debt to income ratio, and that's even in like one of the emails she attaches from the fellow at the bank. It's hearsay, but nonetheless, it goes to show she can't do it because even he's saying, well, debt to income ratio has to be this. and she's not there. She just cannot make this happen. The idea that we should further delay the sale is not appropriate. In this case, again, this has been pending since March. Summer is the prime selling season for homes. Both parties are entitled to maximize the value from the sale and not wait until sort of that prime selling season is over. So we are asking at this point, she's had since March, April, May, June. We're at the end of June. She's had more than 4 months to get this done and hasn't. We're there. It's time. So we're asking the court to order that the home be sold. It should be placed on the market immediately. We're asking it to be placed on the market and marketed by Sherry Ewald. That's not my client's pick. That's my pick. Sherry Ewald has done work for Ms. McLean, Mr. Zandy, Ms. Bliss. I think every high quality attorney would testify or recommend her. So that would be my request. I don't want to delay in choosing an agent. Everyone should cooperate with the agent and the home should be placed on the market immediately. There's just after 4 months, there's no reason to continue to delay.
Right. Thank you. Any response to that specifically, Ms. Gibson?
Yes, Your Honor. Thank you. I did attempt to refinance, as I stated in my declaration from the loan officer that I spoke to. I was not allowed to complete the application process without court approval. Petitioner is still on the current mortgage that is being paid. So the loan officer, without any sort of written indication from the court that I could finish the application process to refinance the home solely in my name, they couldn't do that without either, as I said, court approval or authorization from petitioner. And I did what I could. Ms. Baldwin's indication that I'm not maintaining the home is inaccurate. The mortgage continues to be paid timely. The second mortgage continues to be paid timely. There's no issue of the home falling into foreclosure. I'm maintaining the home. I'm doing all of any sort of necessary repairs on it as I'm currently living there. In addition, none of the other community assets related to the parties have been settled or agreed upon. So I believe that this should be in consideration of all of that, whether it's by agreement of the parties or at trial. I understand Ms. Baldwin and petitioner's claim to the equity of the house. That makes sense. He's on the mortgage. But there's also other community assets that I have or should have equal access to that I don't. I understand if the court is going to order that the home be sold. In that instance, if they feel that the assets can be divided, I personally don't see how, since we've not dealt with any of the other community assets, why this needs to be taken care of separately when I'm continuing to make payments timely and everything is being kept up. I don't see that the home would be losing any sort of value between those times. If anything, it continues to accrue value as time goes on. I do ask, though, that if the court is going to order that the home be sold, that it be delayed at least 75 days to allow me to find time for other housing. The rental market right now in this county is very limited and rental costs are very high. So putting the home on the market and immediately having to try and move out of something without having adequate time to find other housing presents a lot of complications, including getting time back with my children, which I understand we're not talking about right this minute. Additionally, I would ask that each party get access to $20,000 of the proceeds of the sale of the home. I'm going to need access to that equity in order to find another situation and any other expenses that arise out of being forced to move. So I would ask the court hold off due to other community assets not being dealt with at this time, or if the court's going to order the sale of the home to delay 75 days to allow me time to find other housing accommodations.
Very briefly.
Yes, yes, Ms. Baldwin, hold on. Ms. Gibson, can you respond to why it was set at 350 versus 400 in the request for the refinance?
Oh, that was an oversight with the loan officer. I did speak to him and tell him that the assessed value through the court was $400,000. So I apologize that that was missed on my behalf. I can, if the court would like, I can get another thing from Mr. Alexander at the $400,000 assessed value rate. During mine and his phone conversation, I did indicate that the court set it at 400,000. So I apologize that it was inaccurately depicted in the paperwork that I provided.
And I'm assuming based on that, your comments, that he indicated that that would not be an issue. Is that correct?
I'm sorry, I don't understand the question.
Like you would still be able to do this process if it was 400 versus 350.
If for the assessed value of the home, yes.
Okay. All right. Thank you very much. Ms. Baldwin,
Yes.
go ahead.
What she means when she says he can do this process, he can run the numbers. He cannot approve the loan. Turn to the page after the mortgage passport page. So her exhibit B has 2 pages. First page says loan program scenarios. Second page is an email. Email is from the loan officer. Says, hello, Jill. Next line after that, our guidelines through Fannie Mae cannot exceed 45% debt to income DTI, max of $49.99 with 6 months, and then it goes on. It's saying you can't do this right now. If you look at the last line before I sent the scenarios, it says total payment of $1,507. Again, please keep in mind, this puts the numbers over 45%. She can't refinance it at $350,000. She certainly can't refinance it at $400,000. She can play with the scenarios. We can all play with math, but it doesn't mean that it'll be approved. This idea that you have to have court approval for a loan application, simply not true. You might need court approval to go through the process to finish and actually get a loan, but not to do an application. Similarly, I did what I could. The 350, if you look, he says down below, I sent the scenarios for your review. Means there was more than one. There's probably one that's at 400,000. She just doesn't want to show it or provide it here. And again, even this email says this is a very limited cash out. So this is, again, $9,000 cash out when the court said half the equity, which is $110,000 minimum. So at this point, we're there. The court's given her month after month after month to provide the same information. She hasn't been able to do it. The court was very clear giving her this last 30 days. She still has not complied or provided the information necessary. The court should order the home sold. 75 days puts us essentially at the end of August. That's not appropriate. Homes aren't sold one day and sold the next, type of a thing. The process still takes some amount of time. That gives her some amount of time to find a new housing situation for herself. As far as funds to both parties at the sale, I think that should wait until the home is sold. We can address that later once the home is sold. I think that's the most appropriate thing. The hearing coming up on the 11th is contempt regarding non-payment of children's expenses. So I think we should address more financial issues than just that all at the same time, again, after the sale.
All right. Thank you. So as far as I am going to order the house to be sold. And I am going to delay it slightly. I'm not going to give the 75 days. I'm going to give 30 days for it to get on the market. And as with the interest rates being what they are, houses are moving, but they aren't as moving as fast as they have been. So I'm assuming Ms. Gibson will have more than 30 days to prepare for this. As far as any distributions to the parties post-sale, I'm happy to consider that, but I don't want to dictate what those would potentially be at this point, since we don't know where we're going to fall with the home sale. I would absolutely be willing to consider a disbursement of some of those funds after the sale of the home to help the parties as we continue to move through the process. As for, and I don't have any reason at this point to say that Ms. Ebald is not appropriate to list the home. As for the 2 remaining issues that we need to deal with, so that have to do with the children. I'd like that done as quickly as possible. The 11th is available. I'm not here, but there's space on that docket. I'm not sure who's covering that docket. Potentially a commissioner, potentially another judge. It just would all depend. Then the next available for me would be the 18th. So I don't know, Miss Gibson, do you have a preference? I'm sure the parties want the sooner the better with dealing with the children. But I just want everyone to be aware on the 11th, it would not be me. So any preference from anyone?
I prefer consistency, but I'm fine either way.
Miss Gibson, do you have a preference?
Yes, Your Honor. I would prefer for this to be heard as soon as possible.
All right, so we'll set it for the 11th of July, 1:00 p.m. And I believe that'll close that docket, Miss Terry. So I'll give the last spot on the 11th to this matter. And I'm sure whatever judicial officer that is here will be more than prepared to handle the matter and address the parties' concerns and make a determination. So we'll pass the other two. And is presentation for the home sale order on that same date work for you, Ms. Baldwin?
Can't be the 11th because you won't be here.
Oh, that's right.
I could do it. So I am happy to pump out an order. And if Your Honor has space on your presentation docket this Friday, I'm happy to do it there because that's fairly straightforward. Otherwise, I think that puts us to the 18th. And then, so we can address that. And then I have one or two more quick clarifications.
I have court at 9 a.m. and I already have two presentations on this Friday. So if it can be, my hope is that it be agreed. I've made it's pretty short order. If not, then I guess we'll review it on the 18th. I'm trying to let me see if we can do I think the 18th, let's just set it for the 18th at 1 p.m.
And so just on clarifying, the home needs to be placed on the market. And I'm just picking July 27th because that's 30 days out. But everyone has to sign the paperwork, sale agreement, those types of things prior to that. What I don't want to do is nothing happens until the 27th as a method of delay. So essentially everybody needs to do all the prep work, but the home will actually be sort of listed on the MLS on the 27th.
No later than the 27th of July. Yes.
Okay, very good. And then the court's issuing that regarding the children, the current orders are just going to maintain until the 11th.
Correct.
Okay, very good. I think those are my only questions.
Okay. All right. Well, good luck, everybody. I'll see you on the 18th, and then the other matters will be heard on the 11th.
Very good. Thank you.
Okay. Ms. Baldwin, let's go back to
Gibson.
your case on Gibson.
Very good. This is 21-300-38308. For the record, I'm Chelsea Baldwin. I represent the father and custodial parent, Cameron Gibson. These are our motions. Again, just for the court's reference, there is a presentation noted that's already on the calendar for next week for Judge Fassett.
Okay.
I'll note for the court, the children of this action are young. Genevieve is 4 and Isabel is 2-3 years old. This case unfortunately has a long history at this point with more than 200 case pleadings so far. The history is important, so I am going to detail some of it because even if the court read quite a bit, you probably didn't read all the way back. And so I'm just going to pare it down to the history that's most relevant to what's going on regarding first the restraining order. So in this case, originally the children were placed with the mother with significant time to the father, who was an active and involved parent. A critical provision was included in the prior parenting plan that the children were to have no contact whatsoever with the mother's boyfriend, Brian Rosales. That was in place because Mr. Rosales is a dangerous felon. He has prior domestic violence convictions in Superior Court. He has a prior finding of domestic violence regarding his own children. He has a prior assault 3 felony conviction. He has the records reflect that he struck his primary partner in the face with a closed fist multiple times. There are domestic violence protection orders between him and his last prior partner. And again, findings in his own parenting plan regarding his children of domestic violence, emotional or physical problem, and abusive use of control. He has no contact with his own children. And this is why the court said he was to have no contact with the children of this action, because he was a dangerous person. From that order forward, for nearly or just past a year, the respondent mother denied the children having any contact, repeatedly said she'd cut ties with this person or moved on. But the reality is those denials were just simply mistruths and lies, and several of them straight up. The children had contact with Mr. Rosales, and despite this, the respondent mother misrepresented, she lied, and she actively hid the truth from the court, from the guardian ad litem, from her own counselors and everyone else. In October of 2022, my client dropped off the children and shortly thereafter received a text from the respondent mother that said, "He's gone." And my client thought, that's odd. And what she meant to do was text Mr. Rosales that my client was gone. She did not mean to text my client. Video proof from a neighbor nearby would then show that shortly after my client dropped off the children and this text was sent, Mr. Rosales pulled up, picked up the mother and the children, and they then drove away. Text messages that had been previously filed with the court, which are voluminous, and the text messages and phone records are just the text and phone records between Mr. Rosales and the respondent mother, show hundreds, if not thousands, of communications over the last year, showing the depth and breadth of their relationship, that it was daily, it was continuing, and the information is that he resided largely with the respondent mother and the children, very much contrary to court order. When he was when the respondent mother was finally caught on video violating the court order and putting the children at risk, is when the court finally changed custody. I'll note that this came before the court with the children referencing things such as, "We're not supposed to talk about Brian." And there was a significant level of control and authority exercised by the respondent mother over these very young children who were, I would argue, terrified to say anything. Children that age generally are going to let things slip unless they are very much motivated to not do so. And in this case, the respondent mother was able to do that and extort her own children to remain silent. From there, she was caught in October of 2022. The children, came out that the children had been repeatedly exposed, and we would argue almost daily exposed to Mr. Rosales. During the same period of time, just before October, the children were showing up, and it's included in the file, but quite a bit back. There's photos of the children with bruises on their faces that are unexplained. The mother would refuse to put the children on video during video conferences. Again, the concern being that because Mr. Rosales is in the background or the children were sporting other injuries. The court took exception and changed custody in October. Unfortunately, from there moving forward, the children have resided with my client. He's gotten them involved in counseling. They're doing very well, but my client is now tasked with unwinding from the children that they need to be secret keepers, and telling them that the truth matters, the truth is important, and that children are not to keep secrets, that's wrong. And that's something that the children really don't understand. And it's very difficult for them, having spent a year so carefully guarding themselves and keeping these secrets for their mother. On May 29th, Genevieve made a disclosure of sexual assault regarding Mr. Rosales. From there, my client took appropriate steps, contacting law enforcement, getting the child into counseling, getting the child scheduled for a CJAC interview. At the first CJAC interview, the child was reasonably not comfortable. This is a new process. She had never met these people. She did not make the same disclosure at the CJAC interview. She was then scheduled to begin very specific counseling that's aimed at young children. That began just, I believe, July 1st. So the child is now meeting with a counselor that has specialized training in counseling and working with young children who've been the victims of sexual assault. Child's already starting to make not disclosures of assault, but disclosures regarding contact, including contact that occurred during the child being bathed already with that counselor. Child subsequently made additional disclosures to my client and to others, and a second CJEC interview is being scheduled if that hasn't been scheduled already. Child is scheduled to remain in this really specific sort of targeted counseling through essentially mid-August. So it's not a long-term counseling situation. It's very specific and aimed at helping children who are in this unique position. So what we're asking the court to do with the restraining order is to maintain the current order, which has no contact for the respondent mother while this counseling continues and while the second CJEC interview can be conducted. The reason is that the mother was the one that made these children keep this secret for more than a year. Any contact reinforces secret keeping. Any contact allows the mother to be in this position where just her presence reaffirms that love means silence, that love means keeping secrets, that this is their job and something that they have to do. She exercised that power and control over them for a long period of time. At this point, her presence in and of itself reinforces that prior behavior. And what the children need to do at this point is to just tell the truth, whatever that truth is what we're looking to do. So we're asking that the that the restraining order remain while the child finishes the specialized counseling. That's really not that long. It's scheduled to end essentially mid-August with a review expected August 18th. So that's just over a month. That's about 5 weeks out from where we are today, about 45 days. That allows the children to, again, work with the counselor, but without the pressure of the other parent who's asked them to keep secrets, and specifically keep secrets about Mr. Rosales. We then asked that the court set a review for August 29th, which is essentially the next available day regarding the restraining order. At that point, we'll have the counselor's report, which is an expert report. We should have a second CJEC interview, and we have the child who's been given sort of the grace and space to make whatever disclosures she's going to make. Again, these are very young children. Their process is not an adult process. It's not necessarily linear or easy for them. They are very much challenged with not the right tool set that we have, and certainly not the same communication tool set. So that's what we're asking as far as the restraining order. Not permanent at this point, but to give the child space to work through the process. Does the court want to address these one at a time, or would you like me to move on to my motion for contempt?
Let's do one at a time, since I think I can separate them fairly easily. So
Very good.
Ms. Gibson, your response to the request for an extension of the restraining order.
Thank you, Your Honor. I'm going to ask that the temporary order not be extended. As Ms. Baldwin indicated, this has been a long process with a lot of hearings and a lot of documents provided. There were some key dates when Ms. Baldwin detailed the history of this case that I feel are pertinent for you if you didn't have the opportunity to review them in the file. So I have been the girls' primary parent since they've been born. I was designated the primary parent until the hearing in November of 2022. I was assured by the GAL on our case that this was just temporary for the kids, and that, you know, we had a hearing set for February 7th of 2023 to address it. At that February 7th hearing, the GAL filed her final report, which named me as the primary parent. During that hearing, Ms. Baldwin alleged that they had continued video evidence of violence and yelling in front of my residence, and requested that the GAL report be pushed out and the investigation be continued. To date, that video has never been produced. So at a hearing where I should have been able to move forward and petition the court to get time back with my children, there was an allegation of evidence that has yet to be produced to any party, to my knowledge. We did have a hearing on May 30th of this year, 23, which talked about the disclosure that she referenced and wanting to schedule the CJAC interview. But there was nothing in front of the court at that time to change the current parenting plan. Prior to this temporary order, I'm on supervised visits. I have been since November. The supervised visits are either with, we have 3 designated people. One is my sister, one is petitioner's father, and one is a very good friend of my family. So since November, I have not had time alone with the children. They've been supervised by these 3 individuals that have been agreed upon by the parties. So because Judge Fassett at that May 30th hearing stated that there was no change to the parenting plan because there was nothing in front of her to change that, that's when the ex parte order was signed. It was submitted and signed by a judge on June 2nd. That should have been heard 14 days from when it was signed. I believe that's the standard timeline. It got extended out to June 27th because we were already scheduled for a hearing that day. Okay, fine. By June 22nd, I hadn't heard anything from anyone. I hadn't heard from the police officer who had initially tried to reach out to me regarding the disclosure. I hadn't heard from the GAL. I hadn't heard from anyone. So I submitted a public records request to the Kelso Police Department to find out if the CJAC interview had taken place and what was going on with the file. The report that I received that I filed with the court indicated that the CJAC interview happened on June 5th. No disclosure was made at that time. So the officer informed petitioner that no disclosure was made and they were going to be closing their file. In that report, it's noted that Kelso PD closed their file the following day on June 6th. At the hearing we were just had a couple of weeks ago in front of Judge Fassett.
Hold on, Ms. Gibson. We just need to pause for a minute. Hold tight.
Yes, ma'am.
But it's not. Okay. We're just dealing with a tech issue, so just hold tight here.
Oh, okay.
You want me to test playback? Okay. We are back up and running. So Ms. Gibson, hopefully you remember where you left off. Go ahead.
Okay. So yes, I received that report from Kelso PD on June 22nd. I then filed it with the court the very next day on the 23rd, along with documentation from, documentation from DCYF, which is my understanding of CPS, that their file is also closed, that they never even opened a file, that there were multiple intakes taken in regards to this disclosure by different people. You can see in the where it states decision on all of those intakes that they were screened out, meaning a file was never opened because it was referred back to law enforcement. We had a hearing on June 27th, just 2 weeks ago, in which counsel indicated that I had filed some things late. I had only done that because I just received the documented information, but that she had asked Judge Fassett to set it over to today's docket so that she had time to respond to the documents. The documents that I received, which weren't even filed with the court until this past Friday, July 7th, was that apparently there's another disclosure. And apparently that disclosure was made on June 14th. So nearly a month ago, that disclosure was made. There's no indication of it in any of the CPS file. There's no indication of it in the Kelso police file. Otherwise, I wouldn't have been able to obtain that report. Additionally, when I found that information out, I called back to the Kelso Police Department and filed on Monday. So I don't know if you received a copy of this or not. I tried to get it to you.
Yes, your email with the police department.
Yes. Yeah, so I followed up with Kelso PD, thinking that there might be something added because this alleged disclosure happened almost a month ago, and they indicated to me that there was nothing new added to the file. So it's just really alarming that petitioner and his mother in these declarations are alleging that another disclosure happened, and it's not in any of these files. That's very alarming to me. And that Ms. Baldwin didn't bring that up during the hearing 2 weeks ago. Her indication was we need time to respond, not, oh my gosh, there was this other allegation that needs to be addressed and heard. So we're at this hearing today, which is 40 days since the ex parte order was signed on June 2nd. 40 days, Your Honor. I haven't seen my children at this point in almost 2 months. The temporary order was only supposed to be until the CJAC interview was conducted. The interview was conducted the next business day on the 5th after the order was signed. No disclosure was made, and all of the files from everything I've been able to obtain are closed. There was no finding, and it's done. Both counsel and the GAL stated that this CJAC interview needed to be done to see and confirm if anything happened. The CJAC interviewers, from my understanding, are trained specifically in this field to find out the truth. And the truth is she made no disclosure. Nothing happened and the files are closed. So now I'm flabbergasted, Your Honor, because I was told that this CJAC interview would be the definitive thing, that yes, something happened, or no, we didn't, so it could move on. And now it's, well, nothing happened this time, and now we need all of these other things to happen. It's also, through reading petitioner's declaration filed on July 7th, this is the first time I'm hearing that my daughter is seeing a new counselor. To my knowledge, this temporary no contact order doesn't change our just joint decision making that's currently as the rest of our temporary plan. So the fact that I was never notified by anyone that my daughter is now seeing this other provider is not okay either. I would just say that it's in the best interest of the children to have contact with me. As I stated, until November of 22, I was their primary caregiver since birth. I took care of them all of the time since petitioner worked so much. And due to this ex parte order being signed, I missed my preschooler's graduation as well as her 5th birthday. She just recently turned 5. I couldn't contact her on her birthday to reach out and wish her a happy birthday. My family also tried to reach out, and to my knowledge, didn't receive any sort of response from petitioner. So no one in my family was able to call her and wish her a happy birthday. I made a mistake back in November. I've recognized and acknowledged that to the court. I followed all of the court recommendations since then, and I've been on supervised visits. As I've stated, half of those supervised visits are with petitioners' families. My supervisors have submitted declarations to the court stating that they'll sign anything necessary. I'm not on unsupervised time. Nothing has happened. There have been no disclosures for any of the time that I've been on these supervised visits. So I don't believe there's any reason to allow the no contact order to continue. It's been, even just since the order was signed, it's been 40 days, and I'm just now being able to be heard on this matter.
Okay.
My children need their mother in their life, and I'm asking for the supervised visits to be returned.
All right. Thank you, Ms. Gibson. Ms. Gravina, are you here to give input on this issue or the contempt issue, or both?
A little of everything, I think, Your Honor, but I think my concern extends a little bit further back, as Ms. Baldwin kind of addressed. While in some cases I would agree with Ms. Gibson, and she is right in some of her aspects, what I would say is that when this matter was brought forward, when Ms. Gibson was discovered to have Mr. Rosales around the children, the concern had been about the dishonesty and the lying, and mother very blatantly lied not only to me but to the court, and when caught in the situation then was able to finally admit, but there was some significant concern, and there was some significant growth that the court had kind of placed on mom's shoulders to expect her to step up to the plate and show that she was making changes and that she could be trusted and that this was a priority for her. And at first it did appear that way, which is when I put out my additional information saying that it does appear, or that I was at that place where I put out the report and say it does appear mom did address these things. This is where everything is at. And then that weekend or that week was contacted and said, there's some concern. There was an altercation. Mother's contention was that she had a pipe burst and had only the ability to contact him. No other family members were available. She had tried a number of people. The city had already closed. It was too late on a Friday. And mother had indicated repeatedly that there was not an ongoing relationship. And father and Miss Baldwin had addressed to the court that there was some pretty significant concern about mother lying specifically about this in the past, and that there was an inability to trust that she was not continuing that relationship and what that would look like for the girls if they were to return to her care, and mother can't be trusted. The court did ask that I investigate specifically for that. As that progressed and as discovery was ongoing throughout that, there were a number of conversations between mother and I, specifically regarding the contact. Mother repeatedly indicated that no, there was, initially a couple of conversations right when the matter happened in October where she broke up and he had to get his, few things that he had at the home. And then there was nothing further. Mother reiterated that to me several times. No, there was only that call. And then the one call where I had to have him come over and help me fix the pipe. There will not be any more than those two instances on those particular days. I indicated to mother that the court was specifically asking if mother was being honest, and that was the standard that the court had asked me to investigate, and whether that reflected in the messages and in the discovery and in subsequent information throughout that period. At one point I received records from mother. Father indicated that he didn't believe those were accurate records. There were misspellings. There was, the records just looked a little funky. And father had expressed concern and asked that I wait and not formulate my opinion, but that they were going to subpoena the records. The records came and there were dozens per page of calls missing. And when addressing the issue with mother and discussing, hey, these records don't match up, mother's indication was, well, I don't understand why they're missing all of those. And I specifically asked mom, even if they didn't match, when you indicated to me that you were not continuing to talk to him, you would know whether you did or not. I feel like the dishonesty means that I'm struggling to believe the things you say. Within, I think, 48 hours of reviewing those records was also the disclosure. And so those conversations at the same time gave me a significant rise to concern. Mother in that conversation also indicated there were not times where Mr. Rosales was around the children. The children have continued to say that's not accurate. It is now becoming more and more difficult to believe mother's report on those things when mother blatantly lies, and the children are saying that mother blatantly lies and tells them to lie. And I have, because of those records, already had concern and was ready to address with the court that there was concern about mother's ability to report honestly, and that mother's willingness to protect against Mr. Rosales, and that she was unwilling to be honest about his presence in her and the children's lives, gave rise to concern for continued contact, and what a recommendation for time would that look like at that point. And then with the disclosure is a significant hesitancy to believe how mom reports she's discussing things with the girls, how mom is saying, well, I've never told the girls to lie, but the girls repeatedly say, mommy said to lie. Mommy, they are continuing to say this to father, apparently to counselors, although I have not heard back from the counselor yet. So when I brought this up with mother's contention is that Mr. Rosales did not have contact alone with the children. However, in a transcribe where Mr. Rosales made a call to father the transcribe, he admits regularly being alone with the girls and even caring for them while mom was not present and things like that. And so there is a significant level of understanding whether there will be accurate disclosure if mother has been or continues to encourage these types of conversations where they're not allowed to talk, or they are told to lie, or they believe that even if mother hasn't, they're reporting that that's how they feel about the situation. And they have definitely felt unheard about Mr. Rosales and not believed throughout this time by being told, no, that's not accurate. He's not still there. You're not still seeing him. But then a year into this, that turned out to not be the case. And so my level of concern, even for myself, I have a concern that it's beyond my scope and role to even go interview the children when there are professionals that are trained to do this and they should be the ones doing it. I am even hesitant to go meet with the girls until the professionals have completed their investigation and have a recommendation. I have not received any calls back from CPS yet, so I don't have that information to update. Although I did see mother's documentation, I just have not verified anything further or if there's anything going on or ongoing, I mean. So I do have levels of concern. I am hesitant to believe almost anything mom reports at this point. There have been numerous incidences over the course of this investigation where mother has just blatantly made things up and found to be not the case later on, and to the point where the girls have now been put at risk. And the concern is the unwillingness to protect or the failure to protect from that individual. And on top of that, the encouragement to lie or keep secrets.
Thank you. I appreciate that input. My decision on extension of the restraining order is this. I am going to extend the restraining order through the date the court can next review this, most closely following what we think will be the end of counseling. I believe that date is August 29th, 2023 at 1 o'clock. My reason for this is I do believe, based on the pleadings, the reason for initially imposing the restraining order still apply. I do feel as though more likely than not, we do need to protect the child further at this point, while potentially either a second CJAC interview is being conducted or has recently been conducted, and further discussions with a counselor will be had. I take into account the age of the minor, which based on my training and experience does tell me that it could take some time for a child to be comfortable with a counselor or other adult before truly opening up. So I think this is warranted given the allegations and given the documentation of credibility issues with respondent in this case. So I am going to sign that order. Ms. Baldwin, I didn't know if you had a separate one that you were sending over, but I do have the proposed one I got had extended it just through today's hearing. So I just crossed that out and put August 29th at 1 o'clock. I initialed it.
Very good.
And I'll file that with the clerk, but if you're needing something different, certainly. Okay.
That should be
fine. Okay, I will sign that and it is filed.
So the next issue is the motion for contempt. The motion for contempt is pretty straightforward and clear cut. The obligations of child support include the actual transfer payment, but they also include payments on daycare expenses. Both parties owe a percentage share of the daycare cost. My client advances the cost at 100%, and then Mrs. is obligated to pay 40% of that total cost to him. I'll note, this is not our first contempt regarding financial misdealings regarding the respondent. There's a prior contempt from April 11th of this year, also regarding financial issues. In this case, the issue is specifically regarding those daycare costs. Those costs were incurred. No one disputes that. The bills were timely forwarded. No one disputes that. And the respondent has not paid, except she made I think $350 has been her total payment. Her entirety of her argument is simply the argument for an offset, which is not appropriate. Child support is a completely independent obligation from any other obligation. There is no ability to self-help in any way. And that is essentially what she is arguing about. That's not appropriate. She's arguing for an offset. And even if you were to delve into that argument, which I don't think you should, essentially her prior attorney wrote that she was obligated to pay the mortgage, which does include, and everyone agrees it includes, the taxes and insurance. And then below that, put that my client was obligated to pay, I believe, the taxes on the real property home that Mrs. is residing in. I would argue that's an ambiguity. That is a confusion, as we know from contract law, that's construed against the drafter, and the drafter in this case was Ms. Gibson and her attorney at that time. So an offset is not ever appropriate in child support, but even as it was in this case, you just don't rise to that. The next argument she attempts to make is essentially that, well, gee, I can't afford it. There's no evidence in the record of that either. She doesn't provide any financial declaration, no budget, no expenses, just sort of a bold-faced, I can't pay, so I'm not going to. I'm going to pay what I want to. The reality is these children have expenses. They are very real, they're very present, and they're required. My client needs for the children to be in childcare just like they were in childcare previously when they were in mother's care, and my client paid. It's this shoes on the other foot, and Mrs. is saying, I'm just not going to do it. I'm not going to pay, and you can't make me kind of a situation, and that's not appropriate. So in this case, other than I said, she's made about $350 worth of payments since October. But at this point, the total arrears is approaching $5,000, $4,690 through the date of filing of the contempt. She also is obligated to pay 12% interest on that. That's statutory. We are asking for fees of $3,500. This is a long-term refusal. Efforts have been made to get her to comply. She's just ignoring them. That's not appropriate. A sanction of $1,000 and costs of $75. That's essentially service fees and ex parte filing fees. In this case, absent payment, the children really are very much in danger of losing their daycare position because my client just can't do it all. He cannot front the entire cost permanently, fronting essentially mother's court order responsibility. The prior child support order outlines mother's income at $3,300 per month net. She has a reduced child support obligation of $552. She has more than $2,700 per month to pay and make her bills. You notice that absent from her declaration is any statements on any efforts whatsoever to reduce costs in her household. She doesn't say, I've cut my cable, I'm eating beans and rice. I'm doing everything cheap. I'm not wearing makeup. She hasn't cut a single expense. It's just, I'm not going to pay because kids are with Mr. and I think I can get away with not doing it. That's not appropriate. Again, this is the child's right to receive support. A mother is ignoring the things that are necessary for the children and their world. We're asking the court to find contempt, order the arrears and the fees and penalties that we've outlined. Additionally, the court should set a review and a amount certain that mother has to pay towards the arrears to bring herself current.
Ms. Gibson, I do have your responsive pleading on this issue. And I am going to let you make argument to me as Ms. Baldwin did. I just want to clarify, I believe you've acknowledged in your response that you have not paid the 40% towards the expenses. Is that correct?
I have been paying towards it, Your Honor. I do just want to say at the hearing 2 weeks ago, the indication that I received was that this was going to be heard by Judge Fassett next week. My responsive declaration in regards to this, I omitted a bunch of information because this has already been litigated and talked about before Judge Scudder and Judge Fassett. Okay. So omitted some information that I've provided in previous declarations because my understanding was this was going to be heard in front of Judge Fassett. So I'm not fully prepared to argue this today. However, if you need me to, I will do my best. But my understanding from the hearing 2 weeks ago was that this was pushed to Judge Fassett's docket next week.
Are you, there, you do have a presentation in front of Judge Fassett regarding the sale of the home, which was set to July 18th at 1 o'clock. Are
Yeah.
you, the court notes I have state that court sets child issues and restraining order to today, July 11th.
That'd be correct. I think this is the actual show cause date. So this was set via the show cause. I don't believe it was on last week or last time this was before the court. I believe this was the show cause date that was originally set. And then I essentially said, well, Judge, we're already on. Mrs. was given the option to put the restraining order over to have Judge Fassett hear it next week when she returns. She said, no, I want to have it heard. This is the first time this is being heard. It's appropriate that we go forward today. Everyone submitted their responses today. There's nothing more to be submitted at this point. So I think it's appropriate that we move forward. And I would disagree that the issue of contempt on child support has been raised previously.
Okay. And I'm just digging into this a little further. So let me clarify, Ms. Gibson, are you planning to submit additional evidence to the court regarding the contempt issue?
The responsive declaration and the financial declaration that I filed on July 6th was based on my understanding that this was going to be heard next week by Judge Fassett, who has already previously ruled on issues that are related to this contempt that she had to look over from when Judge Scudder was our initial judge. Had I known that this was going to be before you today, I would have filed a completely different declaration to outline and explain some of that, but I didn't, based on my understanding that Judge Fassett was hearing all of this and she's previously heard some continued issues regarding payments of bills for both parties.
Yeah, and I think here might lie the confusion. And, Ms. Gibson, I understand you are unrepresented. In one instance, when you all were in front of Judge Fassett on June 27th, the notes, the typed up clerk's notes do reflect that, quote, court sets child issues and restraining order to July 11 at 1 o'clock. Presentation of order regarding sale of home set to July 18 at 1 o'clock. But then down below, it does indicate on July 18, 2023, 1 o'clock, show cause contempt, Judge Fassett, July 18, 2023, 1 o'clock, presentation of order. So I think there might be some confusion. I guess what I would say is I understand Ms. Gibson's confusion on whether the show cause contempt was going to be addressed today versus heard by Judge Fassett, who has already heard some of this case. So I think what I'm going to do, given what Ms. Gibson has stated to me just now, and my review of the notes that do show July 18th for show cause contempt, I think I'm going to give Ms. Gibson the benefit of the doubt and just move this specific show cause contempt issue to next week, July 18th, since you're apparently already set for that.
And just for the court's reference,
yes,
the only reason it appears, that's the alternate date. So that's why it shows.
Right.
So she was served timely for today, and we always set them so there's the initial date. But if you don't serve correctly or get it served in the right amount of time, there's always an alternate date. So that's why it appears on the court's calendar next week.
Gotcha. And I guess I'll ask you, Ms. Baldwin, do you have a strong objection to setting this over 1 week for Judge Fassett to handle?
Only if I understand the court's concern. I would just ask to reserve fees. We're here. I basically made argument She listens to my argument and then says, oh, I should have filed a bunch of things. And now is going to have a week to file things that now are not going to conform
Yep.
with the local court rules. So that would sort of be my concern.
Yep, so I think I'll make the record clear that if there's additional attorney fees, let us, for sake of argument, if we assume that this motion is ultimately granted and attorney fees entered, certainly the court would entertain the additional attorney fees for essentially re-argument in 1 week, which I think is appropriate.
Okay, very good. If the court would just make sure that that's in the clerk's minutes, then we could address it with Judge Fassett.
And I'll make sure I'll send a follow-up email to Judge Fassett so she knows what my ruling was today. Okay. Anything else on this matter from the parties?
No, Your Honor, not on this matter.
Okay. Ms. Gibson, you'll be back before Judge Fassett next week, next Tuesday, at 1 o'clock to, and just so you're clear, the two issues you'll be addressing are presentation of the order regarding sale of home, and now at this contempt motion.
Thank you, Your Honor.
Okay, all right. You're free to log out.
Gibson and Gibson.
That matter's ready. First issue we have is presentation, and then we can take up the contempt. So we have really two presentations. When we looked at the file, we realized there was one regarding the home sale, and there was a cleanup one that had never been entered from May. So I'll address the home sale one first. There should be an order regarding home sale. Ms. Gibson filed objections. The only thing she's really objecting to is I'm asking for the home proceeds to be placed in my trust account. She wants it to be placed in essentially a bank account with both their names on it. That's just not appropriate. It should be a significant amount of funds. Ms. Gibson's already been found in contempt for financial misconduct in this case. Second, based on material she's previously filed, there are concerns whether or not she has fraudulently altered documents, again, leading to quite a bit of concern on what she would do to access those funds. She doesn't provide any other basis for putting it into a sort of traditional bank account instead of an attorney's trust account for safekeeping. There's just no reason not to protect the funds, especially when we anticipate the funds will be $150,000 or more. My client just wants the funds protected and have them placed in my trust account. So we're asking the court to sign the order as presented.
And when were those objections filed? Because I didn't see any objections.
Yeah, I can find it. Looks like she filed July 6th.
Okay.
It's Clerk's Papers 223, if that helps.
Their objection to proposed orders. Thank you.
Yes.
Okay. And I guess I did review that. Miss Gibson, any response there?
Yes, Your Honor. Putting them in a joint account gives equal access to both parties. You had previously ruled, because I'd also asked at that hearing where the court had decided for the home to be sold, that each party be allowed access to some of those funds, particularly because I will need access to some of the funds in order to move. And you said that you would reserve and consider that at the time when the home sells. I need access to those funds. Ms. Baldwin's accusation that I've documented or falsified financial records just isn't true. And it's also really easy to see if there's a joint account, if money's taken out, which person takes it out, where it comes out of. So there's no risk of money being moved without the parties being aware of it. And because you made that ruling that you would decide or that you would be willing to allocate some of those proceeds, it just makes sense to put them in a joint account. It can accrue interest during that time. Both parties can see where the money is. so that I can just know that if the court does make a ruling that I am allowed access to those funds, that I can get immediate access to those, that I'm not trying to have to work through Ms. Baldwin's office, which whatever delay that may or may not incur, that I have funds available should the court allocate those to each party. So that's my only concern. And I guess just a clarification point, I don't know if it needed to be in the presentation order, that when the realtor comes out, if there are any costs to any sort of, not upgrades, but any sort of costs incurring to getting the home ready to sell, that those be split equally among the parties, that I shouldn't be solely responsible for those, as petitioner is still on the mortgages for the house, and they are the party that wanted the home sold and not myself.
Okay. Let me start and then I'll turn to you, Ms. Baldwin. So I guess as to the trust account, there are very, 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 very strict guidelines on attorneys' trust accounts. And frankly, the historical posture of this case, I think the trust account is the appropriate place for the funds. If there is an allocation of funds, which I did reserve and said I would be willing to consider to allocate funds, there should not be a significant delay because it's in a trust account versus a joint account. There was, I believe, a contempt that was found previously for on a respondent for essentially doing the thing that you're claiming you're worried about happening to you. So I am not swayed by that argument. So I think the trust account is appropriate. As to any, and I appreciate Ms. Gibson raising this issue because I don't know if that was brought up. So if there is, something that needs to be done to the house in order to approve it for sale, I don't know that we address that. So Ms. Baldwin, whenever you're ready.
So on that issue, that really hasn't been raised in any declarations previously or any motions previously. Generally, because we do have a selected real estate agent, that agent will go through the home, make recommendations on what's possible, what's feasible, what's financially prudent. And then usually the parties work that out. So it's to both of their benefits to maximize the sale price. I'm not saying my client won't contribute, but the contempt that we have coming up next indicates my client doesn't have a lot of funds to do that with. And so I just don't think the court should address it. I have Ms. Ebald's information. She readily communicates with me if there's some kind of repair or sort of curbside improvement, beautification. We can certainly talk about that. I just don't think it's properly before the court. So again, both parties are motivated to deal with improvements. Usually then the way we handle that is after the fact. Everybody provides receipts and that gets paid off the top. So I don't have any objections to those sorts of things. But again, those all need to be agreed on, things that Mrs. Ebald recommends. And so I don't think the court should address it today. I just don't think that I don't think it's necessary. It's not properly before the court. It's something that I haven't historically had a problem handling when both parties are motivated to maximize the sale price.
So at this point, it sounds like there's a commitment to trying to work things out. If there are any bills or anything that, if there's a water heater on its last legs that needs to be replaced, whatever it is that's suggested, or if something comes back from a home inspection that, I think that can all be negotiated either outside of the court's purview or in front of the court if it comes to that. But my hope would be that the parties would be able to work together on those issues. So I am going to sign the order regarding home sale as it's presented. Then I have the order on hearing from May 30th. Ms. Baldwin.
Yes, we did provide that. I'll note we didn't provide a full week's notice on that. If Ms. Gibson is requesting additional time, that's fine. I think this was intended to be presented at a prior hearing, but we had some intervening surprise things happen. And so this sort of fell by the wayside. So haven't received any objections to date, but she's had less than the full week.
Ms. Gibson, do you want to, are you prepared to deal with this today, or would you like more time to review the proposed order for on hearing from May 30th?
I would appreciate some more time. I was confused when I received it, what it was regarding or what it was about. So I am not sure how to address it because I didn't know what it was in reference to.
Okay. Do you, is 2 weeks enough time for everyone?
That's fine.
Does that work for you,
Okay.
Ms. Gibson?
Yes.
Okay, so we'll, I'll set over the order on hearing for May 30th to 8/1/23 at 1 p.m. And I made a note, Ms. Baldwin, on your original order in hopes the clerks will hang on to it for that 2-week period. Okay, and is there another issue that we need to address?
Yes, we're also before the court on contempt.
If I may, before you begin, Ms. Baldwin,
Go ahead.
for the court. So I have been in the process for a while now of trying to obtain counsel. I had a scheduled consultation appointment with counsel that got unexpectedly rescheduled due to an illness. I had hoped to have representation for this hearing. I am set to meet with counsel later this week. So I would request, since we just set a matter over for 2 weeks, to set this over, because I was prepared to have representation for this hearing today that, as I said, got rescheduled due to an unexpected illness. It's been very difficult, as I'm sure counsel and the courts are aware of, trying to get consultations with attorneys in family law matters.
I can't disagree with that. I'm sure appointments are difficult to come by. Ms. Baldwin, any objection to setting the contempt to 8/1?
Certainly do. Here's why. The contempt was originally scheduled for last week. Everyone understood that we were going to have that heard last week. That's why we put, the court will recall there was a restraining order. We put the restraining order on the same date because as the contempt filing, because that was already sitting last week before the court. And I said I didn't care what judicial officer heard it, and Ms. Gibson said I want to heard it as soon as possible. So last week we come before the court. Ms. Gibson then, despite having filed a response, basically says, well, I don't want it heard, makes no mention of finding counsel, kicks it over to this week at her request for continuance. Here we are yet again. Again, she's filed her response. Nothing has really changed. Counsel may come in or may not come in. We don't know. But the reality is we're in a position where we've already had, this is the second hearing where we've come before the court on the contempt. Everything's filed. I think it's appropriate that my client receive relief. The children at this point are suffering very real consequences, and the idea that we put it out is not reasonable. My client, because of how we time these things, my client's already waited a month to have this heard. The idea that it takes 6 weeks to get a pretty straightforward contempt heard isn't reasonable. So we ask that we go forward today.
All right, I do see, so Ms. Gibson, you did respond. And the last hearing I was at, I do note Ms. Baldwin's correct that there was a request for this to be heard as quickly as possible. So that was set on to the 11th, and then it was continued to today, the 18th. So given that this was filed, looks like the 12th of the 9th of June, and we're at the 18th of July, and this is the third date that we've had since this has been filed. We'll handle this today. All right, so Ms. Baldwin, go ahead.
Thank you. This is a very clear-cut matter of contempt. This is for failure to pay daycare fees as apportioned by the order of child support. That is a child support obligation. When the court looks back at the record, you'll find that the court largely adopted Ms. Gibson's proposed statements about her income level and her proposed proportional share of the children's expenses. At that time, and throughout the case, essentially until this contempt was filed, Ms. Gibson repeatedly told the court that she could afford to pay all of her obligations so that she could avoid having the house ordered to be sold. Again, and it wasn't just that she could meet all of her obligations, she could meet those obligations and refinance the house in order to be able to avoid it being sold. So she said that she could refinance and increase what she was paying. This is what she told the court she was able to do. Now she comes before the court and says, oh, I can't pay it all. Let me make $50 a month payments, even though the obligation is somewhere in the hundreds and hundreds of dollars. Let me just pay $50 and not pay anything more. So which is it? You can't have it both ways in essentially a 6-month period of time. Either you can make all your obligations or you can't. And the reality is that Miss Gibson will tell you whatever she thinks is going to get her what she wants on that day. I think it is notable that Miss Gibson previously had a second job. She quit that job. That's a job that is not considered in her current income as set for the purposes of child support. So the court did not assess her to have that, but she did have that historically. Again, it's undisputed. There's a court order for her to pay, that my client timely sent her the billings, and that she, for the vast majority of it, has not paid. Her claims that there are, I've made $50 good faith payments, that is not good faith. That is a, please don't send me to jail, but it is absolutely, I'll pay what I want. So I'll just keep paying $50 so that you don't throw me in jail. She's not providing her bank statements. She's not saying, here's all the expenses I've cut out. Gee, I've cut my cable, my phone down to the bare minimum. I've cut this expense and that. There's none of that. It's sort of just, gee, I can't pay. I'm just going to throw my hands up and to say that that's an excuse. Again, notable from she only started making these payments, I believe in March or April. Children have been in daycare since January. And again, she's just making essentially a $50 payment toward what amounts to a $1,000 bill. That is not good faith. When you look at her income, again, just blatant dishonesty with the court. She'll tell you what you want to hear the day you want to hear it to get her way. You look at back in December of 2022, she claimed, and we put it right in the reply, that her net income was $3,189. This is her statement. We are now 7-8 months down the road. If anything, she's gotten a raise, but now she claims that her net income is $700 less a month. Well, that $700, there's just no evidence that supports a reduction of $700 a month in her income. No basis for that reduction. And if she had been applying that $700 a month toward the children's daycare expenses, we wouldn't be in this position. That would be good faith to say, oh, this is every bit of extra I have. So again, even within the course of 6 months, she's just talking out of both sides of her mouth. These claims that, oh, gee, I self-helped for offsets, those are really throwaway arguments. First, latches in the sense it was never raised until my client said, hey, you owe this child support obligation. Never once raised in the more than year she says that obligation existed until my client asked for payment. So if it was a real obligation, she should have been asking for it from the minute the order was made. 2, if you're using basic law school contract principles, the order is construed against the drafter as to any ambiguity. This was drafted by her counsel at that time. And 2, you can't, and 3, you can't self-help. This idea that, oh, well, I'll just offset these things is not appropriate. We do have 2 prior contempts in this case, one regarding finances, one regarding the parenting plan. This would be the 3rd. There are very real consequences to the children of this action. The children have now been removed from daycare due to non-payment. That is a very real negative consequence that the children of this action now have to deal with, and that my client has to deal with, because he can't afford to manage everything on his own financially. The child support is a right of the children. And Mrs. is just saying, I'll do what I want. I'll pay what I want. Sort of shrugging her shoulders at the consequences. And that is not appropriate. This is somewhat a disaster at this point because it takes so long to have these matters heard. It's really a disaster of Ms. Gibson's make. She's done something that has financially harmed everyone and is actively harming the children. Daycare spaces can be precious, and getting them back is a question mark on whether or not, even if she pays now, there may be now a waiting list where my client has to choose more expensive options because that's all that there is. Given this, the order only calculates arrears through June. That's fine. Arrears through June for the daycare obligation is $4,490, $318 of interest. I am asking for a substantial amount of fees of $3,500. That considers the set over from last week. That considers today, all the efforts to get her to pay. But it also considers the fact that when we dealt with the motions, the court had reserved previously sort of fees on the motions regarding the house. And again, when you're being blatantly dishonest before the court and saying, I can meet all my obligations and afford a refi increase, but that delayed the sale of the house, which would have provided funds for my client and would have freed up money because Mrs. could choose cheaper housing. She's really, again, created a financial disaster for these parties by being dishonest with the court about her finances. I'm asking for a civil sanction of $1,000. Again, when you have somebody just blatantly lying to you in a pleading where I can put captures of look at this and look at this, and these are the dates that she did it, and told the court one thing and then told the court something that's significantly different, that's sanctionable. It just is. And finally, cost of $750, or I'm sorry, cost of $75. Finally, because the court has ordered the home to be sold, what I am asking the court to do is authorize that my client will be made whole any judgments that have been entered to date in his favor against Mrs. That will allow him to catch up all the daycare payments. And those would be then establishes against her community portion whenever that is later decided. I think that is relief that's necessary and appropriate. Again, my client needs these children to be in daycare. He needs to work. He works full time to support the children. So we need to be in a position where we're making appropriate use of those proceeds if and when they become available. So again, really a problem of Ms. Gibson's making, and frankly, the old adage, what a tangled web we weave, that is the position she is in. And so at some point we have to deal with that. And I think that's today.
All right. Thank you very much. Ms. Gibson, your response?
Thank you, Your Honor. We're here today for something that I feel shouldn't even necessarily be in front of the court today. Ms. Baldwin is correct that I've been making weekly payments to petitioner. If you look at my financial declaration, that extra $700 is for child support that is coming out of my check now, since petitioner has had the children. And at this point, I thought that things would have been different with all of the extra things going on with the children. I thought that I would be able to refinance the house and do those things under the assumption that what I was, told by the courts, this step needs to happen, this step needs to happen, this step needs to happen for the kids, that I would get the children back and potentially be getting child support payments again. And that's clearly not happening at this stage. So as I showed in my financial declaration, I'm making payments to him in good faith because I'm already in the negative for all of my bills. I'm having to pay all the house payments. I have greatly reduced all of my bills as much as I can. I need a phone bill. That is the smallest phone bill that I could get. I cut all of my cable. I just have basic internet. I don't spend excess money on groceries. I don't spend money on myself. I can't afford to make these full payments at this point to petitioner and also keep a roof over my head or make my car payment so I can go to work. So I'm not quite sure what Ms. Baldwin or the court expects me to do. I can't do all of it. And then to talk to the point of Ms. Baldwin's point that I started making $50 payments to petitioner back in March. That was after months of trying to get this offset for petitioner still not paying his court-ordered obligation on the house, which is his half of the homeowner's insurance and his half of the property taxes. It's been addressed in multiple pleadings, so I didn't touch base on it too much in this response declaration. But back in November of 2021, Judge Scudder approved that initial separation of expenses. Then in March of 22, Ms. Baldwin and my attorney at the time, Ms. Winkles, had a whole hearing about it in front of Judge Scudder, who ruled that he wasn't changing any of those obligations. And payments still weren't made. It was advised to me when I had counsel that I could just, since I was able to afford.
Is way beyond the declarations and citing lots of hearsay. I've kind of let it go for a while, but at some point she needs to hold herself to her declaration.
All right. So yeah, let's refocus onto this contempt. Ms. Gibson, I know in your responsive declaration, you alluded to a contempt you were filing. I don't know that you did file that contempt, so that's a little bit beyond what we're dealing with today.
Okay, Your Honor. Yeah, I'm having difficulty trying to figure that out since I don't have counsel. I guess what I would say is I've been making these good faith payments, even though I don't have the money to make those payments. Petitioner lives at home with his parents. To my knowledge, he doesn't pay rent. He doesn't pay the mortgage. He works full time. He makes twice what I make. His mom is retired and stays at home and watches the children. Even before he established them in daycare, which is a daycare that he put them in that I wasn't notified about until months later. In our parenting plan, we still have joint decision making, and I'm not being made aware of where my children are seeing doctors, where they're going to daycare, any of this. So I would just ask the court not to find me in contempt. I'm doing the best that I can with the money that I have, because at this point, it's either I pay the mortgage or I pay childcare. And I don't know what counsel or the court want me to do. As you can see in my financial declaration, there just isn't, I don't have the funds to pay that full obligation. I'm doing what I can. I've tried to get the other outstanding issue resolved, which the court has acknowledged at least twice, that petitioner is still not paying, which is now leading me to have to try and file a contempt motion for something that the court's verbally ruled on, which to me just seems like a waste of the court's time, but he's not meeting obligations on his end either. I'm doing the best that I can with the money that I can provide without making myself destitute and making myself not be able to make all of these other payments that I need to make each month in order to survive. So I'm just doing the best that I can, and I hope that the court can see that. And I want to provide for my children. I'm just doing the best that I can right now.
Right. Thank you, Ms. Gibson. Ms. Baldwin, anything else?
Just briefly, paternal grandparents have been gracious in their efforts, but they are not obligated to be full-time daycare providers for free for Ms. Gibson because she doesn't want to pay. They attempt to sort of muddy the water of, gee, all these terrible things have happened. A, we dispute those, and B, they're not relevant to today. But the reality is we have somebody who isn't providing you with bank statements, isn't providing you in advance of sort of hearing my argument of the things that she's cut out of spending. And again, we have a court order on what her obligations are, and she's getting the bills and just shrugging her shoulders. It's not appropriate. These children are facing a real consequence, or at this point have faced that consequence, are in the middle of that consequence for her non-payment. Payment should be made. We're asking for the arrears and these fees and sanctions as I've ordered. And then finally for the judgments to be apportioned out of Ms. Gibson's any award that she has, but paid immediately from the sale proceeds of the house, so that hopefully the children can return to daycare shortly.
All right, thank you. So I'm looking at the temporary order of child support that was entered in December of 2022 by Judge Scudder. And it does appear that Judge Scudder deviated downwards from the state, essentially the calculation, the standard calculation for child support. Not only just in the standard calculation, but then took off another $250. I'm assuming there's a reason for that, but there's a transfer of $552 a month for child support. And then a 60-40 allocation for uninsured medical costs, work-related daycare, preschool, and the like. So 60 to Mr., 40 to Mrs. It's that order is cut and dry. I understand Ms. Gibson has concerns with the previous order of the court and the mortgage, the home insurance and it's escaping me now, but I understand her issue and the concerns with that. That's not before the court today. I also very much sympathize with Ms. Gibson's position. If everything, assuming everything she is saying is accurate, that it is a difficult situation to be in when you feel you don't have the finances to cover one versus the other. So frankly, I think it was appropriate to make the decision to sell the home because I don't know how Ms. Gibson, given the situation she's claiming to be in monetarily, how that would have ever worked. And two, this is a pretty straightforward child support order. And it appears as though while there's attempts, there's also a failure to be able to provide those. And unlike a lot of cases, it does appear that this has already negatively impacted the children in this case with their removal from any daycare programs because there's just no money to pay for that. And the lack of payment from the respondent. I'm not unsympathetic. I do think based on, again, the historical posture of this case, I am going to make a finding of contempt. I will, and I don't have, did you present an order on the contempt?
I did. Let me see if I can see when it was filed. Filed July 11th. If you don't have a hard copy there, we can deal with presentation if you'd like when we come back in 2 weeks.
Okay. I don't have that. I am not, and what I'm the back costs, the interest, standard costs. So the $46.90, the $319 interest, $70 in costs, I'll adopt all of that. At the civil sanction, I'm going to reduce to $500, and the fees I'm going to reduce to $1,500. All of that, I don't expect Ms. Gibson to be able to pay that money. I want her to stay as up to date with the support order that sounds like it's being garnished, and make as many payments as possible. But ideally, if the house can get sold, I think it's appropriate for those to be just subtracted from her side of any award for the return on the house. So we'll set presentation to the 1st. And then I don't know if Miss Gibson is planning on filing a contempt if she gets or how quickly that turnaround time can be. I think we all know based on some of her declarations what she intends to file the contempt based on. But with her meeting with counsel later this week, we may not be able to address that. And obviously the court, what I don't want is a lot of transfer payments back and forth. So we'll can look at any offsets if and when there's a potential new contempt filed by either side and the ruling of the court. So we'll enter that order. And I don't see it. I had 2 orders in my stack related to Gibson. One was the house sale and one was the May 30th order. So we will do presentation on the 1st along with the other reviewing the other order.
So only request is at this point, because the children have exited daycare, it is a set sum that she owes. We'd ask that we just be able to update that full amount of what she owes through the day the children exited care.
That's appropriate. So if those numbers are different on the 1st, we'll enter the final number on that date.
Very good. And I believe we've already filed a copy of the daycare billing. I'll just make sure that whatever billing is in the record goes through the date that they were last in care.
All right, perfect. All right, thank you. Good luck. We'll see you on the 1st. Men and men.
Presentation. And Ms. Gilmore has joined the case, and I welcome her.
Well,
Thank you.
welcome, Ms. Gilmore. I believe. So were the objections that I received from you? My Odyssey, of course, is frozen right now.
They would be from Ms. Gilmore.
And they're filed on July 28th. They're very small,
Okay.
so I probably could just go through them quickly with court.
And that's fair. If the court can't find them, I'm fine that Ms. Gilmore just does it orally. That's fine. I did receive them.
Okay, sorry, hold on one second. Apologize, Ms. Gilmore. Hopefully, seems at least Odyssey is working now, so I should be able to pull up what.
Perfect.
Okay, so I have, my notes here are objections to the costs that were outlined and language in section B1.
Yes, and the first
Or
objection, sorry, I'll just
go ahead.
defer to court. The court made a specific ruling in the minutes. Obviously, I wasn't present for the hearing, but made a specific figure reference for the back due, I believe, expenses for the children. It seems like Ms. Baldwin has updated that figure with the current amount owing, and she's filed some sealed financials. So I would just defer to the court if you want to reflect the current amount owing or the amount pursuant to the ruling in the minutes.
And I'd ask that you use the amount that's listed. We specifically referenced for the court that we would, because the children, if the court would recall, were dismissed from childcare because of the lack of payment. And I specifically told the court, because there was a set sum, that we would get those records, present them, and then update the total amount owed. I don't think the amount owed is in dispute. So I'd ask that we use the amount owed as of the date the children were dismissed from care.
And I have a note here that the final number would be updated for today's presentation. So
Okay, that's
the
fine.
only thing that I am going to say is, and this could be a Scrivener's error, in the clerk's notes, it said $70, 70 in costs, and in the proposed it's 75. I don't know. I mean, $5 is $5, but I don't know. That's the only discrepancy I saw there.
I think 75 is the correct number, but the court's discretion, I'm not going to quibble over $5.
Okay. All right. And then section 3B1.
And so again, I'm just relying on the minutes as I wasn't present, but I didn't see anywhere in the minutes that the court reflected the language contained within that section. Particularly just kind of a bad faith finding with specifics on that relating to my client repeatedly arguing and refusing to pay. So, I mean, absent a specific finding to that effect, I think that the language should be stricken.
And she's looking at about lines 12 and 13.
Mhm.
I think this is reflective of what happened in the history. There was multiple attempts to obtain payment, months long of non-payment. I think it just reflects what actually happened.
And just a review of my client's materials and response, there was some dispute on how that payment would be made, if it was going to apply to back support owed by husband. And so after that back and forth, my client made good faith efforts to pay directly. So we're just asking the court to strike that finding as the court didn't make it specifically.
I'm going to strike the last sentence of that. I think it's accurate that she was notified of her expenses. I don't, I understand Ms. Gilmore's argument, so I'm just gonna, the argument refusing to pay portion, I'm just striking. Any other objections then?
No, Your Honor.
And then
All
did the court leave 75 or did you change it to 70?
I left it.
Okay, very good.
And then, Ms. Gilmore, is it okay if I indicate approved via Zoom?
Yes, I did hear Your Honor mention the fact that Ms. Baldwin wasn't present, but I didn't hear you mention that the hearing for next week is full and closed. We were hoping to set over the review of the home sale for next week. We're already before the court on review of the GAL status investigation. So I would ask the court consider putting us on.
Well, before we move on, we do have another presentation. So there is also
that's
the
right.
order of May 30th. And I didn't see any objections filed as to that. That was before the court previously for presentation. The court sent it over to give the respondent time to file objections. That time's come and gone. At this point, we'd ask the court sign that order.
And I do apologize, I'm catching up and there's about 1,000 pleadings in this case. I would ask if we are sending that over to the 8th, if you just let me have a review of that order. I didn't understand that we were on for subsequent presentation of any order outside of the contempt.
I have no objection sending over with terms because this was expressly on and Ms. Gibson was expressly told it was on. Not Ms. Gilmore's failing here, but my client's paying for me to be here. I would just ask for terms of $500. I think that's reasonable. It's a pretty straightforward order. That's just kind of a cleanup order in this matter.
All right.
Sorry.
Here's what I'm going to do. I'm going to set this order over to the 8th at 1 p.m. The other order I'm entering with that change that we discussed. I am extremely glad Ms. Gibson has an attorney on board now, and I'm hopeful that will help the process move along. I am sure that there was a great number of details and information that was passed back and forth. I'm willing to set this over to the 8th, and hopefully, Ms. Wade, this won't be an issue to add this since the Gibson matter is already on next week. So we'll just have it on for a review of this order on hearing for May 30th. And then whatever else it's already on for. So
And I'll present signature if I think it's consistent with the court's ruling, obviously.
And we just want to make sure that the court reviews, if the court's setting it over to next week, we're also going to review the home sale. That was set to be reviewed today. I think we're trending towards it being something that's resolving. And we won't need the court's help on that, but I want to leave it on as a sort of a benchmark for us to make sure that it gets resolved.
Okay, so we'll add the order on hearing for May 30th / home sale to the review for next week, the 8th.
Very good. The Gibson matter is short.
All right, that's 21-300-38308.
That's correct. So there's two issues. One is a presentation of an order from May. Ms. Gilmore did file just a single objection that should be in your file. The second issue that it's on the docket for today, I don't believe is accurately on for today, and that's review of the GAL order. It's or GAL report. It's my understanding that the court previously set that over to review on August 29th. Ms. Gilmore wasn't involved when that happened. She said, sort of find me the document and I'll agree. I just haven't had time to do that. We do have the GAL with us today, and she can confirm if she recollects. The court had set, the reason why is that the court had set the restraining order review to the 29th as well. The child's doing 8 specialty sessions with a counselor that specializes in abuse of young children. And so the idea was that the guardian ad litem would have time to review those records and then issue a report. So that was my understanding on that issue.
And so do you want to hear from me? Sorry.
Yes, go ahead. Sorry.
Sorry, I kind of jumped in. My understanding is the opposite. And I can kind of give the court some timeline or the timeline to refresh. So the immediate restraining order was entered in on June 2nd, based on a disclosure from June. And the court entered the restraining order with the understanding the child or the children would be interviewed by CJAC. That interview was completed on June 23rd. We were then before the court in another June hearing, I believe it was June 27th, where father made a second allegation of a disclosure by the child. The child, as we provided under seal, was subsequently interviewed for a second time on July 25th, we filed those records showing that the child made no disclosures from the second allegation. So at this point, my client hasn't had any visitation since May. We're on procedurally before an immediate restraining order. And as the court's very aware, an immediate restraining order is supposed to be immediate. So we're supposed to be before the court within 14 days if the court finds good cause. But I'm concerned that we just simply, my client's not having visitation. She historically was the primary parent. I know that, again, I wasn't part of some of this argument, but my client has the right to at least progress forward with at least supervised visitation at this point. We are frustrated by the fact that the court reappointed Ms. Ravina in May. My client's had zero communication with the guardian ad litem as we filed under pursuant to the court, and we just don't want to kick the can anymore. These children have the right to have a relationship with their mother. My client has a right to parent these children. And so I'm concerned that we just continue this on until the 29th. And we're just having another set over because Ms. Ravina hasn't investigated the case at this point because she's had no communication with us. So I asked the court to review it. I asked the court to reestablish visitation pursuant to the parenting plan entered in December. I think that all of the CJAC issues have been resolved. And so I think that we need to progress forward. And I think that we can talk about the order, but I think that the order itself that's proposed indicates that the review is supposed to be set today. So I'm confused. I don't see anywhere where there's an indication that this matter needs to be set over. So I do think that we need to move forward. I don't want to be entering into September where we're having another set over on a GAL review.
And so briefly, that's just incorrect. If you look at the court's order of July 11th of 2023, the court specifically set the review of the restraining order to the 29th of August. The court can review that court hearing where we discussed the fact that the child was in specialty counseling that was specifically, the specialty is children, young children who've been in abuse situations, and that was the information the guardian ad litem wanted to review. And I believe we also even discussed the timelines of when that counseling was happening, when it should be completed, and that's where we set the review to the 29th. So it's not really fair to say, well, GAL hasn't investigated the counseling records that are being created right now. She can't review things that don't exist. I would absolutely object to the idea that we're going to do something that's not before the court at all today, which is to change the restraining order, which isn't set for 3 more weeks. That's just not appropriate and not at all what we're here for. We're here for a presentation. At most, we're here to review a GAL report. And again, not fair to the GAL to say, where's your report when we already said we were going to look at it after she's had access to those records.
So as to the restraining order, I do see in July 11th, Commissioner Carmi was on the docket. She made a good cause finding to extend the restraining order through 8/29/23 at 1 p.m., finding specifically that the child needed some level of protection given the CJAC interview and the counseling that was I don't know if it was ordered or requested, but between the CJAC and the counseling. So there was a good cause finding to extend the restraining order through 8/29. I have us on today for entry of the May 30 order and a GAL review. So based on and not hearing that case and just reviewing the notes from Commissioner Carmi and the minutes, it appears as though she addressed the extension of that restraining order and made a good cause finding based on the minutes and notes that I have here. So that'll stay for the 29th. I just note the concern. I understand the concern, Ms. Gilmore. And the objection, going back to the hearing order on May 30th, the objection was to page 2, line or paragraph 2, first line. Is that correct about the AT&T records?
Yes.
Yeah, just as to sort of the court's finding on that they were very different than what Mrs. had submitted versus what the subpoena provided.
So I'm going to leave it, but I'm going to strike through significant so that there were discrepancies basically. And I will sign that order. And then I did see, Ms. Gilmore, the filing from the correspondence attempted with Ms. Gravina. I don't know if she's present today. I don't know what's happening there. Clearly the court doesn't have any reports. I don't know if the council has received anything.
I received no communication back in response. I can update the court that she did call my client, I believe, yesterday. I tried to call back, but then I was in a consult. I just think at this point it's a little too late. And so my client's trying to progress this forward to have a successful hearing on the 29th to move forward with visitation. And we're not having participation by the guardian ad litem. So,
And she is present, the guardian ad litem is present.
Can you hear me, Your Honor?
I can.
This is Tanea Gravina, guardian ad litem. I did receive, or I was appointed to further gather the information from CJAC, from CPS, and from the counseling. The sessions were, from my recollection, to go to the 18th, not the 8th. I was surprised to see that we were on the docket for this today as well. My understanding was that we were reviewing this at the end of the month. I did call Miss Gibson over the weekend, and really the only response, once I was reappointed, I had sent an email to all the parties saying these are the costs and requirements to move forward. I received a pretty short, please let me know what you need, but had outlined everything I needed to proceed forward. I have not received any payment. I have received a please update me again email from mother. I did call her. I have reached out to father. I received text message communication back from him, but no call back from him. But again, no payment since the initial part of this case, and have put forward 3 reports. It is not as if I have just blown off and not continued investigating. This has been a very intense matter that has gone on extensively and has impacted other cases, which I had to catch up on in the meantime as well. And so, as my understanding was that I was to gather additional information regarding the sessions and the findings with the children, that is what I am still working on. I have just not received that information back from CPS nor from the therapist yet.
All right, Ms. Baldwin, Ms. Gilmore, any concerns with your clients being able to make payments to Ms. Gravina by the end of the week?
No, I'm dictating to my staff right now that happened right now. And the materials, my understanding is the child met with the specialty counselor. Essentially, I think she began the end of June, beginning of July with 8 sessions. So that timeline fits with the guardian ad litems. I know it can just take time to get documents from them. But again, we'll work with Ms. Gravina to try to facilitate her getting access to the documentation as soon as possible to help her finish her report.
Yeah, and I'm just, sorry.
No, go ahead. I was just going to ask Ms. Gilmore your position.
I was just reviewing the email correspondence. My client is, as indicated with the need communications, more than willing. She was just asking a way to set up a payment plan. Based on that request for a payment plan, I don't know if she can pay in full, but she's more than willing to pay some sort of amount to ensure this moving forward. And I do request, if this was an issue and Ms. Baldwin had indicated potentially an objection, but I have requested the GAL file both through my client and through myself. And I think that the order itself, as well as the GAL rules, require her to supply that file to me. I'm not trying to cause any further delay, but my client has a right to those materials. So if you can provide direction on if that is actually required by the court.
And my understanding is that they're required to do that after the report is complete, because otherwise what you get into is these he said, she said, he said, she said, with both sides then demanding the file constantly. And so that it's available once her report is complete, and that they have to pay for her time to get it. So, and not that can be excessive, but the copying costs and those types of things. And so that's my understanding of the court's rule, but again, the court can rule as it likes on that.
So, and I guess if I can pick your brains, does the entire case being complete, or in this case we have Ms. Gravina indicating three separate reports already filed? Could one ask for the records on all the stuff that's already been completed, or do you think the entire file, that it's once everything is done?
I think it's once
It-
she's essentially completed her investigation. What's been hard is she's issued like a interim report. And then the court's kind of said, well, now go and investigate X and Y. I think you're asking her to do a lot of work to then separate out what came before and what came after, kind of a thing.
I think that, frankly, I've never been aware that anything needs to be finalized. I don't think that the order states that whatsoever. It says that basically we're open to request the file. I don't think there's anywhere that says that the case must be complete. And frankly, since we have open litigation and we're concerned about she's filing declarations, basically supporting concerns. And so my client has a right to respond and be provided notice of the materials that she's basing this on. And so I think that, and I'm concerned by the fact that she's either refusing to or ignoring the request, which makes me even more concerned and want that even further. So I do think that my client has a right to those materials and should be provided them timely.
All right.
And
Well,
Your Honor, I'm sorry.
I have some concerns that, and I know the GALs have heard this from me before. If payment is an issue, it needs to be brought before the court, not at the last minute. This is inappropriate to delay for payment. There was an attempt to contact for payment. Sounds like Ms. Gibson said, how can I set up payment plan? I read the emails. There was zero response, and that was in end of May, beginning of June. And here we are 2 months later, excuse me. And nobody's paid me. And we've been in court. I don't even know, probably half a dozen times in that 2 months. So I'm a little frustrated by that. Payments, it sounds like, will be made by the end of the week. Ms. Gravina, do you think that you can have a report for the 29th of this month?
My understanding is that counseling is complete, I believe, on the 18th. So long as I get documents pretty immediately after that, that was my intention. My understanding was that my scope was pretty limited for this additional appointment. I did just briefly meet with Tina before she leaves on vacation to ask her about the specifics about providing my file and things like that. And she said that that is not done until the case is all over with. So I did seek advice of Tina for that, just to find out where that was at, because I have completed reports already in this matter. She indicated I should wait. But as far as receiving the records, as soon as I get those, I can kind of, compile that limited amount that I'm looking for and provide that to the court to the best of my ability. I imagine it will be within a week or so as soon as I get that.
All right, well, let's shoot for the 29th. And then I'm going to authorize Ms. Gravina to release her entire report as soon as this last report is completed. So that won't be, hopefully, an unnecessary delay. We understand it may not be the 29th of August, but my hope would be that it would be very soon thereafter. That would provide Ms. Gibson an opportunity to respond and move forward from there. So we'll set the GAL review over to the 29th of August in the hopes that we have some information there, and then review the restraining order on the 29th as well.
Thank you.
And I've signed that other May 30th order.
Very good.
All right, thank you.
The mother of this matter, I represent the father, Cameron Gibson. We're on regarding the guardian ad litem report, as well as reviewing the restraining order in this case. Guardian ad litem did submit a report. It is, earlier.
Mr. Gibson is joining, as is Ms. Gravina. So looks like Ms. Gravina just came in. Mr. Gibson, it still just says joining. He's been in the waiting room joining for a little bit of time. So I don't know.
I'll have my staff reach out to him and just have him watch via YouTube. So I'm glad we were able to get the GAL back. She was here earlier. We did receive the GAL report. The report is compliant with the court's request. I'll note, I think this was either the third or fourth report Ms. Gravina has written on this case. And so the court was kind of giving her parameters of what it was looking for in that report. And I think that report answers the questions the court had when they assigned her this latest report.
Okay, I don't mean to interject. You received a report?
She emailed it to us as well as the bench. Hold on. It was earlier today.
I have it coming in at 12:32 p.m.
She emailed it to your group, Megan, to Megan's group.
I didn't receive anything, so I don't know if there's a typo there, but no, I have not received anything.
hold on, give me a moment and I'll see if I can forward that to you real quick.
Can you hear me? It looks like I was able to get back in.
Yes, we can.
This is Tanea, the GIL. Thank you. I was kicked off and attempted to log back on, but was in the lobby for a bit.
Yes, we can hear you. And then Ms. Gilmore, I just forwarded that email on to you. So hopefully you'll receive that momentarily. And I recognize both parties are just receiving this so that they, clients have not had a lot of time to review and digest it. But in my quick review of it, it's looking at what the court had asked the guardian ad litem to do in this most recent report set and sort of the questions that the court had, kind of given the evidence that we were looking at in November, December of last year, and then waiting for the subpoenaed information, getting that, and then sort of having some of the most recent issues this summer unfold. The guardian ad litem's kind of, to her credit, been kind of pushed out several times because the court's like, oh, but now I need a little bit more information, or we were waiting for things to come in. So in looking at,
sorry, let me just voice my objection. So at this point, I have to voice an objection. I asked the court not to consider the report at this point. I literally haven't received it in my email yet. I'll close out my outbox and do it again, but I haven't received anything, so I haven't even been able to skim over it or forward it to my clients.
Well, and I know that both clients didn't receive it not long ago. I think your honor's calendar is full for next week. So, I mean, it's your option, Ms. Gilmore. Do you want to push out a week?
I think I have Mariah in the courtroom. I think the 5th is the 5th available?
I believe so. Let me check the numbers.
I'm very apprehensive about setting it over. But again, this is on an immediate restraining order that was filed at the beginning of June. My client has on visitation in the meantime and receiving a GAL report at 12:30 when she hasn't had any contact with my client since we were last before the court. So I don't have it for me. I haven't reviewed it with my client. We would like to proceed. We would ask the court not to consider the report, frankly, at this point.
I don't think you can have it both ways. With respect to Ms. Gilmore, I think because the court has to make a decision in the best interest of the child, the guardian ad litem report is important for that purpose. And we knew that we were skirting sort of the edges of timeframes on when the child's sexual assault counselor was going to be able to provide information to the GAL and when the GAL is going to be able to get a report out. So we knew that those timelines that we had set were razor thin. And so that's kind of where we are. So I'm fine to go forward, but if we go forward, the court should consider the report. If we're going to set out, that's fine. Give Ms. Gilmore time to look at the report. That's fine too. But I think it's kind of all, you've got to have it both ways.
So it looks like we were here on the 8th the last time. We were here on the 1st and the 8th of this month. We did speak with Ms. Gravina at that point. She indicated she would have a report filed before the 29th. She filed it on the 29th. I don't know if there was a misspelling in the email. And frankly, I glanced at it just to ensure that it went to everyone and assumed. I didn't look at, if there was a discrepancy in the email address that it was sent to. It is only 3 pages long. Have you received it yet, Ms. Gilmore?
I literally just received it.
Okay. It's only, I think, 3 pages long, and it is almost entirely about counselor information. There's a little bit of supplemental. I guess I'm going to pause. I'm going to give Ms. Gilmore a few minutes just to read through it. And then if you want to have a breakout room with your client, I'm happy to do that. And then there is room next Tuesday on the 5th. So if we set it over, we'd only have to do it for 1 week.
If you can break me out with my client, I mainly just need to talk to her about what she wants to do.
Sure. Let me do that here.
Okay. Thank you for doing that. We're just going to proceed today. We would like it to be addressed.
Okay. Very well. And Ms. Gilmore, you had an opportunity to look through the 3 pages.
Very quickly. I don't have a meet, but I got the recommendation.
All right, very good. So again, guardian ad litem has sort of been tasked with like multiple reports at various points in this case, has complied with doing all of those, despite some of the hiccups in getting information and having to subpoena information for her that was pretty critical into understanding the realities of what was going on. So when we look at the context of the guardian ad litem report and the restraining order that currently exists, the primary concern is the child. And sort of the buck stops there, is that this isn't about what Mrs. wants and not her desires. And it really isn't about what my client wants either. It's really about what this child needs at this time. And so the goal is to make sure that we're meeting that child where they're at and not forcing things child's not quite ready for, or putting the cart before the horse. When we have to look at what we know as a verity. And so there, in many cases, there's some he said, she said, but in this case, there's a lot of verities that we know that we can rely on and evidence that really isn't disputed. So we know that Mr. Rosales is a dangerous person. We know that he has a criminal assaultive history, a domestic violence assault convictions, and I believe those were regarding strangulation and domestic violence. That's extremely concerning. We know he's a felon. We know that there are findings against him in his prior parenting plans that restrict him from any contact with his own children. And this is why the court previously prohibited all contact with him between him and the children. We also know that for approximately a year after that order was entered prohibiting all contact, that the respondent allowed Mr. Rosales contact with the children in violation of that court order. And while she did that, she was dishonest with the court, with the guardian ad litem, and with my client. And the concern here is that, while this is not direct evidence, the circumstantial evidence that's extremely strong is that the children were either taught to or forced to lie about Mr. Rosales contact them. These are fairly young children. One's just starting kindergarten this year, and the other one is 3 or 4. So these are young children who naturally are just going to kind of spout stuff out, absent some parent really putting a cap on that and prevention on that. And so there's strong circumstantial evidence that that occurred for more than a year, because this wasn't something my client knew was happening. In October, November of 2022, this was found out. There was direct evidence that Mr. Rosales has having direct contact with the children. And the court at that time then moved the children to my client's home and restricted the mother's visits. But even then, the mother continued contact with Mr. Rosales, despite the court's order that at that point was more than a year old, that he wasn't to be involved in the children's lives and was essentially a bad idea. She continued, and despite the fact children were being moved out of her home because of him, she continued that relationship with him. And what's concerning is, even as we stand here today, her declaration says, I stopped all contact with him in January of 2023. And that's from page 3 of her declaration. This is December or January of this sort of last 6 months ago. But then when you look at, if you were to peel back your file and look at the phone records that were all filed, we see phone contacts with them that continue through March of 2023. So again, there's concerns here that sort of mom's just going to say what she's going to say match up with the evidence at hand. And I'll note for the court that our phone records stop in March because that's when our subpoena was responded to. So we don't have anything past that, but that's the concern. So that even then, so children are moved to my client's home. The oldest child's put into therapy. The younger child is frankly just too young. There really aren't therapists for, at that point, a 2-3-year-old. We then fast forward a couple months, the oldest child starts making disclosures. Child ends up with a special trauma sexual assault counselor that's working with that child. We do have the letter from that specialized counselor. That counselor indicates there's, between the counselor's letter and the guardian ad litem report, no indication of coaching from father. This is not something that father wants whatsoever. This was heartbreaking for him to have this information that verifies at a minimum that Mr. Rosales had direct, very inappropriate contact with this child. Whether or not that contact rises to the level of sexual assault still is a question that remains to be seen, but still that this child was exposed to somebody and was intimately cared for by somebody who had frankly no business being around that child whatsoever. And the concern here is that this is coming out because the children finally feel safe to make these disclosures and finally have been in a situation in a home long enough where the repetition of we don't keep secrets, that's not something that we do, that's finally rang true for them. And they finally had sort of been untrained from secret keeping to telling what's happening. That takes time. So at this point, the biggest concern is the specialist says that the child needs additional time, essentially 6 to 8 more weeks of specialized counseling is appropriate for the counselor. This is pretty critical time for this young child's processing. Child's only 5 years old, again, kindergarten age. The child, again, is in the position where they're unlearning that secret keeping and being put in a position where they are clearly told, and it's repeated through repetition, that not keeping secrets, you won't get in trouble for that. And that bad things aren't going to happen to you or anybody else when you don't keep those secrets.
I just like to voice my objection. This is hearsay with no personal knowledge. There is no direct evidence that my client has ever verbalized these words to these children. So we're just making the blatant allegation without any substantiating evidence at this point. So I object for hearsay.
So I was very clear that there's circumstantial evidence that mother has required this due to the children's behavior and what's happened. And additionally, when you look at the counseling records indicate this is what the counselor is doing. And so that's what I'm talking about right now, is what the counselor is doing, which is part of the GAL's report and part of the counselor's letter. Oh, you're muted.
I'll note the objection. I understand Ms. Gilmore's concerns. I think understand what Ms. Baldwin's trying to argue, and it'll all be weighted.
Okay. Again, child's in that process with the current counselor of sort of unlearning some of those old behaviors. And again, being in a place where, as she finally provides information, there are not negative consequences attached to it. And that's something that I think children have to learn as a practical aspect. It's one thing for adults to say it, and it's another thing for a child to see it in action and say, well, if I disclose this, is the world, is the sky going to fall down? If I disclose this, is everything bad going to happen? And when the child sees that bad things aren't happening, and that it's okay to tell the truth, and it's okay to not keep secrets, then that child can be reassured that further truths can be told, and the child can be free to just say what happened in their time. But that's kind of the key, is it takes time. Again, my client's only goal is the child's best interest. My client fully recognizes that at some point there'll be some sort of reunification with mom at some point. The question really is, when is the appropriate time to do that, and then move back into the supervised visits that were happening prior to this summer. The current recommendation is that child's further counseling will go through October 20th. So we're looking at about 6-8 weeks from today with that specialist. The child does have an underlying counselor as well, but this is sort of that specialist counseling that's really focusing on the sexual assault. What we'd like to see happen is the child have the space to be in that counseling without mom's interference through that October 20th. After that, I don't want the parties to have to come back and then relitigate what do we do now. At that point, we think doing some reunification counseling would be appropriate. The reunification counselor should be located where the child is located. While Zoom is nice, I just don't think that works for young children. And these are young children. I don't think sort of zooming in is effective for young children. So the reunification counselor should be located where the children are. I think the reunification counselor should indicate how long that reunification needs to last. It might need to last a couple sessions and we're done. It might need to last a while, but I think that should be to a large degree dictated by the reunification counselor. I think these are younger children. My hope is that it's relatively short, and that at that point we would return to the prior parenting plan, with the exception of, so mom was receiving a couple hours supervised every other week. At that point, I think it should return to professionally supervised visits for a period of time, and then after those, and then remain at that level, frankly, until we get to trial. This is a case where trial is appropriate, discovery is pretty much done. It's time to move on and time to have the case resolve one way or the other. And so that sort of gives us a pathway into what's appropriate. And again, it's focused on the child and what the child's needs are right now, but also is progressive and moving forward. So again, my client does not want to eliminate mom. That has never been his goal, never his desire. He really is just, I got to put kids first and what they need first over sort of everyone else's desires. Finally, the guardian ad litem in this matter has recommended a psychological evaluation with a parental risk component. We think that should be ordered. And we have a long track record of behaviors that are, frankly, somewhat irrational. We have Mrs. just blatantly lying, and that's pretty rare. To some degree, like everybody twists the truth in their favor, but I would say it's pretty rare when somebody says, the car was black and the other person says the car was white, and here's the picture of the white car, and then the other person still says, the car was black. I mean, that is the level of odd dishonesty that we have from the respondent that really doesn't make sense. I mean, we see it even now with her statements of sort of when she ended the relationship and what she told the guardian ad litem and what the records show. None of those line up with the respondent's story. And we have her doing all this counseling and sort of, she can say all the right things and do all the, so I should say all the right things, take the right classes, check the boxes, but then immediately is in the same behavior as before. And so that's the concern, is we really have somebody who has not applied any of those lessons. She can tell you she'll tell you all the right things, but there's no indications that she can be a protective factor for the children. And that's really the key here, is that how do we allow time with the parent when that parent can't be trusted to protect the children, and will not put their needs first, and not in a, it's not even saying kind of in a selfish way, but in a way that is, in a way that borders on criminal neglect. I mean, it's that level. And so that's sort of the underlying concern that makes the psychological evaluation reasonable and valuable, because it can provide everyone with information on how we craft a path forward. And I think that's somewhat what we struggle with, is what does the ultimate path look like in this case? And I think that will give us information. Mother says, I don't have any money for that. good news, the house sold. And so in this case, we are going to have money to do that. And so what the court should do is authorize funds from the home sale, which should be completed in September, to be utilized for that purpose. So mother can get in line right now, and there's money to pay for it. And then if she's in line right now, frankly, given the court schedule, by the time we get to trial, we'll have it in hand. And so that's a reasonable solution that gets us, frankly, that plan kind of gets us through to trial. So it's reasonable, it's in the child's best interest. And so we'd ask the court to adopt it.
Thank you. Ms. Gilmore.
For the record, Megan Gilmore on behalf of the respondent and non-moving party, namely Jill Gibson. The history of this case is particularly important. I know that Your Honor wasn't before the court at the temporary orders hearing, and I think it's extremely pertinent when relating to and making the decision between the contact of my client and the children. Particularly, my client was a stay-at-home mother for the first 4 years of these children's life, while father works 12-hour shifts 5 to 6 days a week. My client's role as the primary parent of these children was acknowledged within the temporary parenting plan that was entered in November of 2021. The parties lived under that parenting plan for another roughly 12 to 13 months. During that period, father brought his first motion for immediate restraining order, which was ultimately denied in March of 2022. He then filed a subsequent motion in the fall of 2022, which ultimately resulted in the transfer of custody. I think the timeline of this case is particularly important because I think that there's some allegation that this order prohibiting contact between Mr. Rosales and the children was in place before it was. It's my understanding that the order was entered in response to the denial of the restraining order, which again was entered in March, April of 22. So the restraining order of the contact was only commenced around that time. Again, as acknowledged within the February 2023 GL report, my client, following the temporary orders hearing and transfer of custody, has done over 11 hours of classes, and again, appreciated the severity of her actions. She's repeatedly acknowledged remorse for this isolated one-time incident of violation. She explains to the court in past declarations that it was associated with some sort of something to do with the house, but frankly, it really doesn't matter. There was one violation, and there's subsequently zero evidence that there was repeat violations for over a year period. The order was again entered in March. There was alleged violation in October. My client acknowledged that a violation, subsequently sought treatment, has acknowledged it, and is doing what she needs to do to, again, for the best interest of her children. The court did enter a temporary parenting plan in December of 22 that provides my client supervised visitation. The approved supervisors, Aaron Hall and Jennifer Harrington, filed declarations on June 23rd. The supervisors attest to the strong relationship these children have with their mother and frankly, the success of visitation. The supervisors are only people with personal knowledge. So there's lots of, again, allegations as set forth within my objection that my client's doing and manipulating and speaking poorly of and hiding in secrets, but there's zero substantiating evidence in the record or personal knowledge of anyone that this has actually occurred. The child has allegedly disclosed things during father's visitation, but that doesn't mean that my client was hiding anything in the interim. The GAL filed her most recent report prior to this one that I just received about 5 minutes ago on February 7th that indicated that my client presented no risk of harm to these children and frankly recommended a 50-50 parenting plan. We're looking at what I was like 4 or 5 months ago at this point. It's also important to highlight that within that recent GAL recommendation, father indicates that his only concern relating to mother's visitation is relating to Mr. Rosales. My client testifies under penalty of perjury that she's had zero contact with him whatsoever since January of 2023. There is zero evidence confirming that she has had contact. If there's any sort of communication or evidence within the records, which I frankly didn't see, Mr. Rosales would be potentially contacting my client, but you don't see any responsive materials back, then my client has in fact been in communication. I think it's also important to note that the order prohibits the children from having contact with Mr. Rosales. The children frankly haven't had contact with Mr. Rosales since we were before the court in fall of 22. My client's visitation has been supervised. So I think there's a big confusion between having contact and violating the parenting plan, which again was one isolated incident in October with alleged video, and claiming that my client has then continued to expose the children over that 6-month, 12-month period. There's been no contact between Mr. Rosales and the children as my client has been having supervised visitation since December of 22. Conveniently, after receiving a GAL report in February that was not in father's favor, father filed the motion for immediate restraining order, alleging that the child disclosed at the end of May that Mr. Rosales had inappropriately touched her. Father motion requested that my client's visitation was suspended until a CJAC interview was completed. As filed by my client as a pro se litigant in June, and again on August 30th, the child made no disclosures to law enforcement during the CJAC interviews and the investigation was closed. At the June hearing, father alleged that the child made another disclosure in support of his request for continuance. The immediate restraining order was improperly set over by the commissioner for another almost 2 months to today's date. Since this hearing, the allegations of disclosures have been investigated. There's been no disclosure to law enforcement. And again, the investigation has been complete. But frankly, I believe that procedurally, again, Washington State is a notice pleading state. I think procedurally, father's motion is moot. The CJACT interview has been completed. There's no disclosures made. My client should reestablish visitation just based civil procedure alone. At this point, I'm having a very hard time connecting a nexus between the alleged abuse of Mr. Rosales with denying my client visitation. There's simply no evidence that my client has had any contact with Mr. Rosales whatsoever for almost 9 months at this point. There's zero extrinsic evidence whatsoever outside of father's self-serving statements that my client has ever manipulated the children or forced them to lie. What you see is declarations from people with personal knowledge that were agreed supervisors that this visitation was going great. You don't even have an allegation visitation was going poorly prior to father throwing a bomb in the water and making the ultimate allegation that's almost impossible to prove that a very minor child was hurt or injured by a significant other. As set forth within the correspondence of Richard Dillman, my client has been seeking regular mental health counseling since 2021. We filed that under seal on June 23rd. And so again, we just don't see a connection between a safety risk of my client having visitation to the children. My client was having successful visitation for 6 months. And I seriously have very serious concerns that father is involving these children in conflict, as we have a just recently turned 5-year-old child alleging that and declaring to this provider that her mother is a liar. My client testifies to that she's been a primary parent of these kids for a long time. And this is a very small child. They can't make those sort of declarations to determinations that my mom is a liar. Fathers intentionally put my client in a situation where my client has no visitation for 3 months, while intentionally creating a new status quo, while also creating roots in a community that the children frankly have never lived in. We kind of skip over the fact that father, number one, violated the parenting plan and joint decision-making by engaging the children in services. Again, not saying that my client would refused to do that, but no discussion, no information about the provider until I got in the case. And then the fact that he's now enrolled the child in school up north when the child has lived in Cowlitz County her entire life, and we're under a joint decision-making parenting plan. I understand that there's an immediate restraining order, but that doesn't change the temporary order relating to joint decision-making. Moreover, the counselor is recommending that the child have in-person visits because this has all been happening over Zoom. So again, as Ms. Baldwin has indicated, Zoom visits don't work very well. So not only do we have that, but then the counselor has their own concerns about manipulation of father. So these visits need to happen in person. And I do suspect that if this child is having in-person counseling with this provider, that she likely wouldn't have any disclosures, just like she didn't have any disclosures to the CJAC. That being said, my client prays that this child wasn't injured in any way or inappropriately touched, and she would be the first to step in and draw the line and say, you know, this needs to be dealt with and to protect her children. The children are ultimately the only one that have been injured by this motion for immediate restraining order. They've had no contact with their primary care provider, who has been their primary care for their entire life until the last 8 months. And my client, again, is willing to do whatever necessary to, you know, be in compliance with the court's order, to have visitation with their children, and to regain at least a reasonable resolution and a reasonable schedule for these children that are in their best interest. We do think that there's been zero substantial change of circumstances since the recommendation was made by the guardian litem in February. And we think that we need to move forward. I asked the court to deny the restraining order. I asked the court to adopt the GAL recommendation that was filed in February. My client is willing to do a psychological evaluation. However, and I don't doubt the court would dispute this, but Dr. Poppelson's office is not doing one for six to 9 months. So that's really a non-starter when we're talking about visitation and we're balancing my client's constitutional right to parent her kids, ultimately with the best interest of the children in mind. My client's not a danger to her kids. She's not telling them to lie. There's no evidence of it. So we ask the court to deny the restraining order.
Thank you. Ms. Baldwin, briefly.
We do have Ms. Gravina. Do you want to speak with her first?
Sure. Ms. Gravina, any additional information or comments you want to make at this point?
Not significantly more than what I already put in the report, just simply that I didn't get any written reports or notes or updates from the counselor after the child's last appointment. I filed anyways. I did call both attorneys after my telephone interview with the provider and let them know the information as far as the provider shared it, and then put that same information in the report. But outside of that, there's largely no other information available at this time.
Right. Thank you. All right, Ms. Baldwin.
Thank you. I appreciate that Ms. Gilmore has not been in the case as long as I have. And so sometimes I think that leads to an incorrect impression of what's happened and what's gone on. I'll note that early in the case, my client indicated he was a highly involved parent, that he was, he would at that time argued he was the primary parent of these children, and the one that really was the parent who would step up and take care of their best interests. He's the parent that's fought to get them vaccinated, got them into counseling. All of those things have happened because of my client. Yes, my client enrolled him in school. This is a compulsory attendance state. So it's odd that that's an argument. The services and counseling that the children were enrolled in was something that was indicated early on in the hearings where the court changed custody. Everyone was made aware of that. That was something that was just frankly, I think, on the record, because we said we knew that was going to be hard on the kids. And so my client was like, that's something that's just going to happen, of course, happen, and there's no objections. So odd again that mom sort of tries to spin that at this point in time. When we look at, mother says, oh, I did 11 hours of classes. That is not sufficient. The idea that you were dishonest with the court for a year, and we know she was because we have all of the phone records and clear indications from the guardian ad litem. So we have evidence to that fact. Well, I'll just take 11 hours and sort of I'm cured. That is not logical. It doesn't equate to, it doesn't match with what's happening now. As far as, oh, mom's better, we really don't see that. This is a 5-year-old child that's made these disclosures. A kid calling somebody a liar is frankly exactly what a 5-year-old would say. 5-year-old's not saying, oh, so-and-so is dishonest. That a liar is a little kid word. And so it's a child sort of recognizing that for herself and feeling that frustration of one thing was said to me and now I know that thing isn't true. So those are very much in line with children's speech. When we look at the violations here, we've had contempts of mom withholding the children, playing games with trying to prevent dad from being able to pick up the children from their daycare. There's a long history of mom's intransigence in this case. And again, I don't want to go into all of the history, but she's already been held in contempt once or twice with other things that came really close. So again, long history of mom sort of being a problem. In this case, I'm sure these children, they love both parents. That is not the question here. The question is the best interest of the children and how we facilitate ensuring their protection. And that is the biggest concern here. When you look at the phone records are attached to Exhibit L of my client's declaration. I think that was filed back in May. Those phone records are probably half a ream of paper, and it is very, very small type. So we're talking like 0.8 type and just page after page after page of the contact. And the sole contacts are him and her. So that's what the subpoena was, is this phone number to that phone number. And it's page after page after page of their contact. And that's just one source. So that doesn't count social media. That doesn't count other messaging forums. That's solely the cell phone records. So again, this mom tries to act like there isn't evidence. There is a lot of evidence to the contrary, that just absolutely black and white disputes mom's statements. Child has made disclosures to the counselor. Counselor put those in the materials that we filed. The records show intimate contact between Mr. Rosales and the child, and so that is the inherent concern. That occurred on mother's time. Mother allowed that to happen, and child's clearly extremely upset about it. And either one of two things are the outcome. Either one, child could not tell mother, or two, child told mother, and mother said keep it a secret. There really aren't any other options. And so one is either child doesn't trust mother to keep them safe. And the second is that mother is intentionally interfering with the child's safety. But both things are bad. Both things put the child at risk. And that's really where we stand right now. Child needs, and again, this is not a forever situation. Child needs the space to process with the counselor, who is the professional recommendation that came from CJAC. And my client has sort of put forward a path for your honor. It's reasonable. It moves forward, and it moves forward sort of at the child's pace, because ultimately, the child is the primary concern. Ultimately, we'll obey, of course, any order your honor makes, but the primary driving concern is and always will be for my client, the child's best interest.
All right. Thank you very much. I know this is a difficult situation. This is, there's been a lot involved in this case. There's, frankly, I think by the time this gets to trial, it feels like a lot of the issues will be resolved just because of the piecemealing of this case as we've pushed through. I am, as I stated previously, I'm very glad Ms. Gibson is represented now. I think that's to her benefit, and I've reviewed everything. I feel relatively comfortable with the history of this case, and I do have some concerns. Mom says it's a one-time issue, but it wasn't a one-time issue. It was kind of a repeated issue with this individual. And to be very frank, there was concerns that the court had, and that's why the rulings that were previously made were made, that hiding this relationship ongoing regardless of what level the relationship was concerning and potentially putting the children at risk given some of the information. Okay, now we're here. We have these temporary orders. I see, and October 20th, I believe, is the date. I'm just double checking approximately that the counseling that was provided through the CJAC that was then extended by the counselor, and I believe that was Patricia Anderson, which is weird to say, but Patricia Anderson was the individual that's currently seeing the child and has treatment or counseling sessions set up with the child for the next month and a half, approximately. My understanding is that Patricia Anderson is in and around associated with Charlotte Rosen's office, Olivia Lovely. I don't know if, and so I'm throwing this out here because I'm kind of wondering if we can start things if we can try to get things started. We had a brown bag, family law brown bag a week or two ago. Charlotte Rosen, Olivia Lovely, and Patricia Anderson were there representing their practice and what they're willing to do, and specifically to discuss reunification counseling. So I'm not suggesting that Miss Anderson do that, because obviously Miss Anderson is a reputation or has a rapport now with the child. But my hope would be is, since there's some knowledge within that group of the circumstances surrounding this case, that either maybe and what they're asking the court to order is a reunification evaluation, which would be an opportunity for, in this case, it would probably be Miss Lovely or Miss Rosen, to have a quick interview with the parties at issue to determine how they can move forward. If that can happen while this other treatment is finishing up, then we can maybe be in a place where reunification counseling can start in conjunction with that other stuff finishing. Does that make sense? And I don't, and so their specific request was to say, we need a reunification evaluation. And then they're able to assess, okay, here's timeframes, here's, yes, we can help, here's no, we can't. They're doing that free of charge. So that's something they're just offering. And then obviously, as you move into whatever they offer, and since we have one of the children that's currently kind of in the same office, maybe there can be some working together. We do have to look at the best interest of the children. We also have to recognize that mom is mom. Mom's trying to repair these issues, fix these issues. I will order the psychological evaluation with parental risk component. Sounds like she's willing to do that. I understand that if it's out, let's get it started and get on the books for it. If we can.
That reminds me, Your Honor, if you could, my client spoke with Dr. Poppleton's office, and they're currently not even putting people on the wait list unless you have an order. So if you could potentially make a bench order to that effect, then I can get that started ASAP.
Yes, I can, let me see.
Ms. Gilmore, you could, if you want to like whip out a single line order.
I can do that tomorrow morning too. Yeah. Okay.
If you agree to it and you email it to me, I'll print it out and sign it and file it.
Okay.
Because I want to get, I don't want, I think the longer we wait, it is a detriment really to everyone. Because it's sort of, each party is kind of digging their own trench and wanting to stay there. And we have to realize that if things progress in a positive manner, that mom is going to have visitation, mom is going to have a relationship with these children, and mom will need to be trusted to be a care provider to these children moving forward. So that doesn't definitively answer the question of what's the temporary order look like, but what I don't necessarily want to, I don't have anything from anyone, including in the GAL report, that says mom can't have any visitation until after this is done. If that's the case, then I'd like to know it, but I don't see that in anything that I've been provided. So if we can start this other process, and maybe it takes a month and a half, and mom's, because I do think that the proposed sort of tiered, we start with reunification, then we go to the supervised visitation with the folks that have already been approved, and we just kind of progress from there, because we need to ease the kids back into the situation, regardless of how or why these kids feel. At least the youngest feels some concern or animosity towards mom based on the circumstances. Why that is, maybe we'll eventually find out. If we don't, we don't, but we need to kind of ease them back into it. So I like the progressive nature of this. But I'd like to see if we can start reunification kind of in conjunction with the finishing of the therapy that the youngest is currently in.
But in the meantime, we can do that, you said, reunification evaluation as soon as possible.
Yeah, and if they come back and say, well, let's wait for 2 more sessions. I mean, I want to defer to them, but what I don't want is to say, okay, well, we'll wait and we'll set a review for, October something, and Miss Gibson's just put on the back burner until then. So I'd let, if we can kind of start doing this all at once, that would be my preference. If Miss Anderson comes back and says, absolutely not, this is not going to be beneficial, I'm willing to reconsider, but I don't have that information. There's nothing that says we need to put mom completely on the back burner until this is done. So we don't have I know that doesn't give you, I'll enter that order, the psychosexual evaluation, that order. I'll also enter a quick order for the reunification evaluation, if you want to put those both in one. The only concern I have is it doesn't necessarily solve I don't know how to best word things moving forward. And I don't know that we have, besides next week, a review date that we can set before September 26th.
I
We
think
can
that
do a presentation on a Friday and have, if there's any additional information or concerns, but.
my thought would be, let Ms. Gilmore and I, so with that framework, I think Ms. Gilmore and I can craft something and then work with the folks doing the evaluation, reunification evaluation. Ideally, once we see their scheduling, and then can get that evaluation back. My thought is the court's goal is not to delay, but also to move cautiously. So I think I can work with Ms. Gilmore on how to word that, sort of with the framework that you've given us. And if not, we can note it back up.
Yeah, and that's my thought, is maybe, we can enter in order. I will work to get the reunification evaluation completed immediately if we can, depending on Miss Lovely or whoever's doing its calendar. I would just ask that potentially, if we do have a recommendation that's beneficial to my client, that's saying, let's move forward sooner than later, that I'm allowed to put it on before the court with limited notice without a motion, just on a review.
My understanding of the court's order is if they say reunification should proceed, that we proceed. So I don't think, I think that's what the court orders is. So I don't think we need to note it up for that.
Okay, if we're complying with whatever the recommendation is of evaluation, I think that resolves it.
Right.
Yeah, I want it to be safely done, but I would prefer that it not be delayed any further than the counselors believe is necessary.
Right.
Okay.
Okay.
So I think we can work on a form. Oh, go ahead.
No, you go ahead.
So I think Ms. Gilmore and I can work on a form of the order. If for some reason we disagree, then we could just note it up on a Friday and hash it out. But I don't think we need to set a presentation. If Ms. Gilmore, if you'll draft that single line for the psychological evaluation with parental risk, I assume you're in agreement with taking those funds out of the home proceeds to get her done. And then I'll do one with the rest and I'll ship it to you. And if that works for you, and if not, we can chat.
Sounds good. That works.
Okay. All right. Well, I appreciate your time. Thank you. Good luck. I hope that plan comes together. We'll see.
Very good.
All right.
Thank you.
Thank you. Then Gibson and Gibson 213-003-8308.
That's Randy. Good morning.
All right. I did receive Miss Gilmore's written objections, and I have the order and the objections right here. I've kind of gone through them myself, but Miss Gilmore, if you want to make a record.
Yes, Your Honor. So the first one was pretty easy. The parties agreed that the evaluation, the psychological evaluation of my client would be paid from the home proceeds. However, there was no discussion on how that would be characterized for the purposes of property division. My client, again, is willing to do whatever necessary to, get visitation, but we don't have the results of this. And so we would ask that that simply is reserved pending trial to get the results, see if they were actually necessary, and then we can determine how that would be characterized. The second issue, and I think that we do have some new information before the court, so I think that this is more deferring to the court rather than necessarily an objection, but Charlotte Rosen's office is able and willing to do the evaluation. We've been in communication with Allison Long. The problem is that what the next step looks like to get visitation and reunification going. So my understanding of the ruling is that we do the evaluation in Cowlitz County, and then we comply with whatever the recommendation is through that provider's office, either Charlotte Rosen or Allison Long or whoever it may be. And the position is supported by the fact that father is going to already be driving up north, or excuse me, down south from up north to be having counseling with the other provider, Ms. Anderson. So we think that it's important that this happen in person, that it's in Cowlitz County, and that my client can immediately engage in these services as soon as possible. And then the last question is I guess, what is the next step after kind of reunification has taken place? So just kind of language there that allows my client to bring a motion once the proper recommendations and reunification has been established to move forward from supervision.
All right, thank you. Ms. Baldwin.
Thank you. As to page 1 at point B around lines 22, 23, I think that's pretty straightforward. It should be at Ms. Gibson's cost. We are doing that with an advanced distribution of assets. So we're agreed to do that with an advanced distribution. But again, sort of even Ms. Gilmore says, well, if it turns out sort of in her favor, she shouldn't have to pay. But if it turns out poorly for her, then she should have. It's like, no, the evaluation is to her benefit. She should pay for it. So again, that's an advanced distribution of assets. Turning to sort of the second issue. So the inherent problem that we have is, and it's a little bit of a new system for everybody on these evaluations. The evaluator, and Ms. Gilmore, feel free to correct me if I'm wrong, but essentially it was like, we'll do the evaluation for reunification, but only if we're going to subsequently do the reunification counseling in and of itself. The problem for these children is they are not local. They live in the Seattle metro area. So if we then say, okay, we're pinning you to these counselors down here, there's no guarantees this is a fast process. And so potentially you're pinning children to a 5-6 hour turnaround, like 2+ hours down, do an hour counseling session, wrap up, and then 2 hours back. And the oldest child is a school-age child. How are you doing that between Monday and Friday without pulling child from a half day or more of school? And I don't think that's anything that was really contemplated over the summer. It wasn't a problem because it was the summer and school wasn't in session. But now we have a very practical problem for the child. So again, my client's on board with the evaluation, on board with counseling and reunification. The issue more is, what do we do? Where should the reunification counseling in and of itself occur? And so that's kind of the problem that we've run into. So with that, I think Ms. Gilmore and I are both sort of tossing that back to you, saying, did you intend to did you intend for that to happen up where the children live or down here? We're anticipating that the specialized counseling that's down here is ending within the next month or so. So sort of mid-October. So essentially by the time the evaluation is completed and on board, that's kind of wrapped up. There isn't a reason to come down here at that point. And then counsel's last.
Let me just interrupt you one quick, just to clarify. So the child that's counseling with Miss Anderson, that's what's going to finish up next month sometime. Okay.
Yes.
Thank
So
you.
Ms. Phillips is up north, closer to the child, and Ms. Anderson is the local counselor that's down here. And then Ms. Gilmore's last point, I think it's just, I want the court to clarify, I can file a motion, and I think that's surplusage. Ms. Gilmore's always free to file a motion if there's a change of circumstances that warrant it. So I don't think that piece is necessary.
Can I just provide a little bit more comment?
Sure.
The problem is that if it's not happening in Cowlitz County, we're ultimately, again, a roadblock that's a non-starter. And so my thought is that, and I do appreciate, we were before the court very quickly after the hearing. So my thought is that in the next week, we have the evaluation. We have then roughly 4 to 6 weeks of legitimate reunification potential in Cowlitz County. We don't have confirmation that Ms. Anderson will be for sure complete in October. So we do have the child no matter what going back and forth. And so I do really think that this could happen in the next 6 weeks. And we don't have any understanding if it truly needs to go on for months and months where we're putting this child in a situation where they're commuting back and forth. So I think that if we can, get things going sooner than later, this child's already going to Cowlitz County. And so if it does become an issue and there is reunification that needs to extend beyond the October date where the child is not, coming back, and Miss Anderson says, hey, she doesn't need to be seen by me anymore, then we can bring that before the court. I just don't think that with my client working and the child already coming to Cowlitz County, I just don't think there's going to be any sort of movement if we're kicking the can and saying that this needs to happen up north.
And just for the courts, Miss Anderson is under like a grant funded program. So she was able, the initial, I think 6 to 8 weeks was part of like this grant funded program. And then she was able to authorize an additional sort of package of sessions. But my understanding is then when that's done, that's done. It's not a continuation type of a thing. It's very much targeted towards, unfortunately, children who've been involved or sexually assaulted. So her counseling is this really narrow focus that's sort of connected to CJAC.
So one of the things that I guess I didn't wasn't made clear during that brown bag where they offered these evaluations was that, and I guess it intuitively makes sense. If we offer you this free evaluation, then you have to use us. So that I guess is fair. I do think that if the child, if we can get the evaluation, and it sounds like, is that something that can be scheduled soon or has been scheduled? Yes. Okay.
Well, she is willing to do it. I didn't see any dates, Ms. Gilmore, that she was offering though. She sort of, here's how you start the process in her emails, but I didn't see how quickly they were able to get people in.
My communication with her, she was open and willing to do the therapeutic reunification environment as soon as possible. And she indicated nothing that would cause delay beyond your client signing a release of information.
Okay. Let's just start from the beginning. So objection number 1, section B, line 1, or excuse me, page 1, line 23, 24. I'm going to leave that language as it is. The second objection, section D, page 2, lines 1 through 4. So here's where I may need some white out here. If the child, and I don't remember, I'm looking through my notes here to see, because I feel like there was a number date, at least how many weeks or a kind of a.
I want to say it's mid-October is if you're looking for the end of counseling with Ms. Anderson,
Yes.
I want to like October 20th, somewhere in there.
I agree. I don't know the exact date, but somewhere mid to late October.
Mid to late October. Okay. So I think, that's 6 weeks. If it's October 20th would be 6 weeks from today. And I think we're in a situation where this isn't reunification counseling because mom has been in prison for 5 years. There's not like it's not an extended period of time. Reunification counseling could be 4 weeks. It could be 4 months. I don't know. I'm not the expert in that. And I think obviously there's a lot of considerations that go into how long that's going to be. I would ask that the parties move forward with getting the evaluation here and seeing if that can be started here while the child is still in treatment here with Miss Anderson. If that can be coordinated, that's really what I'm looking for. If the evaluation basically says they're going to need way more time than this, or it's something different, then I think we need to revisit it. Because with a school age child involved and that much travel time, we are going to maybe need to think outside the box a little bit on how to make that work. I don't want it to delay Miss Gibson's opportunity to get that reunification started. But what I'd like to do is hope that it can happen in conjunction with her treatment, with the child's treatment with Miss Anderson. I don't know. I don't know if that means we want to kind of rewrite sections D and E, or if you want, if you have a Miss Baldwin, you look like you know how to make this work.
Yeah, so I can propose. So at D, if you just white out the second sentence entirely. Oh, except I should not this. Yeah, the second sentence, but leaving the third because I did leave how it was going to be paid. And in lieu of that second sentence, I was just going to propose that reunification counseling shall start if it can be completed in the same time frame as the child's sessions with Ms. Anderson. And then you could throw a star on the end of that and say, if not, parties to return for additional direction.
Same.
And just for Ms. Gilmore's benefit, like my client's not gonna, if it's a week over, we're not gonna throw some kind of roadblock in the way. If it's, 3 months over, that's a different story.
I understand the ruling. We're flexible.
Okay, so D now says if the evaluation indicates it's appropriate for unification to begin, then the party shall cooperate with reunification counseling, and then it says and jointly select a reunification counselor. Should I
You can just and use
the and jointly get rid of that? Okay,
Yeah,
and
that's
then I'm sorry, what was your proposed sentence? I spent too much time looking for my whiteout.
That's okay. And then reunification counseling shall start if it can be completed in the same time frame as the child's counseling with Ms. Anderson. And then tell me when you're ready for the next piece.
Okay.
And then if not, the parties shall return to court for additional direction.
All right, and then I have the last line, reunification counseling shall be paid for equally by the parties, still in there. And then the proposal for essentially there to be an F, I guess it would be, that the December 6, 2022 temporary parenting plan may be reviewed upon either party's motion. I agree with Ms. Baldwin. I feel like, yes, it can be. I don't know that we need to say that.
I just wanted, I guess, clarification that we can, once we have more information about reunification, then we will bring it before the court again.
I think more information, once we have more information, I would completely agree. Yes.
Okay.
All right. Today is September 8th. All right. I am signing this. Is it okay, Ms. Gilmore, to indicate approve via Zoom?
Yes, Your Honor. Thank you.
All right. I have signed that order. Thank you all very much. Happy Friday. Want to take Gibson and Gibson?
I didn't call the case first because but I am asking for a likely contested set over. I did provide a notice to counsel.
In the Gibson matter?
Yes, on the
Okay.
motion, their motion to modify. That
All right.
request is based on the fact that they filed a subsequent motion for clarification in front of Judge Scudder on the underlying order that they're trying to modify. So I don't know how we're going to modify an order if we need still clarification on it. So I'm supposed to be responding to that motion no later than the 10th, which is Friday. I'd be asking for the motion to be heard, I don't know, 2 weeks, to allow Judge Scudder to make a ruling on the clarification.
So the motions
And-
have, oh, go ahead, Your Honor.
I just want to clarify, is that set for Judge Scudder to just do a written decision and not okay, that's all I wanted to, go ahead, Ms. Baldwin. Thank you.
The motions have nothing to do with one another. So the motion for clarification has to do specifically with the issue of the taxes and insurance on the home that has been sold. So this is an obligation that no longer exists, doesn't have anything to do with the party's current debt load, doesn't have anything to do with the party's current incomes. The modification to child support and spousal support only has to do with the party's current incomes. So the only issue that's being clarified is really this: is there an arrearage or is there zero? But that doesn't impact anything about the motion that's before you today. So the set over, I would argue, is just strategic. It's strategic in trying to buy time on the sort of, it's just strategic trying to buy time. And I don't think that that is appropriate. My client deserves the relief he's asked for. These motions, as it is, we're on a 3-week time clock to get before the court. I think this one might have been even longer that we gave in this case. So there just isn't a reason to continue it when the clarification doesn't impact your decision whatsoever. And everyone's here today.
I don't think that's necessarily accurate, just because they're indicating that he doesn't have a spousal support obligation. And then we're asking the court to clarify if he did. So I don't know how you modify. We're arguing that he owes $250 under the current temporary order for spousal support. The request is to modify child support and spousal support, which would be impacted by the court making clarifying order on that.
That's not what the motion is, though. The motion to clarify is regarding the taxes and insurance to be paid on the family home. Has nothing to do with the spousal support obligation. So that argument is totally separate and distinct. So if you look at the motion for clarification, it's only on whether or not the court intended to include the taxes and insurance in the obligation of Mrs. to pay the mortgage, or whether the court intended to create a separate obligation. That isn't spousal support. So these are apples and oranges. These are totally different things. Counsel's conflating them together, but they are not the same thing whatsoever. And that's very clear in both motions. Her client argued in response to this motion, my client owed her spousal support, but that's not what Judge Scudder's clarifying. And we provided, frankly, all of the tracking on that $250 that's very clear to be included and addressed today. But that's not what he's addressed. That's not what Judge Scudder is addressing at all.
And I unfortunately, Ms. Gilmore, agree with Ms. Baldwin on that. I think there are two separate and distinct issues. The issue of not being compliant with, because I think the initial order by Ms. Winkles indicated that 50-50 would be the taxes and the HOA fees and that, but the mortgage would be Ms. Gibson's responsibility, and then the payment of that versus the spousal maintenance and reduction from the child support amount, which is I think what's before the court for today. So I think we can move it forward on that issue.
Okay, thank you.
So Ms. Baldwin, your motion.
Thank you very much. So this is our motion to modify child support and terminate spousal support. So the current court order was set just about a year ago when the children were transferred into my client's care in November of 2022. During that time, then the court evaluated spousal support, entered an order of child support, ordering child support to be paid to my client, and then also ordered a continuing obligation of spousal support to be paid to Mrs. But we've provided the transcript, the minutes, and the tracking that shows that the court specifically said, instead of, you pay her and she pays you, that we're just going to deduct the amount of the spousal off of his child support obligation. And you see that not only in the transcript, but you also see it in the order itself. And we've provided both. We've provided essentially a cutout of that directly in my client's declaration. And then we also referenced the clerk's paper so that you can look at it on its face. So again, it's not a separate obligation that needs to be paid. And once again, we're in a position where Ms. Gibson is misleading the court, and she's doing it intentionally, and I'd argue maliciously at this point. And this is really repeated behavior. It's wild that she makes these sort of statements when we've proven time after time when she makes these kind of statements that there's tracking, there's orders. We had a hearing that was recorded and we can provide those records to the court. So again, it just shows that it's completely false. She's lying to try to gain some sort of financial advantage. But that doesn't work when everything's been before the court. And again, we've provided all of that. So in this case, that's not, Ms. Gibson is just attempting to mislead the court, full stop. When we look at the issue of spousal support, this is only a 7-year marriage. My client has paid spousal support for 2 years. There's no basis to continue doing so now. The underlying family home was sold. So again, that sort of the most expensive obligation no longer exists. Mrs. has the ability to meet her own needs. And you see that in her statements, in her bank statements, and in her income. And most notably, we provided her bank statements, which show that she has $3,000 to $5,000 sitting in her bank account month after month after month after she's paid everything. So this is not a situation where she says, she tries to claim that, oh, I'm impoverished. I can't, I can't feed myself. I can't eat. But that's just doesn't match the cold hard facts of her bank statements that show that she's got thousands of dollars just sitting on the side that she's not using. We did apples to apples comparisons on their incomes. We used my client's wage stub from September 3rd, her wage stubs from September 10th. So again, direct comparison. I don't believe their incomes are really disputed. My client has $7,451 per month gross with a net of $5,663. Mrs. has $4,180 per month gross and a net of $3,549. We'd ask the court to adopt our child support worksheet. Now, unique in this case and in the child support worksheet is that we've included the daycare obligation. So the court will recall there was a prior contempt, which was founded by the court, where Mrs. just refused to pay daycare, or essentially when the bill is $1,000, she just says, well, I'll pay $50 and I'll just get away with that. Court says, no, that doesn't fly. You owe the whole obligation. Ordered her to essentially pay that out of the home proceeds, which has been done at this point. Kids had to be kicked out of daycare because she refused to pay. We're now in a situation where the oldest child's now in kindergarten, so that child no longer needs daycare, but the youngest child is back in daycare, which is reasonable. We've provided the tracking to show that daycare has a weekly flat rate of $272 per week. Times 52 weeks a year, that gets to $1,179. So with $1,179, there is a solution to this problem. So instead of begging Miss Gibson to please pay your bill and then holding her in contempt when she doesn't and wasting my client's money and the court's time, the child support worksheets provide a vehicle for this. There is a line item to include the daycare costs directly in the worksheet. That then proportionally results in her proportional share of that coming out in the transfer payment. So she wouldn't owe an additional payment that she has to make each month. It's just included in that, in the transfer payment in and of itself. So this solves the problem, is compliant with what your honor has to order. So the percentage of daycare costs is statutory. So in this case, instead of holding her in contempt and then trying to chase the money, we can just get the money up front and then have that not be an issue. And again, we're in a position where she continues to refuse to pay. This is not solutions, unfortunately, have not been had. And this is why we're coming to the court in part for this solution. And it's something that's contemplated by the statute, is contemplated by how the child support worksheet is set up, it's contemplated by the court orders. This should be effective September 1. Again, that's when the oldest child started kindergarten, so it's a reasonable time to start. And again, we had to file these motions quite a bit previously. I am asking for fees and sanctions in this case, and that's because Mrs. engaged in an intentional and malicious attempt to misrepresent to the court. And that's regarding her claim that my client owes her a separate obligation for $250 for the last year, instead of the fact that we can see from the transcript and we can see from the court orders how that happened, and exactly the fact that the court reduced her child support obligation by that spousal obligation. So we can see that. She was present for that court hearing. She knew what happened. She has copies of the orders. She never once made a request for this money until we said, hey, you owe. And she says, oh, well, I'm going to play this game again and say, well, you really owe me. If this was an obligation that was real, she would have raised it a year ago, not now. not only after we file our motion to modify. That her misrepresenting to the court cost my client very real money and very real costs. I then have to read this declaration that's not true. I then have to find the clerk's minutes, order the disc, get the disc, have this transcribed, and then provide that information to my client, or provide that information to the court through my client's declaration about what really happened. All that takes time. In this case, I think, making a pretty modest request, and that's $525 of attorney fees. That represents an hour of my time. I think the court should additionally assess a sanction. This is not the first time that we've had Ms. Gibson make these kind of statements to the court that are just provably false. And so in this case, we're asking for fees as well as a sanction, because we've had to do extra work in this case to essentially negate, once again, statements that she made. So with that, we'd ask that I'm not asking for any changes to the taxes and tax allocations. Those are reasonable. Those will remain as they were previously ordered. So with that, we'd ask the court to adopt our proposal, our child support worksheet, and terminate spousal support at this time. It's no longer reasonable.
A couple questions, or maybe just one. And this can go to either. I noticed that did the oldest child just start school this fall?
Yes.
Okay. So the year to date of January through September of 16,000 daycare expenses, that was for 2 children.
It was for 2 children until they got dropped out of childcare. So when we came in on the contempt, both kids were getting kicked out of daycare, and then unfortunately happened. So then there was a span of time where there was no daycare, and my client was just trying to bootstrap family care together. He's now able to get the youngest child back into that same daycare preschool. But that total represents the 2 children. And then I think a little bit of the 1 child starting in September.
So moving forward, if the average monthly cost previously was $800, let's say, it's going to be closer to $400 for just the 1 child, which would be split evenly, correct?
If you're just using general math, if you're using that as general math, yes.
Math.
Okay, then yes, the cost for 2 children in this case exceeded, I think, $2,000 per month when both children were in care.
Okay. I'm using the math that was provided in the responsive declaration, because the outline was $16,337.10 in daycare between January 10th, 2020. Oh, sorry, that's January 10th, 2022 and September 12th, 2023. So that's for like,
right.
That was, so I'm assuming that just was her portion over that year and 9 months.
Right. And there were portions where there was like a 3-month span where the kids weren't in daycare because they had been kicked out for non-payment. So you can't just
I can't use that math. Okay.
No.
All right. Too bad.
And we did provide it's the last page of the daycare billing. I think it's like Le Petit École or something like that. The very last page shows the like week cost. I think we drew a little arrow onto that. That's where we got that flat rate week cost. And then we multiplied that by 52 weeks a year.
Okay, so $272 a week.
Yes, times 52.
Be closer to 600 a parent a month ish. Okay, all right. Thank you.
Yes, that's fair.
All right, Ms. Gilmore, go ahead.
Megan Gilmore on behalf of the respondent Jill Gibson. I just asked the court to look at the underlying temporary orders that we're trying to modify. I clearly wasn't at the hearing at the time, but I'm looking to the December 22 temporary family law order. If you look to the second page of the order, section 5, Judge Scudder strikes the language indicating terminated and indicates reduced to $250. Then, if you look to the child support order, you'll reference that on page 2, section 5, they reduce father's supportive obligation by exactly $250 to reference the spouse support obligation. That is why I'm asking for the issue to be continued, not strategy, not because my client's lying or manipulating the situation, but I need an understanding from Judge Scudder because Ms. Baldwin was present for the hearing. And for my interpretation and what I filed with the notes along with my client's responsive pleadings was the court ordered $250 of spousal support and reduced his net by that amount.
It was my understanding they went off docket based on the notes and they ran new worksheets and they entered this order. So that is my understanding. That's what my client's relying on as a pro se litigant, and I'm relying as an attorney on the face of the order. Looking to, and so based on that, and I know that we're relying on Judge Scudder for the clarification on some of the other issues, but it's our belief that he owes $3,000 in spousal support as we stand before the court, beyond what we believe is a violation of the orders. And I would like to mention the fact is this campaign against my client's character is just simply not necessary. My client's not lying to the court. She's simply trying to do her best to get through this divorce process and get this case finalized. My client has attempted to resolve these issues amongst themselves, and she doesn't have the funds to continue to bring motion after motion, as husband has clearly been able to do, as it's a moving target at this point trying to respond. Again, outside of what we believe is the violation of the court's order by husband, we don't believe that there's been any substantial change of circumstances that would support a modification in this case. I frankly think that based on the review of the materials, petitioner's financial situation has in fact gotten better and my client's has gotten worse. The court found his net income pursuant to the temporary child support order was almost exactly $5,000 in December of 2022. Petitioner indicates within his own materials that his income is increased by roughly $800 to the amount of $5,881 net. Petitioner's hourly rate is also increased based on the financial information submitted by him. Petitioner fails to file an updated financial declaration, which is vital for a spousal support request modification, as the court's aware that he needs to establish there's not a need and not ability to pay. The last financial declaration we have from him was from 2021 that inflates his budget because it includes household expenses he doesn't have to pay. We believe he fails to provide a financial declaration because he frankly has limited to no expenses when he continues to live with his parents. Petitioner further inflates the worksheets by including daycare, and my client in her declaration adamantly denies that she has continued to fail to pay daycare. The judgments owed from the contempt were paid from the home proceeds, and she has been making monthly payments towards daycare. We don't believe it's appropriate to include the worksheets. At this point, father is asking for my client to pay $1,212 in child support when she has a net income of $2,700. There's simply no way that this is going to move forward in a progressive way. And not only does she have to pay basic living expenses, but we're trying to reunify in counseling where there's costs associated. So eventually my client's going to be in a situation, if the court does grant their worksheets, including daycare, that she will be not only in contempt, but not able to exercise visitation with the costs associated with reunification counseling. So we don't believe that there's been a substantial change of circumstances. We do believe that the Judge Scudder entered an order of spousal support in the amount of $250 and that he has failed to pay that. And we do ask the court to deny the motion and consider award of fees for my clients, given the fact that we don't think we need to be here. This case has been pending and we need to just move forward in the right direction.
Just clarification under section, I'm assuming 5 on the order, the child support order from December of last year. You're talking about the lined out net income of father and the lined out net income of mother, and how that relates to the section 10 notations by Judge Scudder is part of your concern?
What I'm referencing is the support of spousal support is based on the adjustment of their net incomes. So as the court's aware, often within our orders, we include spousal support to reduce the overall net of the paying party. And so not only did Judge Scudder indicate that the spousal support wasn't terminated by striking that language and indicating that he had to pay $250, but then he subsequently modified section 5 to reflect that his income went down by $250 because he was paying spousal support. And so my position, based on a very clear reading of the order and not being there and looking at the minutes, was that frankly, he was giving her a total benefit of $500. 250 reduction from child support, 250 transfer payment for spousal support. That's what I have to rely on is orders of the court.
I'm happy to address when you're ready.
Sure, go ahead.
Counsel's argument is, gee, I don't know. But you know how you can know? You can pull the tape and read the transcript. You can pull the tape and watch the video. And so it's very frustrating for somebody to essentially say, I don't want to have to read that because it's beneficial to not do so. And it's beneficial to be blind. The reality is we did pull tape. A, I was there. B, we did pull the tape. C, the court can pull the tape. Please do, because this is a case where I know I'm right. because it's very straightforward. And we specifically talked about, hey, we don't want Mrs. to pay her and her have to pay him and play this game of, payments going back and forth. Just reduce it out of what she has to pay, call it a day. Simple. That's what happened. And you can see that on the transcript. And that's why we provided it for you. And that's why it's also clear in the orders. It's clear that he says minus $250. He wasn't making a $500 obligation. He was making a $250 obligation. And again, you can look at spousal support through the course of all the orders, and it's repeatedly gone down and down and down. It's not going to go down and then go up when the children are being transferred into my client's camp. So again, you can't throw up your hands and just say you don't know and take the easiest route instead of actually pulling the materials that are available to you, which includes the transcript. So we did do that. It takes time, but it's available to everybody. So it's very straightforward. Second, again, counselors will, hey, should have provided a financial declaration. Great, so should her client. And you know what? Her client did provide one in the summer, this last summer, which showed a need of $3,210, which included her paying for daycare costs, which included the house that has now sold. So when you look at that and she has a current net of $3,549, she meets her need and exceeds it on her own. There's no basis to have spousal support when she meets and exceeds her need, as she stated in her past financial statement that was submitted on July 6th of 2023. So again, their arguments just don't hold water across the board. Every month she has money left in her bank account. The statement that she's a pauper, again, doesn't hold weight. Hey, he's living with his parents, not because he wants to. My client is financially needy. He has 2 small children and daycare costs that he's trying to manage. He doesn't have the ability to go live on his own right now because he's had to juggle with payments, daycare payments not being made. Daycare payments are unfortunately a mortgage payment. If mom's not making her share, my client can't validly go out and rent a house and hope mom pays. And that's really the position that he's been in. And those payments have been inconsistent. The argument of don't include the daycare costs in the child support worksheet because mom is making monthly payments. She's not. She's paying $50 a month. She's paying what she wants to pay and calling it a monthly payment just so she can make this argument, just so essentially she can, again, misrepresent. She's not paying what she owes. She's paying whatever she wants. She's making sure she pays something, but she's not paying what she owes. And she's not, and we know she can pay because we have her bank statements showing thousands of dollars at the end of the month, month after month, sitting in her bank account that would be available to make that payment. When a parent does that, it's reasonable to include a set flat rate daycare cost in the child support worksheet to ensure payment. This is a right of a child to have financial stability. That's the point of child support. It's a child's right. And so it should be paid. And in a case where we have repeated behavior of somebody not paying, it's appropriate to include that up front. So again, we're really on, we've checked every box here. Spousal support needs to end. It's not appropriate. She can meet her needs, is not proving that she has any need. In fact, proves the opposite. She exceeds her need. The child support, she doesn't really argue my client's income. We should use that. The daycare cost is a set cost. We're asking the court to approve the order that we've requested and to enter that order.
Okay, sorry, I was doing math. And I used to think I was good at math until I got into family law. Okay, so here's what the court sees. I see as I reviewed the minutes, I reviewed the for the December order of child support. It to me seems to be relatively clear that there was the reduction of child support that Mrs. would owe Mr. by way of the spousal support. So the child support was reduced by the spousal support amount to avoid cross payments. There's a reference to that in the minutes as well, and it seems relatively clear to the court there. I understand the concern with how the net incomes were adjusted based on that, and I clearly think there is a need for some clarification as to the order that was entered by Judge Scudder. I still think that we can move forward on this without knowing his intention on the home and insurance and taxes. I do see that daycare was 60/40. So looking at the 272 line item, that puts you at about $1,088 a month in daycare moving forward, which would be $436 obligation to Mrs. a month. That would be her 40% of that daycare expense. Adding that to even just the support amount that that Mrs. would claim based on her child support worksheets, we're at $1,191.04 a month. The proposed worksheet from Mr., including those amounts for the daycare expenses are as $1,212 a month. So we're $21 apart, approximately, if you include that. I do know that has been a recurring issue, that the daycare, it is an obligation that's there. What I am going to order today is based on the financial declarations that have been filed, along with the financial statements that have been provided. We have spousal support has been in place for I think a little over 2 years at this point. And I cannot make it with the motion before the court, I cannot make a finding that there's a continued need for spousal support. So we'll terminate that $250 a month spousal support effective. We'll make it December 1. And then I am going to adopt based on everything that's been provided. I will adopt Miss Baldwin's proposed child support worksheets and have the daycare expenses included in that. And as I stated, even if I used the respondents' child support worksheets, added in her amount of the monthly daycare expenses, were not about $21 apart. So I think that is appropriate, and we'll have that effective December 1, 2023. I am not at this point. I know there was a request for back child support. I'm going to reserve that for trial. So I'm not going to address, I believe there was a request for back child support.
I don't think so.
Okay. Well,
not at this point anyway.
All right. That can be reserved for trial. Yeah, I'm not going to address that now. So my apologies if that wasn't. I thought I made a note that was something that was being requested. So I do not have orders that I'm aware of for this case. I don't know if you want to wait to submit presentation until you hear back from Judge Scudder, so maybe both things can be addressed, or I don't know if there's a need for that since the home has been sold, but I know that Ms. Gibson is requesting essentially back payment for some funds there, and that may impact things moving forward. So
I don't think it impacts this order, because if whatever Judge Scudder orders, it's a separate order, but we have cash from the home sale, and so it's easy to resolve. So I don't think the orders really impact each other. I would just ask that we put it on in 2 weeks for presentation. But I imagine Ms. Gilmore and I won't need it. We just strike it off. But I like to have a backstop. So I'd ask that we put on for the 21st. Yeah, the 21st, just as if that works for you, Ms. Gilmore.
That should work.
Okay.
I'm not here on the 21st.
I can go the 28th. I don't think we'll need it, but just in case.
Does the 28th work, Ms. Gilmore?
That should be fine. I was trying to do the math quickly. So the court's ordering that my client pay,
$1,212, I believe, and that would include daycare expenses. So it would just be one payment for everything per month.
With a start date of next month.
I just was making clear because that I accidentally was looking at Miss Baldwin's worksheets. I was looking at line 15, and the court looks to line 17. Oh, it is $1,212. I was trying to do the math on if it's more than the certain percentage of obligation of the increase, and if the court was going to be doing a step up increase.
I don't think it would be a step increase because it's not an increase based on her income, and that's where the step increases can happen. This is just including her daycare payment, which she owes now. So it's not really a substantial increase when you were just looking at the increase in child support. So a step increase would be if somebody is making $1,000 a month and now they're making $10,000 a month and you're making a huge change. But that has to do with the base amount, not the included daycare amount.
Next meaning is if it's more than a 30% increase, regardless of the reason that they would. But I'll defer to the court. I was just asking for a ruling so we could enter agreed orders.
Step increase is also discretionary.
I think that, so I am making the finding, just so we're very clear. Hold on. I'm trying to get to the document that provided. So initially, support was set at $802 a month, but it was reduced by $250 for the spousal maintenance for a transfer of $552. So we're going from $802 to $1,200. So that would be approximately a 30% increase. However, it's just now including, it's not a significant increase as far as the baseline. It's an increase because the money that she hasn't been paying for the daycare expenses is now included in that. So I don't think that it would impact the same way as if there was a substantial increase or decrease in monthly income.
Okay.
So if the 28th works for everyone, we'll set it for presentation on 11/28 at 1 p.m.
Great.
All right, thank you.
6 months later. After the last hearing in November 2023, this case was quiet for 6 months while I assumed the attorneys were negotiating towards a final settlement. Then in May 2024, the case is set for trial during the first week of October. 4 more months later.
Gibson and Gibson, 21-3-38308.
I'm honored ready, Your Honor.
Good afternoon. So I did have a chance to review the filings on this case as well. Did everybody receive the response and everything? Okay. So go ahead.
Thank you, Your Honor. For the record, Megan Gilmore on behalf of the respondent and moving party, namely Jill Gibson. While this case may have been pending for some time, I think it's important to note the fact that at the beginning of the case and roughly for half of the case, my client was the primary parent pursuant to the court's orders until the order changed December of 2022. As detailed in length by my client has made weekly, if not daily, efforts to comply with the court's order, progress this case forward, and have contact with her children. I can personally attest to the amount of work that both of us have done to comply with the orders and get this case going over the last 12 months. At this point, however, the case is simply not ready for trial. The children and my client are still engaging in reunification therapy. We are now 30 days from trial, and we do not have a recommendation from Ms. Dirks regarding ongoing visitation. We delayed bringing this motion in hopes that we could have that. However, at this point, we don't, and I simply think that it's going to be vital for a trial court to make a parenting plan decision on a final basis. Regarding the psych eval, we received an addendum last week as attached within petitioner's responsive materials. That was only received on August 27th. My client didn't have notice that this was going to even occur and didn't have the ability to respond. We have subsequently received communications from Dr. Dimming indicating that she would be needs to do a supplemental report, and she has quoted costs for that. In other words, the psych eval is simply ongoing, and my client has the right to respond, and it's simply not the we're not to the point where the court will have adequate information regarding this expert. The court specifically ordered Ms. Gravina to take or provide an updated report in May of 23. We've received zero communication despite my client and myself's efforts since the fall of 2023. My office personally mailed the check for $500 to the guardian ad litem. Those funds were returned to my office. My office subsequently made multiple attempts to have her pick that up, and she failed to do so. At this point, the last report before the court was in February of 23, which recommended my client to have 50-50 visitation. The statement of concern that was filed subsequently thereafter in June of 23 recommended no visits until a CJAC interview was completed, which has now been completed 12 months ago. We requested discovery over 12 months ago that we just received on August 15th. It's also important to note that the prior trial dates, both of them, were struck by agreement of the parties based on petitioner's request for 90-day extension. So simply my client's request to set over trial to have the pertinent information in this case isn't her attempt to delay whatsoever. Simply, we just don't have the information that we need before the court. And again, it's in the best interest of the children to have a relationship with their mother. And the court isn't going to be able to do a parenting plan that's in the best interest absent this information. Just quickly addressing some of the allegations contained within the responsive materials. The children were not school age when the recommendation regarding reunification counseling was made. My client wasn't aware of any sort of vacation, so we're not trying to manipulate or cause hardship for petitioner in this case. I simply brought this because we waited and waited and waited for the reunification counselor to provide a recommendation, and I wanted to get it before the court before the year and 904 deadline to ensure that both parties don't pay additional costs unnecessarily so in preparation for trial. My client does not deny the abuse, and the evidence will show once it's complete that the children and my client are working on this incident that occurred previously. So again, the court does not have enough information to move forward today. My client brings this motion in good faith. She simply just wants to be able to progress forward in a way that's in the best interest of the children. We don't have that information at this point.
Ms. Baldwin?
Thank you. For the record, I represent the petitioner Cameron Gibson in this matter. We're asking the court to allow our trial to go forward. Just for explanation, we didn't receive the order shortening time until Friday. So our materials certainly came in at the last minute, but with that understanding. And time was shortened on this matter, I think, with undue haste, given the fact that there's no sort of perilous emergency that's happening in this case. This is a case that's been pending for over 3 years at this point, and counsel has been involved for more than a year, since July of 2023. We have currently sitting an October 7th trial date. We're still more than 30 days away. No one has set any depositions for any experts in this matter. So it's not as if there's some barrier to doing so. There is still plenty of time if counsel feels that that's necessary in order to prepare for trial. In this case, we have a number of experts who have provided reports. None of them are a surprise. It's not as if we are adding a new expert at the last moment. These are all experts that have been on board. Everyone's been aware of them, and they've been existing for 8 months, 12 months or more. So these are people that everyone is fully cognizant of, fully aware of, aware that they exist and the expectations. And so the idea that we're going to strike a trial date that is 3 years in the making, 30 days out, just doesn't make any sense. They complain that my client somehow delayed the process because in October of 2023, it took him 7 days
to sign an ROI because he wanted to chat with Ms. Rosen to make sure he understood what he was signing. Obviously, that didn't delay anything, and no one says that it did. So again, it doesn't make any sense. Their statements here are essentially, well, I want to be able to rehash the psych evaluation. That's what happens at trial. That's what trial is for. That's what cross-examination is for. Similarly, I think it's really important that we just note that my client has a right to finality. 3 years and tens of thousands of dollars later, my client has a right to be done and to know that this case is over. The children of this case have a right to be done and have permanence in whatever their plan is going to be. A new guardian ad litem, which is requested, doesn't add anything to this case but delay and cost. At this point, we have experts in the file. We have a psych report. We have counselors. We have reunification experts. What is a guardian ad litem going to do for the court? A guardian ad litem is then just going to weigh credibility. That's the court's job. It is not the guardian ad litem's job. So the guardian ad litem would then add nothing in a case like this. Counsel's statement that the children weren't school-aged, they were. The oldest child was school-aged, and now both children are school-aged. That's why reunification is happening where the children are located. Mother just doesn't like that that's what's happening because she's located here and they're located in the Spanaway area. So again, my client has a right to finality. Anytime we move a trial date and we push it off, it's going to inherently increase costs. And this is true. This is currently setting as a first set. We're in that first week of October. It will be increased fees for my client, which is substantial in this case. There's already been a significant expenditure of fees. It's absolutely prejudicial to just continue to push it out. And honestly, I think it's more, hey, I don't have the evidence I want yet. I want to wait until I can try to develop a little bit more evidence so that my case is better. But that's not a reason to delay trial. You have the evidence you have. There are, I'm sure, all kinds of cases that would like to push out and hope things get better, but that's not where we are now. And everybody has sort of dealt their hand that they're dealt at this point, and we need to go to trial and have a decision. So I'm asking the court to deny the motion, and in this case, award fees. I'd ask for 2 hours of my time.
Ms. Gilmore?
This isn't a case where we're trying to manipulate or delay the situation to create a different reality. It's simply a case where we just don't have the evidence at no fault of my client. And the records show that my client repeatedly has attempted to comply with the orders for the last 12 months. We don't have a completed psych eval based on the recent email from Dr. Deming. We do not have a recommendation for visitation from the reunification counselor. We do not have a GAL report despite the court ordering one in May of 23. So all we have before the court is things that are ongoing. I brought this motion again to reduce costs in hopes of avoiding trial preparation prior to the 30 days. So we do ask the court to strike the trial, to reappoint a guardian ad litem, and we'll set a new date once we have that information.
All right. So I tried to make heads or tails about this case, and it looks like there was an order entered in September by Judge Fassett, and I don't know where that came from. This is the one that talks about it's a counseling order and some things.
Mm-hmm. I believe it's in response to their motion for an immediate restraining order.
I think that's, well, it depends on the timing. So by the fall, the court ordered the.
Well, let me say what I'm saying is I don't know why we're at where we're at in the case. I don't know where that order comes from. Mm-hmm. So my thought is Judge Fassett, at least when she ordered that order, would know what she was looking for. My thought is to put this on at 8:45 on Friday for her to determine whether or not she thinks there should be, the trial should go forward in the current status that it's in or not.
Oh, that's fine.
I just don't know enough about the case. It looks like there's been a lot of things going on in this case. And I spent about an hour and a half trying to read back through and figure out how we got where we're at today. And it wasn't real clear to me that how we got here. So.
And I think Judge Fassett, I don't know that anything has come before anybody else really. after.
Well,
we
Judge
get
Scudder
past.
ordered some stuff, but I think that was mainly related to property and maintenance, but
Yes,
the order that I'm looking at is the one that's dated September 8th. It's clerk's paper
23.
257.
Yeah, that's fine. 8:45
So I'm gonna put it on 8:45
this week though.
on
correct?
the 6th.
That works for me.
And then she can take a look at it and see if she thinks it's ready to go or not.
Very good.
Do we need to give bench copies to her, or is she just going to?
It'd probably be useful if you have that available.
Okay.
I don't know that I do have a bench copy that I could, from Miss Baldwin, I could pass on. I don't know that I had one from your office.
I'll do the same.
We'll make sure we send it electronically as well.
Okay. So at this point, I'm not making a ruling on the motion. It's still pending.
Very good.
Then we have the matter of Gibson and Gibson 2130038308.
Good morning, Your Honor.
Good morning, Miss Gilmore. Good morning, Miss Baldwin. Excuse me. All right, what are we doing here?
Why are we here? Judge Basher kicked it to your docket because he thought you were better equipped to rule on my motion to strike because you were the judicial officer in the fall of last year that ruled on reunification counseling. I think that we both emailed our materials to you. I can make brief argument if you like. The long and short of it is my client has worked diligently to comply with the court's orders, and we're simply not where we need to be for trial. Reunification counseling just recently started. We don't have a visitation proposal from the reunification counselor. The psyche eval is still being collateralized, so that's not finalized. We received an addendum last week that needs to be collateralized by my client, so that's not finalized. The court appointed or reappointed the guardian ad litem to provide a report. She's frankly, Ms. Gravina has fallen off the face of the earth. I have had no communications with her despite our efforts since the fall. She changed her address, and so when we attempted to pay her for her services for said report, the check was returned to us. And then my office made multiple attempts to contact her to make payment made. So we don't have a GAL report. The last GAL report was from February of 23 that recommended 50-50 custody or visitation between the parties. So we need a recommendation for visitation from the reunification counselor. We need a finalized psyche eval. We need a updated GAL report pursuant to the court's orders. I do understand counsel's argument regarding finality. However, these children also deserve a final parenting plan that's in their best interest. And a relationship, frankly, with their mother. Father had no problem with striking prior trial dates out that were at his advantage because we just received an updated GL report in February of 23. So I do think that we're premature here and we just simply don't have the information. I frankly have never worked on a case so diligently and my client working so diligently with no movement. I don't know if it's provider unavailability because of COVID or whatever it may be, but I can affirmatively say it's not at the fault of my client. And I think that's detailed in the emails.
Okay, and so the last name, and maybe I'm wrong, I see an updated statement of concerns from the GAL in June of 2023. Is that the last we've basically received anything from Ms. Gravina?
Yes. Yeah.
Okay, I just wanted to make sure. All right, thank you, Ms. Gilmore. Ms. Baldwin, good morning.
Good morning. So in this case, we're directly opposed to a continuance. So we're setting, we have a first set trial set for next month for October. At this point, this case has been pending for 3 years. Ms. Gilmore has been on the case for more than a year. Children have lived with my client exclusively since 2022. At that point, Mrs. had supervised visits. The children then made further disclosures, unfortunately, of sexual abuse. And then that resulted in the position that we're in now where mother's visits terminated for a period and now we're working through reunification. Children have had specialized counseling. They continue to be in that counseling. So when you look at all of those conditions have been present for an extended period of time. These are not new things. These are not new revelations. These are all things that have been existent in the case for more than a year at this point in time. The psyche eval is finished. That's why we filed it. Ms. Gilmore's client doesn't like what it says. She doesn't like the addendum that essentially cleared up a couple of the facts where the psych eval said, well, if these conditions were true, then this would be my concern. And we said, well, actually, this was the condition, essentially the ages of the children at the disclosures. That was the addendum. To get anything else requires them to re-engage that professional and pay her. And I haven't seen any of that happen. So we do have a final psych eval at this point. My client has not delayed this process at all. They sort of try to hoist that on him because of essentially a 1 week delay in signing an ROI back like more than about a year ago. That doesn't make any sense. There was one continuance when the case, I think it was actually before the case was set for trial back in 2023. And this case was previously set for trial in early 2023. So this, again, not as if this is our first setting. There have been no moves to depose anybody. I haven't seen any subpoenas to any experts or any of the involved professionals from Ms. Gilmore's office. So again, sort of this idea of, well, I don't have what I want. There are ways to obtain those materials. I don't see them engaging their own experts to obtain the things that they need or want or to make something different. It would be wildly prejudicial to my client to continue at this point. We are getting ready for trial. My year 904 is essentially complete and is going out today. Anytime you delay a case, it's going to result in higher costs. That is just absolutely the case. And so in this case, when I don't see any efforts to hire their own experts, no efforts to obtain records, to depose anybody, to subpoena anybody, and asking for a delay does not make sense. My client in this case has spent close to $90,000 to get us to this point to get finality. So just kicking the can down the road is frankly just a terrible result. There's also a request for a new guardian ad litem. Again, this is a delay with no benefit. What would their purpose be in the case like this? To summarize expert reports for the court, who's frankly more equipped to read them than the GALs are. So I think that that's a cost with zero benefit to these parties. It's just, hey, can I get one more bite of the apple for some biased person to make a recommendation in my favor? We have a expert psychological evaluation. We have multiple counselors of these children who are experts, and we have a reunification expert who I believe is a PhD level provider. So all of these individuals are far more capable and equipped than a guardian ad litem, and the court is more capable than, frankly, a guardian ad litem after receiving those expert reports and information to then make a final decision. So again, my client just wants finality. No case is perfect when you take it to trial. That's just how it is. But it can't be that you get a delay because you don't have the evidence you want. Sometimes you have the evidence that you have, and you just have to go forward with what you have. And that's where we are. 3 years is long enough. Everyone is entitled to find out.
That's a few questions. So the psych eval looks like that returned on June 12th, 2024, but then there was an addendum or an update that was filed the 27th, or not filed, but submitted to the parties on the 27th of August. Is that approximately fair as far as timeline?
I think that is fair.
And I think it's important to note that my client wasn't provided any notice that she intended to do the addendum. So we were frankly shocked that we received that. And so I've been in communication with Dr. Dimming, and she plans on further communicating with my client without additional costs. So this was blindsiding to us.
I guess that's not in any declaration though, and I haven't seen anything about that.
Well, as an officer of the court, I can tell you that I've communicated with Dr. Dimming, and she's going to be communicating with my client about the addendum and providing a response.
All right, I'm trying to get a time frame here. So the most recent information from Northwest Family Psychology was received August 27th, approximately.
Yes.
We have a GAL report that's, I guess the most recent update from that would be June of 2023.
Correct.
We have the reunification process started in October of 2023. Is that fair?
I think it started more at the beginning of this calendar year. So to get everyone involved and engaged. It took a little bit of time. So I think that they actually, I want to say they started in January, but
Yeah.
it was just with the parents. And now now it is the parents and children together.
Okay, so I do see January 14th, 2024. There's been an intake with Miss Gibson, an intake with Mr. Gibson, a review of paperwork, a consultation, referral for sessions for Miss Gibson, and a review of a report from Allison Long.
That all sounds correct.
And because the psych eval could not be completed without Ms. Gravina's input, there was delay. So I believe the reunification with the children and my client didn't actually occur until June of so like in the last couple months. The first session with the children and my client have been in the last couple months.
But I don't think that had to do with the psych eval. I think that's just based on what the reunification counselor believed was appropriate.
All right. Most family law cases that go to trial, you're not going to have a reunification counselor specialist. You're not going to have a psychologist available to testify. And those are just the two folks that were included in Ms. Baldwin's response here. A GAL, whether Ms. Gravina can testify at trial, obviously is up to the parties, if she can be found, I guess. But at this point, I'm going to deny the request to appoint a new GAL. I don't think there's any need for that when we have the level of expertise of folks that have been working with these parties and these kids for at least the last 9 months, if we're talking about reunification. I know that Miss Anderson and Dr. Rosen, I remember seeing things that they were, at least last fall, were working with the kids. So I think a GAL at this point is really isn't going to add much for anybody. So I'm going to deny the request for a GAL. As for the motion to strike trial, So I understand that Ms. Gibson's position, and it does appear to the court that there has been, to be very frank, a drastic change in her involvement in this case. I'm happy to see that she's been productive in the last 9-12 months. But a lot of the delays that are listed are really of not anybody's fault at this point. Looking at, let's see. Ms. Gibson outlines kind of a time frame for everything playing out, and her concerns with needing more time. It's going to be a time crunch, but I don't see that there's a need to strike the trial at this time. So I'm going to deny the request to strike the trial. This is a 3-year-old case. There's been so much happening in this case, and frankly, there was a large portion of time that was lost because of Ms. Gibson herself. So at this point, we have evaluations, we have reunification set up. There's going to be at least another month worth of information that can be gathered from the parties, from those folks prior to trial. And I think we do need to move forward. So I'm going to deny the request.
Understood. Can Your Honor just enter a bench order, or?
That works for me.
Unless somebody else wants to do something, I'm happy to just do a bench order saying denying the GAL and denying the motion to strike trial.
That's fine. Thank you.
All right. Thank you. Good luck. All right. We can go off the record.
They had a trial readiness hearing at the beginning of October, a week before their trial was scheduled, and according to Odyssey, instead of proceeding to trial, they decided to go with binding arbitration. I'm not that surprised that they agreed to mediation. Both of the lawyers on this case are very professional, and they can usually avoid a trial and save their clients both the hassle and expense. But I also think that Mom realized that Dad was likely to have the upper hand if they went to trial, and Dad was more likely to get what he wanted due to her deceptions on the court. By being willing to negotiate with each other, they're more likely to have some control over their parenting plan and division of assets, rather than leaving it all up to the judge to decide and just hope she does what both of you want. I hope Mom has learned a lesson here about making her children's personal safety a lot more of a priority if she ever wants to have any meaningful custody of her children. They were able to come to a final agreement in mediation, and that was the last time this case was in court. I wish all of them a happy life. Thank you for watching.